Good morning, all. This application hearing is in the matter of CFI 079-2023 before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by White and Case. Lead counsel is Mr. Tom Montague Smith, KC. The defendants are represented by Habib Al-Mullah and partners. Lead counsel is Mr. Stephen Docherty. Thank you, Your Honor.
Thank you. Yes, I think probably we should start with you, Mr. Montague Smith.
Yes, thank you.
Unless you, counsel, got a different view.
We haven't discussed it, but I'm very happy to take the lead.
Yes, obviously, just going on the basis that your application 9, I think, was first in time, so we just go through them.
Thank you. Yes. All right, let's do it like that. So we say that actually the most important part of what's before you today is really the adjournment application, in the sense that we say it's critical from our perspective that you keep those dates in the diary. If you don't, if you push the trial off, and I'll come on to the reasons for the adjournment, but if the consequences will be quite significant. This is a position that's been kept in the diary for some time, and you know we've tailored our preparation to that. These applications themselves have been incredibly disruptive. There's days taken away from preparation for a trial that starts in just over a week. And the reality is, if it goes out of the diary, a listing for this period is unlikely to get back into the diary for some time. And certainly, as far as my diary is concerned, and there's a little bit of evidence about this, it is probably unlikely that I would be able to be involved. So it's going to dictate to the claimants their choice of counsel, because my diary can't accommodate a 2-week trial or 7-day trial, whichever it is to be, before 2027. So from our perspective, a lot of the cost has already been incurred in relation to that, including brief fees and all the rest. And so, you know, there will be a huge amount of wastage and preparation that's been wasted. And the way we would characterize this, both the opposition to my application and also the applications that have been made by the defendants, is really, and I'll develop this, but we would characterize this as a last-ditch attempt to derail a trial which they have come to realize is going to be extremely difficult for them. And we say it's quite surprising that they make that application at the last minute, but also that they seek to blame it on the claimants. We say really what this is a wrecking application by the defendants, and the court should be quite sceptical of it when one gets to that stage. Now, I preface my application with these comments about my learned friend's applications because, in part, he now says that my amendment application is going to lead to an adjournment and delay as well. And as you'll have seen from the evidence, there's nothing in the evidence about that. That's a new assertion made in his skeleton argument for today. And so there's no evidence to support that. And in fact, there's nothing in that. But what he does is he tries to sort of layer that on as a make weight to his own application, to try to do everything he can to get rid of this trial for the time being. And I mean, just again, as by way of preface to all of this, the reality of this claim is that we say it's quite a simple claim ultimately, and it started as a very simple claim, which is that just taking a step back, you've got a situation where Mr. Shehata, this the first defendant, caused Health Insights Dubai, the second defendant, to enter into 2 transactions with a third party that he owned and controlled. He didn't provide written notice in accordance with the regulations, and none of that is in dispute. So he says, well, there's no conflict of interest because it was in the interests of Health Insights Dubai, but that's not the test for conflict of interest. So it's quite straightforward, we say. And the only real response to it all sort of has been, well, what was transferred by these arrangements, or what was dealt with by these arrangements, never belongs to Health Insights Dubai in the first place. And so he sort of says it doesn't really matter because there's nothing there's no content to those those contracts, that's effectively the case. And so the cases doesn't really matter. That's his case, and yet it's blown up into this 7-day trial and now 10-day trial. He doesn't say those agreements.
Why did you say 10? Why did you say 10 days, Mr. Montague Smith? I wasn't aware of that.
That's what he now says this trial needs. Yeah,
I might have missed that. Is that in the skeleton or something?
Yeah, he's provided a timetable in his skeleton arguments. So,
has he? I didn't see that.
Yeah, let me just find it. It's on page 36. I think, in fairness, day 10 is slippage.
So, oh, I see. Yes, I didn't go that far.
So I mean, fundamentally, the claim that we've been trying to get on, and we said was very simple, it could be dealt with by way of Part 8 claim, this main aspect, because of course quantum's gone off. We always accepted that quantum would require evidence, but that's not what we're dealing with today. Really, fundamentally, the issue is, should you set aside a claim, a couple of contracts which are entered into, we say undoubtedly in conflict of interest. But they say, well, they didn't really achieve very much. But actually, the evidence on that, when we get to it, doesn't say these are sham contracts, doesn't say they're ineffective contracts, and the consequences of those contracts on everybody will be a matter for the second phase. So really, we say it's as simple as that, and yet it's blown up into this large scale litigation. And so he's introduced, for example, this allegation that he personally wrote the code individually. One individual wrote 2 software packages which are worth these millions of dollars and have 50-odd sub modules. And what has happened is that we've then provided the evidence from some of the people who actually wrote that code and supporting documents for that. And of course, that rather blows up his strategy, which was to tell you, well, at trial, well, I'm the only person who was actually directly involved in it, so I'm the only one you can take any evidence from. That was his strategy. So we produced some evidence from the individuals who were actually involved in the development, and his response is, oh, well, you can't do that. You can't actually challenge my evidence. But of course we can, and we'll come on to it, because we say what we've done is within the terms of the order that was made. And just before I get to my application, I mean, just to place this in context, I mean, we've also got this counterclaim, and that's part of what's caused this application and all of this flurry at the last minute. And we say the counterclaim is completely incoherent, because the way it's put is that because the claimants were directors of both Health Insights Dubai, and also they were directors or employees of Al-Khalij, which was the supplier, that they should have used their powers in relation to Al-Khalij to effectively give business to Health Insights Dubai, and Al-Khalij shouldn't be allowed to, for example, have any role in disputing litigation brought by Health Insights Dubai. But of course, the duties owed by those claimants were duties owed to Health Insights only insofar as they were acting as directors of Health Insights, not when they're acting as directors of Al-Khalij. So you're not, when you're a director of 2 companies that are in dispute, you don't have an obligation to both to somehow cause that litigation to be resolved in both of their favors.
No, although there is a long history of the controversy about people who are directors of 2 companies in competition and whether there's any conflict of duty.
Well, there can be a conflict of duty, but only when they're using when those duties bite.
Yeah.
So there's no problem in being a director of 2 companies. The problem comes when you use your powers in respect of one company to favour the other company in which you have an interest. But that's it. It's got to be the use of your powers in respect of that company. So saying, for example, that they were under a duty not to defend litigation brought by Health Insights or to cause Al-Khalij to do that is just incoherent. It's legally incoherent, and then there's this it's put as diversion of revenue, but no case is pleaded as to why they were entitled to that revenue, why that was their revenue. It's put almost as a proprietary claim. And this is used as a platform to try to get documents from third parties like Al-Khalij, this third party that's involved, and it's spun into this great drama justifying what is now a sort of standalone application for what? For a declaration at this stage, 10 days before trial. We have to have this battle. And then we've got this application to bring in 3 new parties, 6 working days before trial. These issues have been out there for weeks and months, and so we say just when you start looking at this, when you get there, we say it's just obvious. It could not be more obvious that this is a wrecking application by the defendants, and we would ask Your Honour to impose a little bit of discipline. And when we get to the adjournment question, we say the court will need a very good reason indeed to adjourn a trial in these circumstances, and should approach that application with deep skepticism, because the justifications which have been advanced, we say, have no basis. But those were my sort of preliminary remarks. But I'll move on then to just deal with my application, which was my amendment application. The proposed amendments are, we say, very modest, and they arise out of documents that were disclosed in the course of these proceedings. But if you go to page 84, you'll see what they are. And essentially, what has happened is that Mr. Shehata has caused various payments, 5 payments, to be made out of Health Insights' bank account to himself between the 5th of September 2022 and 31st of August 2023, when those accounts were closed. And so if you go through these pleadings, and I won't read them out to you because I want to get through this quickly so we can hopefully get back to our trial preparation, is 30 paragraph.
Mr. Montague-Smith,
Yes.
Have you already got evidence in relation to these allegations, or do you need to put on any more evidence? Or
We don't need any more evidence. What we've asked you for is, in the context of this litigation, these allegations have been out there, and the draft has been out there since before the witness statements were filed, and I'll show you that in a moment. Okay. But the allegations are addressed in that witness evidence, and then, of course, in the context of this application for an amendment, those allegations are also addressed in witness evidence there too, so we can rely on that. And in addition, because the only point made in the evidence in the response to this application, in the evidence from the defendants, was that there was no real prospect of success. So just taking it in stages, first, these paragraphs 37 to 40 are not, as we understand it, in dispute. So in other words, it's not in dispute that he did in fact use the money in this way. What is in dispute is his justification for the use of the money, and he has provided evidence in relation to that in response to this application. And again, he's just said, well, you just have to take my word for it. So there's no real issue to be tried here, because I have a good explanation, and here it is. And in response to that, and I'll take you to this briefly.
That's in his 10th witness statement, is it?
I believe it's his 10th. Yes, it is his 10th. Yes, correct. I'll show you that. So let me just slow this down a bit and just tell you what we say briefly. But essentially, you'll see from the pleading that it is put. Firstly, we've said that 37 to 40 is the fact, literally just the facts as to the transfer of the monies, and then we refer to 41 the payments, sorry, the explanation that he had by that point given at 41 and 42, and then we give the legal case at 43, which is avoidance of those transactions pursuant to the particular regulation, and that's the legal hook. So again, we say that he had an interest in the payments because they were made to his account, and then he was conflicted and so forth, and that he didn't declare it. Now he says it wasn't to him, he was just holding it for the company, and he distributed it for the company properly, amongst other things to himself, in respect of salary. And so the resistance, I'll show you this, it's at page 505 of the bundle, is his 10th statement. This is the end of his 10th statement. He deals with it in all the way through this statement, I should say. So his explanation starts all the way up at 497, where he explains the closure of the bank account. He explains the closure payments, and then he goes through them all and says this is what they were all about, and he discloses some documents which he says prove that. The short point that we make in relation to that, and I'll show you this, is we don't accept his explanation of the payments, and we have some good reasons, we say, for not accepting them. And I want to ask him some questions about it at trial. We've got a trial coming up in in 10 days, and it will be a relatively short exercise to do that. So until his skeleton argument, his position, as we see in the witness statement on page 505, paragraph 46, his position was just he resisted the amendments on the basis that there was no merit in the claim. And that was because he said we had to accept his argument, his explanation for the use of the money, and that it was appropriate. And there was no real prospect, indeed, my learned friend says no prospect of disputing that. He now also says in his skeleton arguments it's going to disrupt the trial, and I'll come back to that. So I'm going to deal with each of those 2 points in turn, if I may. So the first point is there a triable issue? We say there plainly is. The test is whether there's a real prospect of success. So what does he say? And I won't take you through it in detail because we'll have to have a trial about this, but 495 paragraph 13, he says, firstly, he says, paragraph 13, I've already dealt with this in my evidence. So you can see trailed there the fact that this isn't really disruptive. He says he's very surprised, in fact, really extraordinary, because he's already explained the use of the payments, and we should have taken his word for it. He says 3 of the payments were salary due to him, and the 2 others were made to him when the bank accounts were being closed down, and he then used them for company purposes. And he produces what he calls a ledger for the 2 accounts into which the money went. And these are documents that he appears to have created himself. So we'll have a look at those and have some questions about them. They're not sort of accounting software or anything like that. They're just schedules. But for example, if you go down to page 500, he then explains what the money that wasn't salary was used for, his own salary. And so he says, for example, I made salary payments to 5 people. If you see that at 27A, and then he talks about insurance invoices, cloud computing, petty cash, and legal invoices. And there's another ledger for the US dollar account. You'll see that at paragraph 29. And he talks about, again, salary payments and further legal invoices. Now, as I say, we've got some questions about these documents and about this explanation, and we say there are reasons to doubt his explanation. And Mr. El-Shafei has put in a 3rd witness statement in response to this statement. You'll find that at 1790, or the relevant part of it.
So what page?
It starts at 1789.
Right.
But if one goes to, again, I'm not going to take you through it all in detail because these are just forensic factual points, but just to show you this. I'm sorry?
I was just noting the page.
Of course. No, I was just explaining I'm not going to argue the full case to you today because it's all about evidence and fact disputed facts. What are the reasons for these payments?
Yeah.
We've got an assertion. It said, well, there's no way to dispute them. Well, let me just show you one or two ways in which we dispute them. At page 1791, for example, paragraph 8, this is Mr. El-Shafai, and he says, well, referring to, for example, the salaries that Mr. Shehata said he was using this money to pay, those do not appear to be HI Dubai employees. They're HI Egypt employees. So we doubt very much that the documents which have been produced are accurate. And there's going to be some difficult questions to answer in relation to that. And another point, if one goes down 2 pages to 1793, paragraph 11, dealing with the US dollar account, and it's pointed out that he's talking about salaries paid, 10 salary slips for himself, dated September 2023, all the way through to May 2024. So it's pointed out that he was dismissed as as the general manager in May 2023, and yet in August 2023 he's using the company's money to pay himself salary all the way through into May 2024. So we say he's just taking money he's not entitled to. It's not salary. You may call it salary, but if you're no longer in the role, you're not entitled to it. And not only that, if you're no longer actually the general manager of the company, you're not entitled to do what he did. You're not entitled to unilaterally just to use the money. So there are, we say, quite obviously questions to answer. There's some points about the lawyers' fees as well, and that's explained at paragraph 12 and onwards. And in short, he says, well, 450,000 US dollars was used to pay Tawfiq, which is a law firm in Egypt, for claims by Health Insights Dubai against 2 entities, Al-Khalij and HI Egypt. And then so the evidence here, one goes to paragraph 15. Mr. El-Shafai has some observations about this too. He says, as regards Al-Khalij, his understanding is that they were represented by a Saudi firm, not by Tawfiq, this Egyptian firm. And 15.2, the only claim against HI Egypt was only for $400,000 or $405,000, I think it was. And that was ultimately struck out because it wasn't properly pursued. So the evidence that's coming in from Mr. Shehata seems to be that he paid nearly $250,000 to half pursue a $400,000 claim. So there are going to be questions about these sorts of things. Now, there might be perfectly legitimate answers to those questions, and it may be that you're satisfied with his explanations, but you might not be. And we would suggest that you can't really make that decision today, which is what my own friend invites you to do. There's a number of other forensic points, but again, I'm not going to go through them all. But essentially, Mr. Shehata's approach appears to be, well, you should just take his word for it. Don't ask me any questions. With respect, we would say that we're well past that point in this relationship. He made substantial payments to himself. That's not disputed. And then the accounts were shut down. He claims they were for legitimate purposes, and we should be entitled to asking questions about that. And Your Honour will be well aware, on this sort of application, this is not the opportunity for a mini trial, and that's essentially what the defendants are asking for. They make some other points in their skeleton argument. They say, and I'll come on to the disruption point in a moment, but they say, for example, well, it's unclear whether further amendments are proposed. I make clear no further amendments are proposed. We seek the amended pleading that we seek. And I also make the point that none of this is terribly new, and there is no need for extensive further procedural steps. These proposed amendments were sent out for agreement in June. That's at page 424. So on the 26th of June, they were proposed. That was before exchange of witness statements. And they should have just been agreed at that stage. That's what the rules say. The issues have been canvassed in evidence, both from Mr. Shehata and Mr. Al-Shafai. I showed you the passage where Mr. Shehata said, I've already addressed this before, and so you should have taken my word for it. And you can see it as well at page 702, which is his reply evidence in the main proceedings. And he goes through at paragraph 40 and onwards under the heading payments from HI Dubai bank accounts. He deals with it. So what you've got is you've got undisputed facts of payments. It's been dealt with essentially in the evidence. There's been a supplementary round in response to this application. And so in terms of witness evidence, it's very difficult to see what more would be required. And there's no evidence from the defendants saying, well, this is what we would need to do. It just appears in my learned friend's skeleton argument without forewarning. We do seek some limited further documents, and you can see that in our skeleton argument. They're recited at paragraph 12 of our skeleton. It might just be the best, easiest place to see them. Essentially, these are simply documents which will allow us to test the explanations that have been given. Now, it is fair to say that in relation to some of these, Mr. Shehata has produced documents which would respond to some of these categories. It may be he says, well, that's all I've got, in which case he won't have to do any more. But essentially, you'll see what we're looking for. Emails or letters between the first defendant and HSBC relating to the payments, emails and letters between the first defendant and Mashreq Bank. I think it's been said previously that somehow my clients have control over Mashreq Bank because they have control over Health Insights Dubai. That is not the case, because part of the problem that my clients have faced in taking over Health Insights Dubai is that Mr. Shehata has refused to provide any kind of handover, and so credentials and so forth are simply not available. That's addressed in the evidence. We're looking for bank statements for those accounts, statements from the accounts from which the payments were made, supporting documents for the alleged operational expenses, and any correspondence with auditors. And so it may be that he will say, well, I've given you everything I've got, and he can be asked questions about that. It may be that he can pull these documents together very quickly and provide them. We don't know. He hasn't addressed it in his evidence. He hasn't said anything about this. He hasn't said it's going to take me a long time to produce all of this. But in circumstances where he's in control, or he was in control, and we are not, we don't have access to this documentation, we would say that it would be appropriate to order him to make limited further disclosure of documents so the court can have a fair view of really what these payments were made for. It's now suggested in the skeleton that this will be disruptive, and the short answer to that is, well, there's absolutely no evidence to support that, and it's improbable. So there's no evidence as to how long it'll take to produce documents. There's no evidence as to what further investigation or documentation or even explanation or witness statements might be required, and it appears improbable because we've had a fairly full exchange between the parties, and he has produced documents, and one would assume he has produced the documents he would want to produce. As I say, we sent the amendments back in June, and this application has been on foot for almost a month, so there's no. It's very difficult to see how they could be any real disruption in terms of the time, actual court time it's going to take to deal with this. One can't see it taking a huge amount of time. It's going to be putting to him a few documents and asking him some questions about these particular transactions. It's not going to add more than an hour to the trial, even if it's that. So we say we would ask your Honour to permit this amendment. As I say, it's very modest, and also all of the disclosure that we have sought. That really was all I was going to say about the amendment and disclosure application. And I can pause there and we can let my own friend respond and I can reply, or you can ask him to develop his applications, whichever you prefer.
Sorry, I'll ask Mr. Doherty. Mr. Doherty, I'd prefer hear from you on the claimant's proposed amendments, unless there is some different course that you propose.
Yes, that's fine, my perspective.
All right.
You ready for me to go?
Yes.
I take it. Okay. It's interesting that the claimants here are having to take, or having to toe at least, a pretty difficult line between telling Your Honour you have everything you need, there's not really much that's going to be needed to prepare this for trial, whilst at the same time trying to suggest that, well, you can't really form a view on this today because you don't have all of the evidence. We say that's wrong. We also say it's not really principled. This isn't an amendment application made at an early stage where we're still waiting on disclosure, where we're still waiting on witness evidence and so on. This is coming at a point in time where, from the claimant's perspective at least, their case on this, at least as they are suggesting to you, is fully formed. And this is one of those cases. I'm not going to take you to any lengthy recitation of principle, because the principles on this are well established. But I've set them out, paragraph 7 of my skeleton argument, which is page 1414. But this is the EDF and Mann scenario, so point 4 in that list, which is the court doesn't have to take everything a party says in his witness statement at face value and without analysis. And in some cases, it may be clear that there's no real substance in factual assertions which are made, particularly if they're contradicted by contemporaneous documents. So one has to be particularly wary where, on the one hand, you've got a party proposing an amendment based on what we say are bare allegations and speculation, and on the other hand, you've got a party who has responded to those, who's provided contemporaneous documents which frankly make the case as pleaded entirely unsustainable. And I'll work through the detail of that, but this is one of those cases where one shouldn't just trundle into trial in this macabre hope that something's going to suddenly turn up in cross-examination that isn't frankly obvious from the face of the documents. This is just an amendment application which was mooted at the end of June. There was protracted correspondence in July in which it was pointed out to the claimants why this amendment didn't have prospects of success and why all of these payments were properly explained. And evidence was given on that, and they persisted in the application anyway. And what we have, which I'll come to, from the second claimant's third witness statement, is some last-ditch attempt to throw out as many allegations as possible, none of which have any bearing on the amended case as pleaded. And I'll work through that, and it's perhaps not surprising that my learned friend dealt with that in pretty scant detail. But that doesn't advance their position on the amendment application. And I think really to make the point good, one has to start with what is actually being pleaded by way of amendment and look at the detail of that, because ultimately the question for Your Honour is, do those amendments have prospects of succeeding at trial? And so they begin at page 84 of the bundle.
'84.
Yes. It's the red text starting at paragraph 37.
Yes, I have it.
And the substance of what is alleged really begins at paragraph 40, which is between the 5th of September 2022 and the 8th of September 23, the first defendant exercised control over the second defendant. And in doing so, and this is by reference to the payments, it's point 1 and 2, the payments were made to the first defendant on his instructions, but also that the USD and the AED account in HSBC were closed upon the instructions of the first defendant. Paragraph 41 then asserts that there are two further payments purported to constitute salary payments. But it says, to the best of the claimant's knowledge and belief, the first defendant was only entitled to a salary from the second defendant of £55,000 per month. The two payments significantly exceed that figure. So just pausing there, there's an acknowledgement that there is contractual salary entitlement that the first defendant did have entitlement to receive. And then paragraph 42 really is the allegation of what's happened to that. So it says that the payments constituted transfers of balances and the accounts being closed. The claimants are not aware of any legitimate reason why such balances would have been transferred to the first defendant. And in effect, what you can see is what's being alleged is the first defendant controls the HSBC bank account. He instructs HSBC to transfer the money out and to shut down the account, that there's no legitimate reason that those funds have been transferred to him. And the allegation is that he has misappropriated those amounts. So that's the case as it's pleaded. And when you actually go to the substance, it's very easy to chip away why that pleaded case has no prospects. So first, the allegation that the HSBC account was closed and payments were made to the first defendant on his instructions. If your Honour turns up page 498, this is an extract from the 10th witness statement of Mr. Shehata. But what's being referred to at the top of the page in the quotations is a document which it's in the trial bundle. It's not on the hearing bundle today, so I'm taking you to the extracted text. But it's a 22nd of June 2023 letter that HSBC sends to the first defendant saying, we're writing to formally advise you of the result of our review of our banking relationship. Unfortunately, we'll no longer be able to provide banking services to you, and we'll need to close your accounts that you've opened with us. What happens next to assist with the transition, etc., etc. So that assertion that the bank account is closed and the money is transferred upon the instruction of the first defendant, the inference being that he's misappropriating the money to his own account for his own use, that's not sustainable. The reason the bank account is being closed is not on the instructions of the first defendant, it's because HSBC has decided to close the bank account. The second point, and this really deals with what's asserted at paragraph 42, which is, sorry, Your Honour is...
Yes, I'm sorry. My finger was
disconnected. So second, when it comes to the payments and this suggestion that we don't know of any legitimate use of those amounts of money, if we go to page 512, Your Honour should hopefully find the bank account statements. In, I suppose, a simple answer, which I'll come to the greater level of detail on, was there a legitimate reason for the HSBC transfer out, which is the transaction that's sought to be set aside and accounted for, whether there was a legitimate reason for Mr. Shehata to have done that. And we say, yes, there is. And the reason is exactly what's described in the description for the payments. It's a temporary transfer because of the account closure. That is a legitimate reason to make a payment out of an account which is imminently about to be closed by HSBC. The money needed to be transferred. There was no other option. And Mr. Shehata has explained, both in his witness statements for trial, but also in the witness statements for this application, and in fact in the correspondence that was exchanged between the parties on this issue, that the reason he couldn't simply open up another bank account in Dubai and transfer the funds there was because there were these criminal complaints made about him in Egypt, subsequently dismissed, which meant that he was under a travel ban. So he couldn't actually go to the UAE, open a bank account and transfer the funds there. So that's the reality of what happened. That's why the transfers were made. And I'll come on to the details of the payments. But whilst we're on the account statements, it's probably worth drawing Your Honour's attention to a few more of the line items in here. So, for example, you can see on the 28th of August, there's a number of payments made of salaries. So that's for Mr. Abdulaziz, for Mohammed Saad, for Divina Mercado. So those are all salary payments made from the HSBC account to the individuals concerned in respect of their entitlements. And what's notable is that the claimants don't seem to take any issue with these payments. So they have access to these statements. That's why the pleadings were amended. They haven't said, you shouldn't have been paying Mr. Abdulaziz, you shouldn't have been paying Mr. Saad, you shouldn't have been paying Ms. Mercado's salary from the HSBC bank account. And the inference that arises from that is clearly they don't dispute that those individuals were entitled to be paid salaries. And this is just a snapshot. The parties both have copies of the HSBC bank statements going back in time. When you go through the history of this, you can see those monthly salaries being paid to those individuals. And again, no question by the claimants in these proceedings which seek to challenge the legitimacy of those payments. It only really seems to be challenged once the HSBC account is closed and the payments are having to be made from a different source. And similarly, on the 26th of August, over the page, this is in the middle of the set of transactions, but you'll see a $15,000 transaction for Mr. Shehata. And again, I pause there because in my learned friend submissions earlier, it seemed to be suggested, we say, at least as a new allegation in these proceedings, that this is somehow problematic, that Mr. Shehata is making payments to himself. But the way that this amendment in the pleadings is put, and you can see it's Miss Roshan's witness statement at paragraph 22, where she quotes extracts from the trial witness statements of the claimants. That's at page 93 of the bundle. But what's said, or the way that the claimants have put their position in this, is that we are aware that Nasser was entitled to receive a salary from HI Dubai in the sum of 55,000 dirhams a month. So that's $15,000. But he was not entitled to receive such substantial salary payments as appear to have been made to him on the 5th of September and the 2022 and the 8th of March 23. So there appears to be some general acceptance that, as a matter of principle, he's entitled to $15,000 or 55,000 dirhams a month salary. The thing that's objected to in the way that the case is put in the amended pleadings is that it's these block transfers that have something that's wrong about them, or something that they're inviting the court to look into. So there's no issue, certainly no pleaded issue in proceedings that suggests that Mr. Shehata isn't entitled to $15,000 a month by way of salary. And Your Honour's probably moved away from it, but you can also see from even that short extract on the bank account statements that there are various payments that go to third parties. So it's back at 512, but there's a firm called Evolve. And one of the payments made before the bank account is closed is to pay accrued expenses for a company called Evolve LLC, who are a cloud computing provider. So on the question of legitimacy, the claimants don't seem to take any issue with the legitimacy of these payments. in the past when they've been made out of the HSBC account. So it's somewhat unclear why, following the forced closure of the account, payments that they seem to accept were legitimate payments all of a sudden come to take an air of illegitimacy. And really, that's the crux of why we say there's nothing in this amended pleading. There is nothing but speculation to suggest that these payments are anything other than legitimate. And that's why the amendments don't have prospects of success. And we can see a detailed record having been kept of all of the payments that were made. So these are the ledgers, starting at page 514. And one can see that the categories of expenses that are coming out of the accounts or that are coming out of the funds are precisely the same expenses that were coming out of the HSBC bank accounts prior to its closure. So it's salary for Abdulaziz, salary for Mohammed Saad, salary for Davina. So those are the three individuals we saw in the HSBC statements. And we can see that there are other individuals there too. We can see on the 11th of October, and there are other examples of this, the payments being made to Evolve, Third Life, MetLife Insurance, that's for health insurance provision for employees. You've got disbursements for petty cash. You have things like professional fees for auditors and for lawyers. In other words, you have the business expenses for a company that are being paid in the normal way. They've just been paid from a different source. And it's not that one is simply taking Mr. Shehata's word for this, because starting at page 521, Your Honour will see that there's substantiation for all of these payments. So you can see the tax invoice there at 521 for Evolve. At 522, there's a run of documents which show slips for salary payments for those concerned individuals. And there are a number of those which have been provided. For example, I'm not going to take you through all of these. 529. You have the evidence supporting the MetLife payments. At 541, there's documentation in relation to a tenancy contract which matches up to a line item in the ledgers dealing with, it's effectively employee expenses for accommodation. And the tenancy contract and so on has been included for that. So all of those payments aren't just Mr. Shehata's assertion that a payment was made. We've got all of the underlying evidence which shows that this was an expense that was accrued by the company and therefore was paid on that basis. And this run of documents goes from page 521 of Your Honour's bundle to page 614. And one could obviously go through the process for taking you to each one of them and matching them up. But ultimately what happens is you have the ledgers, they've got an amount that's transferred in at the start. So that's the amount that comes across from the HSBC bank account. You have expenditure, so that's money going out from the business. And then it's 615 of the bundle is where you get to the end of that process. Which is a statement from the Mashrek bank account. This is opened in May 2024 because it's the first time that Mr. Shehata is actually able to open a bank account. The travel bans have lapsed, the Egyptian criminal complaints have been dismissed, and so he's able to actually formalize how the company's money is held. And what he does is he transfers the balance. So that's what came from the HSBC account, less expenses, and he transfers it into a Matrec bank account, which is in the name of Health Insights FZ LLC. So what Your Honour has is, we say, a clear documentary record in the face of the allegation, which is bare assertion. We add that when it comes to the incurring of these expenses, all I've taken Your Honour to this morning is the snapshot of the HSBC accounts to show you what the position was beforehand. But even there, even from those 2 pages, you can see that prior to September 2023, the payments were made in terms of salary from that account. Payments were made to contractors like Evolve from that account. No issue is taken as to the legitimacy of those payments. And if that's the case, looking backward, there's no good reason to suggest that the payments are legitimate simply because the funds have been necessarily withdrawn from the HSBC account. So when it comes certainly to the amounts referred to in the ledgers, there's just no prospects of anything turning up at trial, which is going to put the claimants in any better a position than they are before Your Honour now. That's certainly their position. They're not anticipating that there's going to be substantial further evidence on this. That's why they're asking you to allow the amendment. So either it's one way or the other. Either there needs to be more disclosure and more evidence, which would feed into the adjournment, or Your Honour is in a position today to decide that there's nothing in this allegation, and that on that basis the amendment shouldn't be permitted. Now that deals with one part of it. The other is Mr. Shehata's salary. So that's the 2 transfers in September 2022 and March 23. I've already shown Your Honour the 15,000 monthly salary, and I've shown you the fact that it seems to be accepted, both in Ms. Roshan's statement, but also in the claimant's witness evidence for trial, that Mr. Shehata was entitled to that $15,000 a month salary. And that's an entitlement that properly accrued to him. The answer to the 2 payments which are at issue is simply that they are block transfers of salary payments. So it's 2 payments. One is for, I think it's $180,000 in September 2022, and then $120,000 in March 2023. And there's a fairly simple explanation for that. And again, this ought to be clear to both parties because both parties have copies of the HSBC bank statements. But when you look through those, from January 2021 through to August 2022, as normal, most individuals are paid their monthly salary entitlements. Mr. Shehata isn't. So he doesn't draw any salary from January 2021 through to August 2022. That's 20 months of salary at 15,000 a month, which is 300,000, which is the total of the 2 payments that come out in September 22 and in March 23. So again, on this question of legitimacy, there's no real question of legitimacy. It's accepted that he's entitled to $15,000 a month. These payments reflect that entitlement. It's just that although the salary was accruing to Mr. Shehata, he wasn't paying it on a monthly basis. They came out on a deferred basis instead. And you can see that none of this is being dealt with in the dark, as it were. If you go to the bank statements for these transactions, so page 308, first of all, you can see it's the first transaction recorded on this page, the 120,000 to Mr. Shehata, and it's described as salary. So that's the 120,000, and then the next is at page 325. Again, it's the first transaction on this page. 8th of March managerial remuneration salary. So the payments are exactly what they say they are. They're salary payments. It's 20 months from January 21 to August 22 at 15,000 a month. The fact that he was being paid like that on a deferred basis was also not something that was some kind of secret, because the way that the payments were made is recorded in the company's audited financials. So if one goes first of all to page 636.
Sorry, what page?
636. If Your Honour has that, you should hopefully see under Note 15, Administrative and General Expenses. Sorry, Your Honour, you're mute.
Yes, I don't have it because I'm still waiting, but describe it and it'll come up.
Certainly. So it's the audited financial statements for the year ended the 31st of December 2021. It's under the note dealing with administrative and general expenses. In the second line down, there's an entry for managerial remuneration. And as you get in accounts, you've got what's occurred in that year, but also it'll show you by comparison what's happened in the previous year. And so for the year ending the 31st of December 2020, under managerial remuneration, you've got a line item for 657,540 dirhams. So that's the 660 odd thousand dirhams that you would get to if you've got 12 months of Mr. Shehata's salary of 55,000 dirhams a month. So that's recorded in the accounts for 2020. When you get to 2021, there's nothing. So the financial statements show that for the entirety of the period from 1st of January through to the 31st of December 2021, that remuneration hasn't been paid. So he doesn't draw it. That's exactly what Mr. Shehata said in his evidence. It wasn't paid to him during that period. And if one then goes from there to page 657, which is the accounts for the following year, so that's the year ending the 31st of December 2022, there is a note dealing with creditors, accruals, and other payables. And noting that by this point, so by the 31st of December 2022, we already had one of the partial payments of the accrued salary. So that's a payment that was made on the 5th of September 2022 for 120,000. But what's left there is accrued expenses of 768,000 dirham, which we say reflects Mr. Shehata's accrued but unpaid salary entitlements. And again, if there was going to be an argument that these weren't accrued salary entitlements, it'd be quite easy to prove that, because what you would see is these block transfers having been made from the HSBC account. And you would go to the HSBC accounts and say, well, look, he was actually paid 15,000 a month throughout the whole of 2021, so that can't explain it. But that's not what the claimants are saying, because they've got bank statements and they know that that's that they don't show any of those payments being made to Mr. Shehata for his salary. So the short point is that the payments are explained. They are legitimate payments to Mr. Shehata, because it's not in dispute that he was entitled to that salary. And so when you put that together with the evidence in the ledgers, there is simply no basis on which to suggest that any of these payments are illegitimate. They've all been explained. They all relate to expenses which, certainly prior to the closure of the HSBC bank account, the claimants don't take any issue with. So it's very difficult to understand what turns what are previously accepted to have been legitimate expenses into somehow illegitimate expenses just because HSBC decided to close the bank account down. And as I say, there's no prospect of the claimants being in a better position at trial than they are now. And in fact, they've had the opportunity to provide responsive witness evidence on this in the context of the application. And that evidence doesn't mount a proper answer to why Your Honour should allow the amendment. This was dealt with on a fairly light touch basis in my learned friend submissions, but it's worth going to. This is at 1789, which is the third witness statement of the second claimant. And one can just go through the nature of his objections to see, one, that they don't assist this amendment application, but two, all it really adds to the mix is sort of more speculation, more new points, and issues that don't have any bearing on the case that is presently being advanced. So, for example, paragraph 7, what's being suggested is that Mr. Shehata hasn't provided any evidence to prove that the amounts withdrawn from the HSBC account were used for the purposes described. I have to say that assertion is quite difficult to follow because the ledgers show you what amount went into the account and what amount was transferred out to the Mashreq account. And in between, it shows you each line item of expenditure, all of which is supported by underlying documentation and invoices. So there is evidence to prove that the amounts were deployed for those reasons, because you have the input amount, you've got the legitimate business expenses being incurred, and then you've got the amount that's left at the end. And one struggles to see what more you would need beyond that. Paragraph 8, this is at 1791, effectively questions the authenticity of the documents and goes on to take issue with payments to two of the individuals, so that's salary payments, to Abdulaziz Albulaihid and Mohammed Saad. And this introduces an assertion that those are employees of Health Insights Egypt. Now, just dealing with what's said out there, the allegations questioning the authenticity of the documents, those are just bare allegations. There's no evidence to support in any way why these, I mean, Your Honour has seen why these documents, which clearly come from third parties, for example, in the case of Evolve and from MetLife, and relate to salary payments, which have been going out of the HSBC account throughout the period before its closure, why all of a sudden those are inauthentic and don't reflect proper entitlements and business expenses. The HSBC accounts, as I say, show historic payments being made to all of those individuals, and those individuals continue to be paid following the closure of the HSBC accounts. The allegations raised about these two individuals in particular not being employees of Health Insights Dubai, one cuts against the fact that they've been paid salary from the HSBC account in the past. But even if that's a point that the claimants wanted to advance, these are brand new allegations. It's not part of the amended claim as it's pleaded. There's nothing in the amended particulars of claim that says there are illegitimate business expenses because you paid two individuals who were not employed by the company. What's alleged is that the first defendant misappropriated the funds. The inference presumably being that he misappropriated them to his own benefit. And the question for Your Honour this morning is, do the amendments as pleaded have prospects of success? Does the pleaded case that Mr. Shehata misappropriated funds to his benefit have any prospects? Because that's the case that's being advanced, and that's what's been put into issue. If what the claimants are saying in a way to adapt to Mr. Shehata's clear evidence on the expenditure that's been incurred is, well, we now take issue with these individuals and whether they were employees or not? Well, it invites a couple of questions. One, are they taking issue only when the HSBC account is closed? Are they taking issue with the payments to these individuals that were previously made from the HSBC account? If so, why were those allegations not made in the amended particulars of claim? Because the claimants have access to those bank account statements. They could see them being made and they didn't take issue with it previously. But if what's going to be an issue, and if this is how the claimants are proposing to advance their case at trial, nobody has led any evidence on whether these individuals were properly employed by Health Insights Dubai. And if what's being contemplated is somehow going back to the drawing board, making assertions that payments were illegitimately made to individuals who were actually employed by Health Insights Egypt, well, then there would need to be disclosure. It would need to deal with, for example, employment contracts. It would need to look at what the underlying contractual entitlements of these individuals were. And one would most likely look to get evidence from those individuals. And in fact, Your Honour might have seen from my skeleton that in the context of the allegations that were raised in the 4 new witness statements filed in reply as evidence for the substantive trial, those 2 individuals were being contemplated as witnesses for the defendant anyway. So it seems that there are 2 potential courses. One, the amendment isn't allowed because the amendment as pleaded doesn't have prospects. 2, if the claimants are telling you that there's this new case that they're going to advance, which requires the court to look into the employment status of these individuals, well, the first step that needs to be taken is that actually needs to be pleaded out properly. And then there needs to be documentary and witness evidence introduced in relation to those issues. And if the claimants are going to turn up to trial advancing some other case than the one they have pleaded, the defendants would need to be given an opportunity to provide evidence on whether that case, first of all, has prospects or not, and whether the amendment should be allowed. But if the amendment did proceed to trial, there would obviously need to be evidence that Your Honour had before you to make a decision in respect of those issues. And those are, of course, points that would feed into the adjournment application. Similarly, this is not unique in that allegation. In paragraph 11 of Mr. Al-Shafei's 3rd statement, that's at 1793. This is an introduction of an allegation about the first defendant's salary payments, which it's now said should not have been paid. But that is not how the claimants have previously advanced their position. The position in the factual witness statements for trial is, we acknowledge that Mr. Shehata was entitled to a salary of 55,000 dirhams a month. Full stop, that's the end of it. There's no caveat to that. What they are now advancing is a case that, well, he's made payments to himself for salary after a point in time when he should have stopped. That is a new allegation. It's not a part of the amended particulars of claim as pleaded. And if it's going to be advanced, it needs to be pleaded. If it introduced new issues into proceedings, for example, dealing with the termination of employment by Mr. Shehata, because there's a distinction between decisions made at board level and when those are given effect on the one hand, and terminating a contract of employment on another. But because that hasn't been an issue in proceedings so far, no one's led any evidence on that. So for present purposes, we say it's not part of the amended particulars of claim. Your Honour isn't being asked to consider whether that's a case that has merit. It hasn't been advanced yet. But if it is a point that the claimants are intending to take, then they're going to have to go back to the drawing board, and that feeds in to the other issues before Your Honour this morning. Similarly, paragraph 15, page 1794, it's another allegation questioning the authenticity of documents relating to professional services, and which also seeks to suggest in effect, that, well, these costs look a bit high relative to the value of the claim. But again, not part of the amended particulars of claim is currently pleaded. It makes new factual allegations, for example, about a lawyer not turning up to court, how expensive the fees were, and so on. None of that's in evidence, none of it's pleaded. Pleaded claims that the first defendant misappropriated the funds. So if this is going to be advanced at trial and the questions that are going to be put to Mr. Shehata at trial relate to this, well, they need to be pleaded out. And the defendant would need to be afforded the opportunity to actually provide evidence to respond to it rather than being asked to simply do it on the hoof. Again, the new allegations at paragraph 16, this time relating to transfers to Miss Davina, who I think is an office assistant. So paragraph 16 takes issues with transfers made to her on the 29th of May 2024 of 50,000 dirhams with no explanation. Now, this actually just pulls us completely out of the context of what's pleaded, because in effect, what has been an issue in the amended particulars of claim is a transfer from HSBC bank account to Mr. Shehata. This issue seems to be picking up on something arising from the Mashrek bank account statement. So it's a payment that was made following the opening of the Mashrek bank account in May 2024. So something which clearly goes beyond the scope of what has so far been pleaded, and something which has not been mentioned before, and something which would clearly call for further evidence if this is a point that is going to be advanced at trial. And it's probably worth pausing there for just a moment, because the pleaded case is seeking to set aside the transfers out of the HSBC account. That is based on a supposed interest that the first defendant has in the transactions. And that interest is presumably because the allegation is that he's misappropriating the funds to himself. So if he's misappropriating the funds to himself, he's operating under a conflict, and the transaction should be set aside on that basis. But none of what the second claimant is saying here in reply really makes sense in that context or fits within that kind of a claim. The first defendant isn't interested in these underlying transactions. They're payments to third parties for services given by those third parties to the second defendant. So what seems to be now alleged in the claimant's adapted case following the receipt of Mr. Shehata's evidence isn't some failure to declare an interest. I mean, it effectively seems to be a criticism of the first defendant's management of the company, and that would be a claim by the second defendant, not the claimants. But even if that's ultimately what is being said, there would need to be proper pleading and a proper opportunity to respond to the case if it's put in that way. And I'm sorry to say that's not even the end of it. Paragraph 18, Your Honour, this is 1796. Introduces another new allegation, and this is an allegation that Health Insights Dubai is receiving income in respect of a contract. So there's a contract with the Cambridge Rehabilitation Project. And a criticism is made that Nasser does not address at all in his witness statement this contract. It's not really surprising that it hasn't been addressed, because there's no allegations either in the original pleadings or in the amended pleadings that the first defendant received funds for Health Insights Dubai from the Cambridge Rehabilitation Project, which he hasn't accounted for and which hasn't been put to the benefit of the company. And this is, I'm sorry to say, a bit of a habit that the claimants are acquiring in introducing completely new and unpleaded issues by way of reply witness statements. I mean, this isn't even something that arises from the first defendant's evidence and answer to the application, which makes no reference to the Cambridge Rehabilitation Project or to income from that. So if that's an issue in the case, it's something that the claimants have been sitting on. It should have been pleaded if it was going to be an issue. It should have been pleaded at the outset of this case and raised long ago. But these are really serious allegations. This is an allegation that income is being received from the company. I assume the inference that the second claimant wishes you to draw from it is that Mr. Shehata has misappropriated the income from a particular contract and hidden it away from everybody else. I mean, if that is a point that's going to be advanced, and if that's something that's going to be put to Mr. Shehata at trial, it needs to be pleaded. There needs to be an opportunity to provide evidence on it, and so on. It's extraordinary to think that an allegation like that can just be thrown out there in a reply statement in an application to amend, with the implication, based on what the claimants have told you this morning, that this issue is capable of going to trial in a week's time and we have some questions about it. It's extraordinary to think that that should be the position, but that the first defendant should have no proper ability to respond to the allegation that's put. So, like I say, none of this is an answer to the question that's currently before Your Honour, which is, does the amended particulars claim, as it's currently set out, as it is currently pleaded, have prospects? And we say clearly it doesn't. But if the claimant's response to that is to say, well, we wish to rely on these other allegations that are referred to in the second claimant statement, then they're going to have to go back to the drawing board, and they're going to need to be upfront about the case that they are putting, and recognise that if that is how they're going to advance their case, then an adjournment would almost certainly flow from it. So, like I said, dealing with the application that's presented to Your Honour, that is the amendments as pleaded, this is one of those cases where Your Honour just does not need to take the claimant's assertions and speculation at face value without analysis, where you already have the documentary evidence showing that those assertions are wrong, and where the claimants, in saying that you're ready to proceed to deal with this issue in a week, must recognise that there's no real prospect of their position at trial being any better than it is now. And if that's the case, the amendments just shouldn't be allowed. And that would reduce the risk, Your Honour, of issues being thrown into play by cross-examination that have never been pleaded out before. And that certainly seems to be how the claimants contemplate going about this. But if, in response to that, what my learned friend says is, well, yes, we do intend to advance these petitions at trial, the alternative course is to make the claimants go back to the drawing board, to be upfront about it, to plead it out, and to allow evidence to be given on those issues. But otherwise, the matters that are raised in the second claimant's responsive witness statement have no place at trial. If those are the lines of cross-examination that are going to be taken, they shouldn't be permitted as lines of cross-examination. So again, there's no prospect of them advancing their position by asking Mr. Shehata some questions about that. So on that basis, we say the application should be dismissed. If Your Honour is minded to allow the application, there are going to need to be consequential directions when it comes to filing consequential amendments to pleadings, to putting forward documentary evidence which deals with some of these new allegations, and witness evidence and so on.
Can you take that a bit at a time, Mr. Doherty? If I was to allow the amendments, then you said there would have to be consequential pleadings. Do you mean a defence to them?
Yes. And any consequential amendments beyond that to the reply to defence to counterclaim and so on. But it would be allowing the defendant an opportunity to respond by way of pleading, and it would be permitting the issues that are going to be advanced to be properly addressed in evidence. So in particular, that's the issues raised by Mr. El-Shafei for the first time in his third witness statement. Those would need to be dealt with by way of documentary evidence and witness evidence, because they have not formed any part of proceedings so far. And I suppose there's a third course, which is if, for whatever reason, Your Honour was minded to permit the amendments as pleaded rather than the contemplated amendments to proceed and be argued at trial. It would certainly, from the defendant's perspective, be on the basis that the new points raised in Mr. El-Shafei's third witness statement wouldn't be acceptable lines of cross-examination because they're new points that the defendants haven't had the opportunity to address. And a final point in response to the suggestion made in oral submissions that the proper course when these applications, or this application was contemplated, was that it should have been acceded to. We don't accept that. The documentary record on this is very clear. There was correspondence in which the defendants have sought to put that information before the claimants to explain why, one, these were legitimate payments, two, the bank account was closed at the request of HSBC and that there's really nothing in this. The proper course at that point of time would have been to abandon the application. But it's not incumbent on a party faced with speculative and bare allegations, particularly where there are allegations that he has misappropriated substantial amounts of money from the company, to simply accede to them, where there are proper grounds to say that there's no evidentiary basis, not even a prima facie evidentiary basis for these amendments, and that they shouldn't be allowed and that they shouldn't proceed to trial. Unless I can assist further, those are the points I have to make, Your Honour.
All right, thank you. Mr. Montague-Smith.
Thank you, Your Honour. We do find my learned friend's submissions quite remarkable. I mean, just picking up on his last point, he tells you that this has all been covered in correspondence, and he says, well, the documentary record is quite clear. So he's implying to you that the documents that he's referred you to today were provided in correspondence previously, and that is not true. So the documentation which supports, which he says gives the indelible record of the use of this money, the ledger and the supporting documentation, his clients refused to provide that in response to requests from my clients, and were first produced in the exhibits to Mr. Shehata's witness statement, which was produced recently. The idea that we are not then entitled to look at those documents and say, we do not buy that, those documents do not show, are not reliable, is just another illustration of the approach that I was suggesting the defendants were taking in this litigation, which is, I say so, therefore you just have to take it as read. The reality here is we're talking in this context about a relatively limited amount of money. It's about $900,000, and my own friend ramps it up to be this enormous thing. But in the context of this court, that is a relatively modest amount, which we've now spent an hour and a half of trial preparation time arguing about. It's not disputed that Mr. Shehata made payments out of the bank accounts to himself at a time when a board resolution had been passed, which you found had removed him as the general manager of the company. So at that stage, his obligation was to hand off the company to the new general manager. And so my learned friend says, well, HSBC wanted to close the bank accounts. What was he to do? There was no other option, and he gives evidence about that. And that's just obvious nonsense. The other option, the proper approach, was not to pay himself money, but to hand over the control of the accounts and the control of the assets of the company to the properly appointed officers. So in this context, to say that there's no case to answer here is an extremely surprising submission. And you are then taken to a bunch of documents. So my own friend says, oh, I'm treading a difficult line on this, because on the one hand I say you have everything, but on the other hand I say, well, you know, there's an issue to be tried. Well, that again is just, it's just a specious submission, because these are issues of fact, and the way issues of fact are decided in this court is by trial and cross-examination. We don't do mini trials on the documents. That's precisely what you're not supposed to do on an application like this. So then he takes you to the actual underlying documents. So just go back to them very briefly and have a look at what we've actually got. If we go to page 512, he says, well, you can rely on the bank statements. The bank statements prove it because they say this is a temporary transfer due to company account closure. Well, that's just a description that's been entered by Mr. Shehata at the time of making the transfer, at a time when he's been ousted from the company. So that doesn't take you any further than Mr. Shehata just saying, take my word for it. He then takes you to the ledgers, which start at page 514. And these are just ledgers created by Mr. Shehata. This is just Mr. Shehata saying, these are the reasons I paid myself all this money. It wasn't actually paid to me. I was holding it for the company and I used it for company purposes. So of course we're entitled to question this. Of course the court can't, on an application, on a hearing like this, just take Mr. Shehata's word for it. And amongst the justifications that he provides, he says some of this, and you'll see it on page 514, salary payment to, for example, Davina. And then one goes down further, for example, and you will see page 516, the salary payments to himself. And then if one goes down further still to page 519, you see the legal fees and also salary payments again to himself, stretching forward to May 2024. All of this made early on, so after the actual transfers were undertaken. And so my own friend says we have to advance some sort of pleaded case about how this was misappropriation, but this is the justification that's being provided by him. So we're probing his justification for his use of company money in circumstances when he should never have been in control of it at all. These are not new issues to say what this is a response to his evidence. This is how I used it. Well, that doesn't work because X, Y, and Z. This is how I used it on this. Well, that doesn't work because X, Y, and Z. There's not something that requires endless pleadings. He's given his explanation. We've explained why we think that it's not reasonable and not truthful. And that is precisely the sort of conflict of evidence that needs to be resolved at a trial. So when one goes down through the substantiation, you get to page 522, for example, which is then an example of a salary slip, which again is a document produced by Mr. Shehata. And the reasons why we doubt these sorts of documents have been articulated by Mr. Al-Shafai. And I invite you to read his statement. Again, it starts at page 1789. But I've explained some of those points, but not all of them in detail, because it's not appropriate to do so because this isn't the trial. But in summary, if one goes to 1791, I've told you some of these people don't appear to have been employees of HI Dubai at all, and there is evidence to substantiate that. The signatures don't appear to match previous signatures given by those individuals. And C, it's said that cash payments have been made at a time when, according to Mr. Shehata, he wasn't able to travel to Dubai and to hand over any cash at all to these people because he was under a travel ban. So there are obviously questions to be asked of him. Now, it may be that there are answers to those questions. We doubt it, but there we are. And then in relation to the payments to him, we make the point that those are partly payments that have been made all the way up to May 2024. That's his position. I paid myself salary. Presumably he's saying he's still entitled to draw that salary. So he's gonna say, well, I'm entitled to another 55,000 dirhams a month for perpetuity. But that was a salary associated with his role.
Which role?
His role as general manager, because it's not a contractual arrangement. There was a board resolution permitting him to take that salary for the purposes of his role. I mean, we can investigate this. We can show him those documents. We can deal with this at trial. But I think my learned friend suggested that we need employment contracts for Mr. Shehata, but that's not the basis of the salary. So I'm not sure where he's getting that from. It's in a board resolution, and then he was removed from that role. So you might agree with me on that. You might disagree with me on that. There might be argument to be had on that, but it's not for today. So the idea that there's no triable case on this is again just not we say reasonably arguable. Essentially, he's had almost $900,000 of the company's money. He's drained it. He's paid quite a good chunk of that to himself, and he says he's paid it for other legitimate purposes. Well, we want to ask questions about that. And I told you about the legal fees, which is another good chunk of it, which is at 1795. And the evidence in relation to that, amongst other things, was, as I say, we doubt that that can really be for HI Dubai legal services attributable to the purposes that have been said. But we'll ask questions about that. But also, he says some of it was paid in cash, again, at a time when he wasn't able, he said, to travel to Dubai. And there does appear to be a false passport number, for example, that's been inserted onto that document. So there are genuine factual forensic reasons to doubt the veracity of the explanation that he's given. This is not raising a new case. This is simply him saying these are the legitimate purposes for this, and us saying, well, we doubt it. Well, let's find out. Let's have a trial about it. That's how these sorts of things are determined. So that's the case that was put forward. There's no need for further pleadings and responsive evidence to deal with an $850,000-900,000 claim in relation to money that he took from the company at a time when he wasn't entitled to act as its general manager, and he's now explained what that's all about and provided his best evidence in support of it. That's really the beginning and the end of it. We can do this next week, or sorry, in a week and a half's time. I don't propose to repeat my other submissions, Your Honour, unless there's any other particular points that arise out of those responses. I don't know whether you wish to make a ruling on that or move on to the next application.
I think I'll await until the end, because in a sense they all tie into the final application number 11.
I can see that. Thank you.
Yeah. All right. Just before we start on with number 10, I'm going to take, or at least switch my camera off for about 30 seconds whilst I adjust my air conditioning, but I'll only be a short time. That's right. I think I have the door open.
You must have the door. Wouldn't you
It's
open
locked
the door?
now. I've got that sorted out. Perhaps let's go to application 10, and I should start. We'll go to you first, Mr. Doherty.
Thank you, Your Honour. As you'll gather, this relates to issues with claims disclosure, the related applications to join additional parties or alternatively for non-party production as the route to addressing those deficiencies, and an application to introduce limited amendments to the defence and counterclaim. The way I'm going to run through that is, first of all, to taking Your Honour to a bit of the factual background material so you can see what the problem actually is. Second, to remind Your Honour of some of the procedural history to show you how we've got here and how the claimants have ended up taking the slightly unusual position that they have. Third, explaining why on any analysis the claimant's position on disclosure is wrong and breaches the document production order that you made. Fourth, I'll set out the basis for the joinder and disclosure applications, and then I'll deal with amendments at the end of that. But the starting point, or the core of the allegations that are going to be advanced on the counterclaim at trial, you can see pretty handily from page 621. Which is the financial statements for the company. In particular, if you go to page 623 of that, one can see what the audited financial position of Health Insights Dubai is in effect prior to this dispute. I say small d dispute, the broader dispute between these parties arising, which is you can see the revenues coming into Health Insights Dubai either side of 30 million dirhams in any given year, turning around gross profits of between 11 million and 20 million a year. So in 2020 and 2021, Health Insights Dubai is booking those revenues, and it is generating those profits from which the shareholders of Health Insights Dubai are entitled to enjoy the benefit of. One can see the operation of the company in practice, and I'm going to deal with this very quickly, but Your Honour will see at trial that there's a long history when it comes to the payments being made and income being generated. But if one goes to the bank account statements, for example, page 240, and there are numerous examples of this, but you can see deposits 1.29 million coming in from Al Khalij. Similar payments appear elsewhere in the bank statement. So 253 is another example, 2.46 million coming in from Al Khalij. So this is the revenue that Health Insights Dubai is generating, and where its income is coming from, and ultimately where distributions end up being paid out to each of the claimants and the first defendant. What happens is once the dispute arises, Al Khalij stop making payments to Health Insights Dubai, full stop. And what we see happening instead, so if we go to 1864, sorry, 1862. I think the numbering of the bundle changed with the latest iteration. These are bank account statements for a newly set up company. So this is Health Insights Saudi Arabia, which was set up by the claimants and which the first defendant is not a part of. And what we can see in the second row of this page is one example of income that you can see was previously being paid to Health Insights Dubai. There's a payment of 1.15 million comes into Health Insights Saudi Arabia instead. So there's a newly set up company following this dispute arising. So Al Khalij in the past is paying Health Insights Dubai. Now it's paying a company which is owned entirely by the claimants. And we have a relatively limited run of bank statements for Health Insights Saudi over the course of about 12 months. So these run from June 2024 to May 2025. We don't have comparable statements for Health Insights Egypt, for example. So whatever's going on there is unknown to us. But even in this 12-month period, what you can see is income being received by Health Insights Saudi from Al Khalij in around the sum of about $3.3 million in less than 12 months. And at 1871, you can also see that there are exchanges between Health Insights Saudi Arabia, whose statements these are, and this is the second row again. It's a 1.5 million real transfer to Health Insights Egypt, which again the claimants have control of, and in respect of which I think already by this time the second defendant's shareholding is being diluted down from around 30 to 35% to about 0.2% during this window. So again, the money is going from Al-Khalij to Health Insights Saudi, and at least some of that money is going from Health Insights Saudi to Health Insights Egypt, both companies that the first defendant has in effect been shut out of. So prior to 2022, we've got Al-Khalij paying Health Insights Dubai in it, booking revenues and shareholders benefiting from those profits. And after 2022, those payments stop. You can see that at 642. Sorry, 644. Where if you compare the year-end results in 2021 and 2022, you're going down from revenues generated of 26 million dirham to 3.5, turning the company from being a profitable business from which one would expect distributions to one which is making a loss. And that's happening because the payments are being made to a company that the claimants have shareholdings in, but the first defendant doesn't. And it's pretty straightforward to put two and two together. And for all that my learned friend comes this morning with all guns blazing and says that we're trying to knock off trial and we don't really have a good answer to the questions put to us, it is very, very clear from the documentary evidence, which Your Honour is going to see in due course, that there is a very clear diversion of revenues that have historically, and this is going back into the 2010s, been paid to Health Insights Dubai, all of a sudden drying up, and the benefit of those contracts being paid to companies which the claimants control and which the first defendant, both as a director and a shareholder, is shut out of. So the first defendant is being directly cut off from his entitlements to profit from the success of these companies. And really, that's probably a convenient point to take you to the thrust of the amendments that are being introduced. So you can also see the wider context of this, because the amendments that are being proposed for the defence and counterclaim arise from, in effect, the relatively limited amounts of documents that have already been disclosed, but which present only a small part of the picture of the claimant's wrongdoing. But if you go to 763, and at paragraph 64A, first of all, is a clarification of a previous sentence that the first claimant wrote, which was that Al-Khalij will not deal with Health Insights Dubai anymore, and that's to plead out that the communication expressly acknowledges that, in fact, Al-Khalij know that the entity that they were dealing with was the second defendant, not another Health Insights entity. And after that, at paragraph 66, we get one of the main substantive amendments, which is to specifically refer to a document from the 28th of August, 2022. And this is a memorandum. It's issued, well, the heading says that it's Health Insights without clarifying further, but it's pretty clear that it's being sent on behalf of Health Insights Egypt. And if Your Honour looks at the text of it, particularly from the third line down, so that's at the bottom of page 763, there's this statement that we confirm what was mentioned in your letter, that there is no formal or legal agreement between your esteemed company, so this is to Al-Khalij, and Health Insights Dubai, nor is there any agreement between Health Insights for Software Design Egypt, so that's Health Insights Egypt, and Health Insights Dubai, regarding the transfer of financial compensation for the services provided by Health Insights Egypt, as the legal contract is concluded between your company and Health Insights Egypt. And then over the page, the final paragraph of this says, finally, we affirm, as per the supply orders between us, that your esteemed company is not bound by any legal contract except with Health Insights Egypt, and that any current or future transfers should be made to the account of the contracting company, Health Insights for Design, so Health Insights Egypt. Now, we didn't have this document when the case was originally pleaded out, but Your Honour will recall from the original pleadings that what was alleged was that either the claimants already had, or if they hadn't already, were going to take steps to both write off debts which were owed to Health Insights Dubai, to deprive Health Insights Dubai of that income, but also to divert revenues that were properly due to Health Insights Dubai to companies that they controlled, and in effect shutting the first defendant out from those. So this document, being entirely consistent with the pleaded case, is therefore set out in its detail, and we rely on it expressly. So we are pleading reference to a document which shows in very clear-cut terms the request to divert money previously paid to and booked by Health Insights Dubai to another company that the claimants control, i.e. Health Insights Egypt.
When did you get the document, Mr. Doherty?
The document was, I think this document was originally sent as part of the disclosure. 60% of the documents sent in disclosure were in Arabic and not provided in translation. So there's obviously a period of time there where a substantial amount of documentation needed to be translated before it was reviewed. And then this document, I should add, because I know that I think there's a point taken, certainly in my learned friend Skeleton, that, well, you can't introduce this because we ought to have an opportunity to be able to respond to its content. And it's interesting that the claimants ought to be afforded that sort of opportunity on the claimant's analysis, but the defendant doesn't need to be able to respond to points. But in any event, this memorandum was referred to in Mr. Shehata's initial witness statement.
You didn't directly answer my question. So you got the documents, 60%.
It came with the disclosure in Arabic is the answer. I can't recall when I first saw the translation of this document, but it was prior to the exchange of the first round witness statements, because the documents referred to in the first round witness statements.
I can help, Your Honour. It was disclosed on the 20th of May.
All right, and then what you're telling me, Mr. Doherty, that it may or may not have been in Arabic, and you didn't see it until when? In translation.
It was prior to the exchange of first round witness statements. So the document is referred to in the witness statements, and therefore to sort of counter off any suggestion.
Whose witness statement referred to?
Mr. Shehata's sixth statement.
And which one? 6, is it? His witness statement?
Yeah. So not the reply statement. It was in the his first trial statement.
Okay.
So it's pleading out by reference to a document, in effect, the case that was already put about the writing off of debts and the diversion of revenue streams to entities controlled by Egypt. So there's nothing inconsistent with the pleaded case. And plainly, given the way it's been referred to in evidence, there's been an opportunity to respond to the content of the document in any event in witness evidence. And similarly, 763, which is the other main substantive amendment. Again, this is to plead out documents which are referred to in the witness evidence.
763, which paragraph?
Sorry, it's my page number is off. 765, paragraph 71.
Okay, 71. Right.
So this is to plead out reference to specific documents which record the existence of transactions which are in evidence which have been dealt with in witness evidence, but which show that contracts that are being awarded for the distribution of Medica-Clyde care are to the benefit of these other entities. So that's to Health Insights Egypt and to Health Insights Saudi Arabia, and that these are based on the previous Al-Khalij contracts. And one can cross-refer these to the various different contracts that are already referred to within the pleadings. So these are support for the implementation of the 24 hospital project and the King Fahd Specialist Hospital and so on. So the contracts...
Sorry, can you just take that slowly for me? So 71A refers to a contract. Now, did I understand you to say that contract is already referred to in the pleadings?
So in the pleadings, particularly in the reply to defence to counterclaim, is set out a series of transactions. First of all, that Health Insights Dubai entered into with Al-Khalij. So this is for the provision and implementation services for MCC. And one can see all of the purchase orders which show the description of these contracts as being for the 24 hospitals or for the Sheikh Zayed Specialist Hospital, for the King Fahd Specialist Hospital, and so on. What happens is that annually those contracts then renew, and we've got contracts going back 2015, 2016, and so on, and payments being made in respect of those contracts to Health Insights Dubai up until a particular point in time, where the renewals come to the benefit not of Health Insights Dubai, but of Health Insights Egypt and Health Insights Saudi Arabia. So this is after the point in time in which the benefit of the contracts has been diverted away from Health Insights Egypt to these other entities. And examples of that were pleaded out in the reply and defence to counterclaim. And the allegation, of course, was made in the defence and counterclaim itself. And what these amendments reflect is further documents which have since come to light, which were provided with the disclosure and which have been referred to in the witness evidence, which show other instances of that diversion of income.
So are each of those contracts or orders referred to in your witness statements?
Yes.
The original ones?
Yes, I believe so. And let's see if I can get you a paragraph reference.
Okay.
I believe it's at paragraph 155 of Mr. Shehata's sixth statement.
Okay. Yes.
So really that's to show you how those particular pieces fit together and what the context of the claim is. There was income and contracts which Health Insights enjoyed the benefit of. The shareholders fall out, and the benefit of those contracts is siphoned off to two companies, Health Insights Egypt and Health Insights Saudi Arabia, which the claimants are shareholders of and control, and which the first defendant is either not a part of or has been shut out of in the case of Health Insights Egypt, and so no longer enjoys his previous entitlements, for example, to shares and distributions of profits arising from those contracts they had previously. And that's the thrust of the case. And the point of showing you that really is to say that these are specific pleadings of fact which relate to the case that was already put. They're just inserted because there are new documents showing new transactions effectively. Now, the reason I showed you that is to underscore why it is that, one, the defendants sought the documents they did by way of disclosure, and two, to remind Your Honour why you ordered the production of particular documents as being relevant and material to the determination of the counterclaim. And I've set this out in my skeleton to put it in as brief terms as I can, Your Honour ordered the disclosure of a range of documents which feed into this issue. But that includes request 2, which was contracts held by the claimants, was the way it was termed, in relation to Al-Khalija's sale of Medica Plus and Medica Cloud Care. None of that has been disclosed. Request 3 was for copies held by the claimants of Al-Khalija's invoices, receipts, remittances, and bank statements. None of that has been disclosed. Request 10 was a similar request for invoices, receipts, remittances, and bank statements, in effect to show the other side of the transaction with both Health Insights Egypt, Health Insights Saudi Arabia, and any other Health Insights brand that had been set up by the claimants. That disclosure has not been provided in full. So, for example, the documents I showed you earlier, which showed incoming payments being received from Al-Khalij, was the Health Insights Saudi Arabia bank statements from 2024, for the middle of 2024 only, whereas there was an order made for the production of Health Insights Egypt's bank statements for several years before that. Request 11 was then financial statements for all of those entities. So Al-Khalij, Health Insights Saudi, Health Insights Egypt, none have been provided for Al-Khalij, and we say a full set has not been provided for Health Insights Saudi and Egypt. And really the purpose of the order was to get disclosure of documents that show the court what contracts have been entered into, which Health Insights on the defendant's case was entitled to enjoy the benefit of, what payments have been received by those other entities that ought to have been paid to Health Insights Dubai, and to which entities have those funds been diverted to. And by not providing that evidence, we say that key materials clearly being withheld and not put before the court. And we say that there's no good reason for that, because an order for disclosure has been made and it has to be complied with. So the procedural background, which I'm sure Your Honour will recall, is that there was an initial objection taken in the claimant's objections to the request to produce. And I'll go to the document, but what it said is that Al-Khalij is its own separate legal entity with an independent board of directors and governance structure. Prior to the disclosure of any documents relating to Al-Khalij, approval of the board would need to be obtained. The claimants are not in a position to compel Al-Khalij to produce any documentation. The documents requested, therefore, are not within their possession, custody, or control. Now, that point having been advanced in the objections, was dropped by the claimants at the hearing of the application. And I've referred to it in my skeleton, but Your Honour might recall that exchange, because skeletons were provided by the parties. The point was effectively argued out in anticipation by us. And you asked Mr. Jackson, who was conducting that hearing, to confirm at the beginning, is that a point that you still maintain? And he said no. And that, as it happens, was a sensible decision, because the point taken by the claimants conflated requiring Al-Khalij to produce documents in its possession, custody, and control on the one hand, with what was actually being sought, which was an order that the claimants produce documents in their possession, custody, and control, albeit ones that related to Al-Khalij. Those are completely different things. And the terms of the order were clear in requiring the claimants to produce documents which they had, which related to Al-Khalij. Now, it so happens that they probably had quite a lot of material to that effect, because in their possession, custody, and control, of course, would have been access to documents which they obtained in their capacities as agents of that company, or as agents of Health Insights Dubai, or Egypt, or Saudi Arabia. And this ought not to be a particularly controversial point. Your Honour might recall in the hearing I referred to the case BVB. That's in the bundle. I think it starts at page 2078. But it might be worth pulling up. sorry, bear with me. I've got a slightly separate set of page numbering. I don't know if Your Honour has access to our authorities bundle. It was sent as a separate PDF.
But it's also been included in this bundle, I think.
It's okay. I'm just trying to search for the internal page reference. Bear with me. Because I'm working off a different PDF version. So if you go to the internal pagination for this case at 186, so that's the page number on the top left-hand side.
For my benefit, could I just have the page number in the actual bundle?
Which I don't have a copy of the bundle to which this was added, so I'm having to work off an offline version. But it's
well, I've only got the case bundle. I think I don't. It should be in section F.
I think it's
the sixth page in to this, and the judgment begins at 2078. I think that's just from my adding together the numbers.
My bundle runs out. I think the online bundle runs out at 1983.
I think I've got 2078.
Ah.
I think this is because there were some late changes to the bundle, and I know that some people have had difficulty accessing the new version and some haven't, which is why I've got trying my best with the page numbers that I have.
Yes, I've got the case starting at 2078.
And the page that I'm looking at, Your Honour, should, I think, be 2084 of your bundle, which should be the internal page 186 for the authority on the top left, hopefully.
I have 186, yes.
And the bit that I'm referring to here is first of all between D and E, which is the sentence beginning custody, which says custody means the actual physical corporeal holding of a document, regardless of the right to its possession. For example, holding a document by a party as servant or agent of the true owner. And at the bottom of the page around G, there's reference made to an extract from the Supreme Court practice. And if you go over the page to 187, it's talking about the discretion that the court has to order inspection. And it says, but the court has a discretion whether to order inspection, and it may be that in the exercise of such discretion, it will have regard to any prejudice to persons having a right to the documents in question. And then if it follows on at B, it refers to express approval in a case called Alfred Crompton of those points, and says it then follows that a person has the obligation to disclose all relevant documents which are or have been in his custody or power, even if he is not the owner or the sole owner of them, and prima facie he is obliged to produce all such documents for the inspection of the other party. If he objects to production, the court has a discretion whether or not to order production. And then from F, it refers to the court considering that discretional exercise. It's a matter for discretion, though in exercising the discretion, the court will no doubt have regard to the words of Lord Justice James and Kettlewell and Barstow. The court will not order the defendants to do what they have no power to do, but it is no ground for resisting production that a person not before the court has an interest in the documents. How do these general principles apply to the director of a company in relation to company documents, that is, to documents which are in the possession of the company in the sense that the company has sole legal right to their possession? If they are or have been in the custody or physical possession of the director, even if he has only held them or holds them as servant or agent of the company, or in his capacity as an officer of the company, then they must be disclosed. Whether such documents are or have been in his custody is a question of fact. In each case, it's a matter for the court whether they should be produced. So the point is, if you've got actual custody of a document, because it's in your physical possession or you have access to it, even if the company would have a legal right to it in the sense of having a right to possession, or if that company had an interest in it, that's not a grounds for withholding its production. So if the claimants have custody of the relevant documents, which they do, in their capacities as directors or agents of Al-Khalij or of Health Insights Egypt, and so on, the documents are disclosable. They have to be produced. The permission or not being given by Al-Khalij's board is irrelevant. That is almost certainly, I would imagine, why this point was actually dropped at the hearing of the document production application itself, because it's not a proper grounds for withholding production. In fact, at that hearing, Your Honour, when it comes to the discretionary aspect of this, wasn't even asked to withhold an order for production based on the exercise of a discretion under, for example, RTC 28.28, which Your Honour will know sets out a number of grounds in which you can ask the court to withhold production. Those includes things like grounds of technical or commercial confidentiality that the court finds to be particularly compelling, but no case was advanced that there was some particularly compelling grounds of commercial sensitivity preventing the production of these documents at that time. And so Your Honour did exercise your discretion in ordering the production of documents. You ordered that documents held by the claimants, which related to Al-Khalij, to contracts, to payments, to bank statements, and so on, you made the order that those be disclosed. That order wasn't appealed, and really that's the end of it. Once the order is made, the documents had to be produced. There's no subsequent get out. A party has to produce documents specified in the order, and the claimants haven't. They accept that they haven't, as I'll come to, and so they've breached the court's document production order. It's really very straightforward. We can see that because the claimants have provided their document production statements, which we say effectively admit the breach. They've unilaterally decided in particular not to disclose documents which relate to Al-Khalij. And Your Honour may have noted when you're reading through the skeleton arguments the way that this was put by the claimants, which is they have produced documents which have come into their possession in their capacities as directors of Health Insights Egypt and Health Insights Saudi Arabia, but conspicuously absent from that mix is documents that they've come into possession of in their capacities as directors, shareholders, employees, whatever it happens to be of Al-Khalij, or for that matter, Jura Holding, the parent company for Al-Khalij. What the first claimant says in his document production statement is at page 797. The paragraph 14. And you can see a almost exact recitation of the same argument that was set out in the objections to the request to produce. So I'm not authorised to disclose documents relating to Al-Khalij without the approval of the board. The board have authorised me to disclose certain documents which I've disclosed, including articles of association. But what's accepted is I've not disclosed documents responsive to the rest of the order. And the second claimant's statement is at 804. He just says, I'm an employee of Al-Khalij and not authorised to provide documents without first obtaining approval of the board. So the same arguments suggesting that we're just not going to disclose, but these aren't arguments that we don't have possession, custody, and control of the documents. They do have possession, custody, and control of documents. They're just saying, I'm not going to disclose it without the board's approval. But that argument was run once and dropped. They can't just run it again, and it certainly isn't a permissible grounds to refuse production under the RDC. I've shown you the BVB case. It says those documents must be disclosed. RDC 28.39 says a document production order will direct that a party must do one or more of the following things. 1, produce documents or classes of documents specified in the order. Carry out a search to the extent stated in the order. There's no get out from that. I mean, one could say the documents are no longer in my custody because the warehouse where they were stored caught fire, and so the documents don't exist anymore. You could say that, but you can't say, well, I've got custody and I've got access to the documents, I'm just choosing not to disclose them because the board won't let me. You have to disclose the documents. That's really clear on an application of both the principles and B, but also the DIC court's rules. But even if you look at the justification that's relied on, I mean, it just really doesn't stack up. So this reference to the laws of Saudi Arabia, first of all, what the first claimant says is, well, I came into these documents because I'm a director of the company, but the law precludes me from disclosing them, so I'm not going to. But the provision relied on says no such thing. It's at page 1536. And this is Article 171. This is Saudi company law, but it says 1, the partner shall have the right to participate in deliberations and vote on decisions, and shall be entitled to a number of votes equal to the number of interests that he owns. So the first point is that what we're dealing with here is a provision dealing with shareholders. Partners in this context mean shareholders. We're talking about voting equal to the number of their interests. And it's 3 and 4, which are suggested and engaged in this case. It says a non-managing partner may present his opinion to the manager. Said partner or his designee may request access to the company's operations and examine its records and documents at the company's headquarters twice during the company's fiscal year. And then it says a person who becomes privy to any information pursuant to this article shall maintain the confidentiality of said information. What it's saying is if you're a non-managing partner, you have a right. So if you're a non-managing shareholder, you have a right to request twice a year access to company's documents. And if you become privy to information pursuant to the exercise of that specific right, you should maintain its confidentiality. And the takeaway point is that that is completely irrelevant in this case, because we're not talking about information the claimants acquired whilst exercising this specific right under Article 171 of this law, as in a capacity as a non-managing partner to access companies' documents. It's also worth pointing out that this provision says absolutely nothing about board approval, but in any event, it just doesn't work. The first claimant is not a shareholder of Al-Khaleej. So this provision does not apply to him.
You're still on Article 171?
Yes.
Now, why are you referring to shareholder?
Because that's what this provision is dealing with. So when it says partner, it's talking about shareholders. So if you look at what
their partner is a shareholder.
Yes, because it's talking about them having the number of votes equal to the number of interests they own.
I see, yes. Okay, thank you.
So the point is that the first claimant isn't even if this provision could have arguably been engaged by someone, it couldn't be engaged by the first claimant because he's not a shareholder in Al-Khaleej. He has a shareholding in the parent company, Jura Holding, but he doesn't have a direct shareholding of Al-Khaleej. So this provision is inapplicable in any event. But beyond that, the capacity in which he came into the documents isn't as a shareholder of Al-Khaleej pursuant to the exercise of this Article 171. He got them because he's the general manager or the managing director of Al-Khaleej, and he's an agent of the company. So the basis on which he came to have custody of the documents is completely different. And for what it's worth, the second claimant isn't a shareholder either. I mean, to the extent that it suggests that there are broader provisions of either company or employment law which say that that's grounds for withholding disclosure, again, we say that that's a non-starter. You can find obligations of confidence with respect to any company director, most jurisdictions. You can find the same thing for employees. So the DIFC employment law imposes an obligation of confidentiality on the part of an employee to their employer. That doesn't entitle that employee to withhold disclosure of documents that are in their custody when the court has ordered them to produce them. And if a party was seeking to rely upon, for example, those provisions of confidentiality which are in either a company law or an employment law, the point in time at which you've got to raise that objection is when the court's exercising its discretionary aspect of deciding what documents to disclose. So it should have been raised under RDC 28.28. That ought to have been dealt with at the hearing, and you can't just resurrect these arguments now. They were bad arguments at the time of the document production applications, and they're bad arguments now. And so where it leaves us is pretty squarely that the claimants just haven't complied with the document production order. There is.
When did they give disclosure? When did they make their document production statement?
Everything all right. The 20th of May, 2025.
Okay. And you didn't make any application seeking to compel them to produce the documents that they were obliged to and hadn't produced?
Well, the history of it was one where the parties, well, we sought in hope to interact with the claimants to try and get disclosure without making an application. So as I've already said to Your Honour, 60% of the documents were in Arabic. There was a process of getting quite a large volume of documentation translated that then needed to be reviewed all the while that witness statements were being produced. But once that material was received and reviewed, correspondence was sent. So it was a detailed letter sent at the beginning of July of this year, which is in the bundle. It's at page 1120. But it's a detailed letter which also sets out a detailed schedule of what the problems were with disclosure. So I think it runs through over some 30 pages. A response was sought to that within a week. The claimant's representatives in response to that said, well, we need longer to respond. By the time we got to the PTR, their position in their PTR skeleton was a substantive response to that is being provided. We hope that it's going to resolve all or most of the issues. So I think what was anticipated by the time we got to the PTR was that there was actually going to be some genuine engagement with this without the need to involve the court. And it's only then on the 4th of August that one gets a response. That's at 1153, where, well, suggesting two things. One, we're not going to provide any of the Al-Khalij documents, and we're going to rely on the same objections that we've taken before. And two, there's a suggestion of fairly limited further searches being carried out. Those, as far as I'm aware, have not been carried out. And certainly no further documents that I'm aware of have been disclosed.
All right.
But really, because the thrust of it was...
Okay, so the 4th of August, they said, we're not going to provide the documents. You still didn't make an application that they produced them.
Well, it's probably also important to put it in context, Ron. I think this is getting right up to the wire when reply witness statements were due. And as soon as the reply witness statements were in, an application was produced dealing with this request for disclosure. But it's not like it's come out of the blue to the claimants, nor for that matter is the request in and of itself, at least for some of the categories of documents, that extensive. I mean, it's not that difficult to produce bank statements and financial statements. They're limited categories of documents.
But you still haven't made an application that they produced them, have you? I'm trying to see practically what I'm supposed to do you still haven't sought an order that they
we have an order. Sorry, I think I misunderstood. An order that the claimants produce. There is already an order that the claimants produce the documents.
Yes, but they failed to produce them, and you've not sought any order to compel them to produce them. You've not sought. Can't recall whether the rules provide, as many jurisdictions do, for orders for production of specific documents or compelling them to produce the documents referred to in their statement or so on. You seem to have just complained that they haven't produced them and moved on.
Well, I'm not sure what form of order Your Honour would be talking about. The only order we can get from the court is an order that they produce the documents. They haven't. The consequences for that, well, there are a couple of consequences in the RDC, but for example, if you signed a false document production statement, it can lead to committal proceedings. There are questions about adverse inferences and so on. But ultimately, the order has been made that they produce the documents. It shouldn't require another order made again that they produce the documents. That order already exists and they have to comply with it. And if they haven't complied with it, then there will be arguments about adverse inferences and so on. But what's been made pretty clear by the claimants is they're not going to comply with it. So one can take the pragmatic view at that point that you can go back and ask them for it again and continue to flog that horse, or you can go about it a different route and get the documents from another source where they can't possibly raise those objections. The reason that, well, we do seek substantive orders be made in respect of the claimants, and that's for a declaration that they've breached the order. My learned friend says there's no utility in that. We disagree. The purpose of seeking a declaration that they haven't complied with their obligations is it changes the starting point one gets to when we get to trial. So what's suggested in my learned friend's Callan is, well, if they haven't complied with the order, then this just has to go to trial, and then you can have arguments about whether the court should draw adverse inferences, and we're going to argue that the court shouldn't draw adverse inferences from it. What an order declaring that they breached the obligation, which we say they clearly have, would do is it now puts the starting point somewhere different. So it will put the onus on the claimants to cure their non-compliance with the order. But if they don't, the starting point at trial isn't going to be that it's open to argument whether or not the court draws adverse inferences. The starting point, if you make the declaration that they breached the order now, is the court will draw those adverse inferences unless you cure the breach. So we don't accept that it doesn't have utility. It clearly does, because it means that we're not kicking this argument down the line and points will be made in submission. Well, we thought we could rely on this, but please don't draw adverse inferences. It should be pretty clear, and it should give the claimants a clear incentive to cut through this issue by disclosing the documents themselves.
Yes. All right. Thank you. I understand that.
So that's one limit, and that's why we say there is real utility in making an order to that effect, because maybe that just cuts through some of the issues. But the follow-on question is, well, if the claimants are, as they seek to suggest, not going to disclose documents which relate to Al-Khalij, even if they're in their custody, well, what can or should the court do about it? As I said, there's been correspondence in this issue, and the clear response seems to have been that production isn't going to be provided by the claimants. They say they need permission from the board. And so the application that's being made, and really the trigger point for making a joinder application, is
all right
to facilitate that.
Mr. Doherty, I think, so that I can follow each application. I know that we're still dealing with 10, but application 10 really has got a number of separate applications in it. And yes, I will find it convenient to deal with them, some of them separately. And I think I might pause you at this stage and go to Mr. Montague-Smith in response to essentially your application for a declaration of non-compliance. Mr. Montague-Smith.
Yes, thank you, Your Honour. And just to preface it, I mean, my learned friend has taken 1 hour and 10 minutes to develop that application. which is quite extraordinary. And I mean, one might see why he wants 10 days for trial if he's going to be that indulgent. And of course, parties should be given the opportunity to fully express their cases, but that we do say there needs to be some discipline imposed here, because that was just excessive. And just for the purpose of today, we're not even going to get through the applications today if we go on at this pace.
All right. Well,
So
I take your point, Mr.
I'll be speaking.
Smith, and I will ask Mr. Doherty to speed up with his remaining applications. Let's deal with this one.
Thank you. All right. So the issue is whether or not Your Honour should make a declaration, which my learned friend says will somehow switch the burden in relation to the drawing of adverse inferences, which he hasn't yet identified what those inferences are going to be.
No, but and let me interrupt you to put you where I sit. At the moment, Mr. Doherty has provisionally persuaded me that the claimants have not complied with the order. Now, one of the purposes of making the declaration that is sought is that your clients would then have a choice. They might comply before the trial begins, or if they don't, then the position will be known that they have chosen or continue not to comply, and Mr. Doherty would then put forward whatever the inferences he says should be drawn.
I understand, but you can't have a stick without knowing what the sanction will be at the end of the day. So if he was applying for some other form of order, then one might give that some weight. I mean, obviously, that there's some submissions I want to give you in relation to breach and all the rest of it, but one doesn't just go and say, well, all right, you haven't disclosed documents, you're ordered to disclose those documents, therefore there will be adverse inferences. Now let's talk about what they are. Unless you give those adverse inferences content and justify them, then there's nothing.
I'm not sure that you can, Mr. Smith. Won't that depend on the evidence and each in relation to particular parts of evidence? It will be said that a failure to produce certain documents might give rise to an inference and so on. You can't draw sort of a blanket inference.
No, but so and no applications made at this stage, rightly so, because it does depend on the context in the trial. But what needs to happen as a precursor to all of that is that the party who is seeking the inference needs to say, this is the inference that I will ask the court to draw as a result of your failure to produce document X, document Y, and document Z. And categorically, that's a requirement for any application for adverse inferences. One doesn't go to the court and say, I want adverse inferences, full stop. And then the court says yes, and then let's discuss what those inferences are. So we would say, look, it's just the submission as a matter of law is wrong, that if the court finds that documents have been ordered but not produced, then inferences will follow. That's simply not the position. B, until you know what those inferences are that are being sought, then you don't give any content to the sort of stick and carrot approach that my own friend is suggesting you ought to take. I think the points that we would make are, first, my own friend talks about various different provisions of the company's laws. My clients are in a very difficult position. They are bound by confidentiality provisions under Saudi law, and in particular Saudi labour law. Confidentiality, Your Honour will have experience of this. Confidentiality is taken rather more seriously, rather more critically in civil law jurisdictions like the one that you sit in. And I'm not...
Yes. Mr. Montague-Smith, an immediate difficulty I have is that this issue was raised by your clients in their skeleton argument and then abandoned at the hearing, and the court made an order on that basis. And so that argument has gone.
Well, right. Look, I wasn't at that hearing, but my understanding is that position was taken for the purposes of that hearing. I mean, one has to put in context what was going to happen next if the problem arose. So what we understood, my understanding is from the documents that I've seen, was that this was always going to be an issue for later. So I'll show you that. We recite a particular passage in our skeleton argument, and you can see it in our skeleton at paragraph 35, where we recite, I mean, you can find it in the bundle at page 1087. And so this is the skeleton argument of my learned friend in relation to all of this, and this was for that hearing. And paragraph 43 said, "There's no evidence that the claimants so much as asked for the production of documents that have been refused permission by anyone at Al-Khalij." So dealing with this particular issue, combined with the first claimant's less than forthcoming approach to the disclosure of the precise nature of the beneficial ownership of Al-Khalij, there are grounds upon which to draw an inference that if he asked for documents, they would be provided by Al-Khalij. And then 44, the appropriate course in the circumstances is for the court to make an order for the production of documents. If thereafter the claimants assert a lack of control, they will have to justify that position in document production statement, which is verified by a statement of truth. At that juncture, D1 can weigh up whether it is necessary to make an application for third-party production pursuant to RDC 2851. So that's the course that we understood would be taken, is my understanding of what happened at that hearing. And so it's not a question of the time has gone for this sort of thing to be debated. Now, and you may say, Saudi labour law, I'm not interested in it. I don't care whether or not your clients are going to be put on the horns of a dilemma as to whether or not they commit some sort of breach.
Well, the problem is, because of what happened, the court was never given the opportunity to exercise a discretion whether it should produce them or not. In a sense, if your position is right, the court has simply been excluded from the whole exercise. What has happened, if you're right, is that the claimants have come along and said, we're not going to argue this today. The court may make an order, and then if the court does make an order, it'll be for the claimants to decide whether they're going to produce the documents or not. And if they choose not to, then that's the end of it.
I understand. I'm not suggesting that the court has been excluded from considering the issue.
Well, it will be if you're right, isn't it?
No, because I'm asking Your Honour to consider the issue now, and consider the issue in this context. So that's really the point that I make. I'm not saying the court is excluded completely from determining the issue. It's a relevant factor, we say, to excuse any breach of these orders, and it goes to the question of whether or not there should be any consequences which follow from that. Now, the narrow question for Your Honour today, because it's not the broader question, which is should you draw adverse inferences, and if so, what inferences should you draw? The narrow question for today is should you grant a declaration, and the issue in relation to that, the issues in relation to that are. So I wanted to give you an explanation of why my clients are in this difficult position. Now, you may say that doesn't matter as to the question of breach.
Just before you go on to that, if I don't make the declaration, I think what you were saying is, in effect, that could be left to trial. And at the trial, at some point, I suppose, I would then be called upon to decide whether or not the claimants had failed to comply. And I don't know.
That's in the context of an application for adverse inferences is likely to be the way it would be put. So that's entirely the usual way one goes about it. One doesn't see applications for this sort at this stage.
Would it arise in this way, that in answer to a particular question from presumably in cross-examination of one of the claimants, defendant counsel would put a question to the claimants, and then at some stage when the answer comes, the defendant's counsel would then move on to you failed to produce certain documents, and perhaps, I'm not quite sure how they do it, but to put to the witness, I'm going to ask the court to draw a certain inference.
The way you would normally see, sorry, the way one would normally see it done. Sorry, I'm so sorry. I keep cutting across you, but I think the question is that how I see it happening?
Yeah.
So adverse inferences come up, frankly, more than the courts wish them to come up, and we'll get onto that in due course, because everybody says they can prove their case by adverse inferences, and the reality is somewhat different. What one has to do is firstly say what inferences you want to allege, and then you will give the justification for that. So you would say part of the justification, or maybe all of the justification for this particular inference that I want drawn, is that documents were ordered and were not produced. So you'd have there the factual allegations that are supporting, and then during the course of trial it would be put to the witness. Yes. You have that document, don't you? You've got that. You've got access to that document, and you haven't produced it, and you'd hear the explanation for the non-production. Altogether, you would be considering the question of, has there been a breach? And if there has been a breach, what's the justification, if any, for that breach? And in the light of all of that, do I accept that and all the other factors that go into the question of drawing adverse inferences, do I accept that an inference should be drawn? Yes. And what one doesn't have ordinarily is an application 7 days before trial, which lasts half a day, saying I want a declaration to this end. For instance, there's an example of that.
Yes, Mr. Montague-Smith, you might be able to help me with this. In the jurisdiction I come from originally, I've never come across a declaration of non-compliance with an order for disclosure, so it's not something I'm familiar with.
It looks like it's happened once in this court before, and my learned friend produces an example of it, but that example was in the context of orders being made. So it was essentially the court having to determine various issues for the purposes of a disclosure application.
Can I ask you, Mr. Montague-Smith, yes, are you familiar with such a process in England?
I've never seen it in England. I mean, it's not impossible that it's happened in England.
All right.
But what I would say is the court should certainly not be encouraging it, at least at this stage. Yeah. It might be that in the course of a specific disclosure application, the court needs to consider this question. So there might be an earlier stage where the court has to say, well, look, there's a contested dispute about whether or not there's a breach of the order, and that's relevant to my going on to making a further order.
Yes.
And having made that determination, one might say, and therefore I declare it, but it doesn't really add much because they've already decided it. And that's the context in which it happened in the previous case in this court. Yeah. At that earlier stage. I have personally, in fairly extensive experience of trials in this court, never seen somebody make an application at this stage for this sort of order. Now, why is it being made at this stage? And we do say that you're ought to have some degree of skepticism as to the purpose of this sort of thing, to make it all seem terribly complicated, and so we can spend half a day when we should all be preparing for cross-examination and all the rest of the preparation that's been required for this hearing to talk to Your Honour about this. But this is something, I mean, my learned friend gives some explanations for this. Amongst them, he says, oh, well, we had to translate documentation, and somehow that caused the delay from the 20th of May when they heard about this. But Your Honour will notice that this was addressed in the document production statement of the first and the second claimant. So, for example, if one looks at 1111, where it's expressed, where the problem is identified and explained, that is in English. They don't have to translate documents to see that this is an issue that's being taken. And then
what date was that?
20th of May. Mm. So if you go down to the page 1113, that's the 20th of May, 2025. So why on earth my own friend needs to wait 4 months to make this application to bring it on the week, 10 days before trial, is very difficult to understand. And the explanation that's been given, well, we needed to translate documents from Arabic, it can't be accurate. And it shouldn't be an explanation that's just being given to you in evidence by my learned friend. There's no actual evidence in relation to this. He's making submissions without evidence which appear to be inaccurate. And that, I'm afraid, is not an appropriate way to advance this position. So it's a disruptive application. We do say it would serve no useful purpose at this stage, because my learned friend's going to have to go through the process that I've described in any event. It's going to have to say in terms, these are the sanctions, these are the adverse inferences that we seek. I mean, you know, he says, oh, well, we had to ask some questions. The questions in that letter that he took you to, which is at page 1120, that letter was sent on the 7th of July. So that's 7 weeks later. They send a letter, and then there's a response, which is a month ago, or more than a month ago, 6 weeks ago. And yet we get this last minute application. So on the timing front, we just say, look, if you want to, just put the issue off to trial. Because it's all going to be, it's basically essentially one component of a much more complex question, which is, should you draw an adverse inference? And one, I would say again, this court should not, in my view, encourage this sort of application shortly before trial. And we do say also one has to step back and ask where this all goes, because my learned friend tried to put this all into context by talking about a claim for diversion of revenues. And I'll come back to that when we deal with the amendments that are being proposed. But my learned friend said lots of things, again, by way of submission, such as, oh, well, we've pleaded all out those contracts that were entered into by HI Dubai in the reply and defence to counterclaim. If you actually look at the reply and to the defence to the counterclaim, it identifies contracts which expired all in 2020, 2021. There is one that expired in March 2022. So there's no extant contract that is being alleged that was in place between Health Insights Dubai and a third party that is somehow matched by another contract between Al Khalij and these other entities that are being complained about. But all of that is part and parcel of the fact that there's just no explanation of how this works as a matter of law. How does it work as a matter of law? So my learned friend is basically saying there's some sort of breach of duty to him as shareholder, because he can't assert a claim on behalf of the second defendant. He's not in control of the second defendant. But even if it was to the second defendant, how is there a breach of duty? What duty is owed to the second defendant that has actually been breached as a result of Al Khalij entering into contracts with these third parties? There's no articulated claim in relation to that. No derivative claim is advanced. So if one thinks about it, say there was a contract between Al Khalij and Health Insights Dubai, and Health Insights Dubai was entitled to payment under that contract. But then Al Khalij went off and entered into another contract with Health Insights Egypt and starts paying to Health Insights Egypt. Well, that money isn't the property of Health Insights Dubai. The answer is only Health Insights Dubai has a money debt claim against Al Khalij. So it has to advance its debt claim against Al Khalij under contracts that it's entered into. Well, there are a number of problems with that. One of which is that Health Insights Dubai sued Al Khalij in Saudi Arabia and lost on the basis that there were no contracts in place. So that's problematic in the first place. And then one has to ask, well, how is it that the first and third defendants are entitled to make that claim on behalf of the second defendant anyway? It just doesn't, none of it makes any sense. None of it is explained in the pleadings. And my own friend takes lots and lots of little pleading points, which we say are misconceived, but fundamentally there's just a gaping hole in the middle of his case. He doesn't explain where the duty comes from. And if the only duties that he alleges are duties owed by the claimants, and this is where I started, as directors of the second defendant. But those are duties owed to the second defendant, number one. And necessarily, this is all. He took you to the pages of the financial statements, which show that he's arguing his case is based on things that happened in 2021 and 2022 and recorded in the financial statements, all at a time when he was in control of the company. So there's no allegation that the claimants caused Health Insights to get into contracts in the way that he alleged, by using their powers as directors of Health Insights. The allegation seems to be this more diffuse one, which is somehow they're under some sort of obligation to cause Al-Khalij to continue to enter into contracts with Health Insights and cause Al-Khalij to make payments under those contracts to Health Insights Dubai. But there's no articulated case as to how that obligation arises. So I think what we say is that there's going to be quite a lot of argument, I would have thought, if my learned friend does finally articulate some adverse inferences that he says Your Honour ought to draw. What one would expect those to be in his skeleton argument, which will appear on Monday, but he still hasn't told you what they are. And we'll have an argument at that stage about all of these matters. And you shouldn't be, we say, encouraging last-minute applications of this sort. That's all I have to say on those issues. Thank you.
Sorry, Your Honour, I think you're on mute.
You're right. Yes, briefly in reply, Mr. Doherty.
Yes, that was very much a response to an application that's not before the court. There's a long list of reasons why you're not in a position to draw adverse inferences now. That's not what this application is for. This application is pretty straightforward. There's an order of the court requiring disclosure of documents. Very little justification was given that provides an excuse for that non-disclosure. And so we seek a declaration that the order hasn't been complied with. The adverse inference.
Can I take up with you what I was putting to Mr. Montague-Smith? As I said, from the jurisdiction I come from, I've never come across such a declaration. Mr. Montague-Smith says it's not something he's familiar with in England. I don't see it specifically dealt with in the RDC in the rules. I know there's reference to one case in this court where such a declaration was made, but it's just not a process that I'm familiar with and which strikes me as having any particular utility apart from the matters Mr. Montague-Smith was referring to, but simply as a remedy in itself.
Yeah, well, I think to answer the question, does the court have the power? We would say yes. There's no reason why the court couldn't make a declaration in those sorts of terms. The court can make any sorts of declarations, and it's a pretty wide discretionary power that the court has. So
declarations are usually declarations of right. One doesn't ordinarily make a declaration that somebody has failed to comply with an order. That's usually dealt with either by a motion for contempt or for some subsequent order to compel something to be done. Again, I've never come across a declaration that somebody has failed to comply with an order, and indeed I've got some anxiety about how that fits in with possible contempt proceedings.
Well, I think there are different layers of what one would need to prove on a contempt application, because it's not necessarily as straightforward as being a breach of an order.
No.
One's also looking at things like intent and so on. The reason,
yes, but it would possibly close off the first question, that is, whether there has been compliance or not.
Yes, but that is a point that the court can quite rightly, and we say should close off, because there hasn't been compliance in this instance. It's clear that there hasn't been compliance, and as much as there's this attempt to conflate the issue to say, well, we saw this as being an issue for later. I don't know why it could possibly be seen as an issue for later. Your Honour asked at the beginning of the hearing, are you pursuing this point? And the answer was no. The point that was picked up on my skeleton argument referred to a completely different line of submission. So this was an extract which dealt with a case called Berkeley Square, and it's about whether the court should take a view that there are likely to be documents in someone's possession, custody, and control based on various factors, including whether they produced documents in the context of proceedings already on behalf of that entity. And really what it's dealing with is, for example, does a subsidiary have a right to parent documents, or does a parent have a right to a subsidiary's documents, and so on? And the point we made was simply to say that there is at least prima facie evidence following the Berkeley Square analysis that there was some arrangement in place through which the claimants were getting Al-Khalij documents, which they have disclosed in proceedings so far. So the court should draw the inference that they have such an arrangement in place for the purposes of actually going and asking for the production of documents. That's a different question to what was already in their control. So it's not this issue, this BVB issue, is not about what documents they could have asked for, which weren't already in their physical possession and custody. This was a question about whether they were entitled to then go to the board and ask for even more that they didn't already have. So it's a different issue. What's clear here and hasn't been disputed is that in the email accounts that they have access to, they have actual control of documents. The BVB case makes clear that it doesn't matter whether they only have them as agent or whether someone else has an interest in them. Those documents must be disclosed. So the starting point is we say, Your Honour, can reflect an order that they haven't complied with the order because they haven't complied with the order. There's not really any get out that the claimants have access to. When it then comes to what the court should do about it, one, we say you have the power to make a declaration. It's rare, we accept that, but it's an order which the DIFC court has made in the past in connection with orders for document production. So you can make it, given that it's a discretion as well. Is there utility in it? And we say, well, there is, because either it ultimately will compel compliance because the claimants don't want to turn up to trial thinking that there's a strong possibility of adverse inferences being made. Or two, if they don't comply, then they'll know what the likely consequences are. But I just wanted to make clear that we're not asking the court now to make those adverse inferences or asking you to formulate or asking us to formulate what the adverse inferences are, but it has real utility in fixing the parties' minds on, one, either disclosing the documents before trial, or two, fixing their minds on what the consequence of that failure is going to be.
Well, I think you've done that by your application. And I think the claimants are well aware that that's going to be an issue and that you will seek to have inferences drawn, whatever they might be.
And the final point I should say on that is, even if Your Honour had hesitance on a declaration, there's no reason that it couldn't be recorded in a recital, for example, that they have not complied with their obligations. But we say that it is pretty clear cut. No real explanation has been provided.
I think you're repeating now, Sir Doherty. You've made that point. All right. What's your next application?
Yes. A lot of the background that I've set out already, I should add, because I know that points are taken about speed, but I've set out the background so that I can rattle through the applications. We've broken it up, but just to give you some comfort on that front. The next application is joinder. So this is really to deal with a scenario in which the claimants just aren't going to disclose the documents, because we say that they are important documents. They're central to how the case is put by the defendants on the counterclaim. And I think points are taken that there's no derivative claim, there's no pleading out of how this claim fits into a legal framework, and we simply don't accept that. So there are two strands to it. One is relief in relation to transactions or arrangements entered into in which the claimants had a conflict which was undeclared, and which they're liable to account. And on the amended case, now that there's evidence of a specific arrangement in the 28th of August memorandum, is to have that arrangement set aside.
So which arrangement?
The 20th of August 2022. So that's the document which says, you previously paid Health Insights Dubai. We have no contract with Health Insights Dubai. Please now pay this money to Health Insights Egypt.
I'm still not clear what transaction you're seeking to set aside. I thought that saying, I might need to look at it more carefully, but I thought what you were telling me is that the memorandum says there is no contract with Egypt.
The memorandum is an arrangement through which contracts which renew annually are migrated from Health Insights Dubai to other Health Insights entities.
So the contracts, so is this it, that there were existing contracts
Yes.
with HI Dubai and others? Under those contracts, they renew annually unless terminated or something. Is that it?
Yes. And the contracts are with Health Insights Dubai. And we can see, and this will obviously be explored at trial, but you can see that the contracts that migrate, if I can put it that way, to these other entities are for the same hospitals. It's for the provision of the same services, which historically Health Insights Dubai has always booked its revenue for. So what you effectively have is the claimants taking control of the company and effectively moving the benefit of all of its contracts to something else, which they have control over, and which the first defendant was cut out of. So we say that those are transactions or arrangements. So the two strands to that, one is the cancellation of previous debts which had accrued. So there's an arrangement to write off those debts. And two, there is the movement of the benefit of those contracts.
Well, that's what I'm trying to get a bit more specific about, movement of those contracts. If it was the case that the previous contracts had expired and the claimants caused new contracts to be entered into between different parties, that of itself would not involve a transaction of HI Dubai, which could be set aside, would it? We'd have to look for some transaction to which HI Dubai was a party.
Well, it can be transactions or it can be arrangements. So transactions or arrangements, and the latter being broadly defined, and we'll have submissions about that at trial.
Right.
But the central point is that there is evidence which we say the 20th of August memorandum, which is what has been termed in the amended pleading, is itself such an arrangement, or it records the existence of such an arrangement. But that's not the only aspect to the pleaded case, because there's also the aspect of the case which is the minority shareholder relief. So it's the unfair prejudice, which is premised on pleaded breaches of the claimant's obligations to Health Insights Dubai's directors to act honestly in good faith in the best interests of the company, to exercise powers for which they're conferred, and so on. So those are duties that are set out in the private companies regulations.
What relief do you seek if you make out that there has been unfair prejudice?
So amongst, this is at paragraph 99 of the unamended pleading, if I can put it that way.
What pages do you know?
That's bottom of page 45. But amongst the relief sought, which feeds into the joinder application, is orders for an account or to pay damages to the second defendant, or alternatively authorising proceedings to be brought and pursued in the name of the second defendant against both the claimants but also the entities who are contracting. So Al-Khalij at E, and then the amended pleadings, because of the documents that have been discovered, adds Health Insights Egypt and Health Insights Saudi. So
ordinarily, when it's established that the conduct of a party has been unfairly prejudicial, that leads to some orders being made, such as that one party buy out the shares of the other, or something be done. But this just seems to be left at the stage of concluding that there's been unfairly prejudicial conduct and no specific relief sought. Is that right?
The range of orders that the court can make on a claim like that is broad. It's not confined to buyer and so on. And so the part of the relief that the court can order is permitting claims to be brought on behalf of the second defendant to recover sums that are due to it. So it would, in effect, it would permit a minority shareholder who has been unfairly prejudiced to advance the company's interests in proceedings which would allow monies that have been diverted to be put back into the company so they can then enjoy the benefit of them as a shareholder.
And where's that order that's sought?
So that's 99D relates to proceedings by the second defendant against the claimants in respect of their breaches of duties.
I was looking in the prayer for relief, which says, and the defendant seeks. And I see that there's not an order there seeking that you bring some sort of derivative action, is there?
It's Roman numeral 4. It's just that it cross-refers.
Oh, outlining, I see. I've got to go back to 96 to see that. Okay.
Yeah.
So 90. Oh.
I think it might be that appears to be a typographical area, but the relief is 99. The first defendant will seek orders A declaring that.
Okay. I see.
So that's the framework of the case and how the central allegations fit together. It's not difficult to see there's a fallout between shareholders and income that used to go to the company, which they all owned, is now going to different entities. The documents which are sought go to that wrongdoing. So it's to show what.
Now, which application are you on now, Mr. Doherty?
So that's it's the joinder application.
Joinder, yes, okay. So is the purpose of joinder to get the documents from the additional parties?
Yes, and we say that that's really what triggered it. I think that there
well,
is
not only what triggered it, is that the sole purpose of joining them?
That's the reason we're making the application. I think what we would say is there may have been other grounds before that would have arguably entitled the court to make the order, but it's really the disclosure issue which is what pushes it over the edge.
And you don't seek any relief against them. It's simply it is a step towards getting an order for production of documents by them. Is that right?
Getting the documents is why we are making the application. There is, I think, an argument that it directly affects the additional parties anyway, because, for example, the relief sought.
But that's always been the case, and you never.
Yes, that's why I say it's the trigger.
So that's the purpose for it.
Yes.
Yeah. All right.
Now so there's two strands that. Sorry, yes, Your Honour.
So I'm going to take a break in a minute.
Yes.
It seems to me the obvious point about it is this, isn't it? If the, not sure, I think you call them additional parties. If the additional parties are joined and orders are made against them for the production of documents, that inevitably leads to the trial being adjourned. Is that correct?
Yes, I think that's likely. We would also say that's
more than likely, isn't it? It's I could not join additional parties who are located. Where are they located? Egypt, outside the jurisdiction anyway.
Yes.
Join additional parties, make orders that they produce documents 11 days before a trial, and proceed with the trial. That simply, it's not just not likely, that just couldn't be done, could it?
Well, it's not likely. Yes, could it be done? I suppose the point we would make is that
not in the exercise of power judicially.
Yes, I think the practical point is that the entities are controlled by the claimants, and the documents sought are not actually that hard to get hold of because they're financial statements, bank statements, and so on. So they should be accessible. And the additional parties have been aligned parties, if I can put it that way, with the claimants in other jurisdictions, i.e. the claimants have advanced cases on their behalf. So there's every expectation, one would see that in much the same way as the first and third defendant have joined representation in these proceedings, that would be certainly a highly possible consequence of making the order. But yes, I mean, our primary position is that the documents are important. They go directly to the counterclaim that's being put, and the test of desirability is met because without those documents, the court is being shown a small fraction of what's actually going on here in respect of the claim.
Okay, thank you for answering that point. It's now 1 o'clock Dubai time. We'll take a break. How long should it be? Half an hour?
With the court hands, I really don't mind how long it is. It can be 5 minutes, it can be 15, it can be 20, whatever.
I think the court staff might have something to say about that, but subject to them.
I think half an hour. It's been a little mean to the court staff, but I think half an hour gives them a chance. So we will. It's now 1:05. We'll resume at 1:35.
Thank you.
All right, Mr. Doherty, you ready to continue?
Yes.
Thank you.
So you're all familiar with the test. It's threshold of desirability. Is it desirable for the court to have the parties so it can resolve all the matters in dispute, or if there's an issue between the new party and an existing party connected to matters in dispute proceedings, is it desirable to add them to resolve that issues? We say you can go through either of those gateways. One can actually follow through similar reasoning to what Your Honour has applied already in this case. So first, do the additional parties have a direct interest? Yes, because the pleaded issues concern Al-Khalij refraining from making payments to Health Insights Dubai that it had previously over the course of many years in connection with its use and rollout of Medica Cloud Care. Al-Khalij acted in that way on the instructions of the claimants. Al-Khalij continues to utilise MCC, Medica Cloud Care, without paying Health Insights Dubai. It continues to generate considerable revenue from that activity, and the benefit of those revenues are now going to Health Insights Egypt and Saudi, who are not entities that are permitted to license MCC to Al-Khalij in that way. And in any event, steps have been taken to write off Al-Khalij's historic debts to Health Insights Dubai. So in other words, the counterclaim asserts that the basis on which Al-Khalij, Health Insights Egypt and Health Insights Saudi are now interacting, as shown by the bank statements I took you to earlier, is unlawful because they are arrangements entered into by claimants which breach Article 79 of the Private Companies Regulations, or they're breaches of their duties as directors of the second defendant, which relates to the claim for minority shareholder relief. The amended defence and counterclaim in that context then refers to specific transactions that have been entered into, and it refers to the 20th of August memorandum, which is an arrangement, we say, writing off debts and migrating the benefit of those contracts over to other entities. The second point we say is that the additional parties are directly affected in a number of respects. One, the counterclaim seeks injunctive relief with respect to the claimant's steps or continued steps to write off debts and the setting aside of those arrangements. So that would have an effect on Al-Khalij as the paying party, but also Health Insights Egypt and Saudi as the recipients of the money. We are also seeking permission to pursue derivative claims against the additional parties. So they're affected on that basis as well. Third, will the absence of the parties prevent the court from fully resolving the dispute? We say also yes. I mean, adverse inferences are one thing, but we say it's a direct consequence of the claimant's decision to try and shield themselves behind the Al-Khalij boards that highly relevant material is not going to be before the court, and that material goes to the alleged breaches. And we say that if there wasn't already sufficient grounds for allowing a joinder application, the failure to disclose is something that tips the balance. And I've given you the reasons why the evidence at the core of this claim relates to contracts between Al-Khalij and the various healthcare providers and how they've continued, how Al-Khalij is generating income, and then what's happening with that income, which used to go to Health Insights Dubai, but now appears to be going to one or more of the Saudi entity or the Egyptian entity, all to the detriment of Health Insights Dubai. And so we say that joinder would give the court the proper opportunity to consider the full extent of the claimant's alleged wrongdoing, and not just the snapshots that one can ascertain from the limited disclosure provided. And then that ties into the fourth point, which is, does it help the court adjudicate more effectively and completely? Yes, because the court's then in a position to deal with all of the issues and to address all of the evidence, rather than it being a case that more wrongdoing comes to light later that has to come back before the court. And yes, because it would ensure that the additional parties comply with and are also bound by any orders made by the court, for example, restraining the claimant's conduct in the claim for an injunction. So we say that the grounds for joinder are made out. I don't know whether points are taken on surface of the application, but we also say that the court can proceed on the basis that it's presented to you today. The general managers or managing directors of the additional parties are the claimants. They're aware of the application because it's been served on them to 2 email addresses on their behalf each. And the application's been sent by post. I think there's confirmed receipt now by Al-Khalij that has in fact been served. But Your Honour will also recall the basis on which the third defendant was joined to these proceedings was pursuant to an oral application made at a hearing, which was sufficient notice because Mr. Shehata was a director and shareholder and was present at that hearing. So the court has the power to grant the application, even if it didn't. There's a power that the court has to either permit alternative service or to dispense with it entirely. And the good reasons here are simply that the persons controlling the companies already know about the application. They've already taken a position on the application and are making arguments about why Your Honour shouldn't grant it. And we say that there's urgency in proceeding in this way. I don't know if it would just assist. It'll take me about a minute to deal with the non-party disclosure, because really it's just an application in the alternative to this. The basis upon which the application is made is what I've already set out, which is when one looks at the test for non-party disclosure, it's are documents likely to support the case of the applicant or adversely affect one of the other parties to proceedings. We say that you've already got not only an inference that it will undermine the claimant's case based on their approach to disclosure, but also I've shown you some of the prima facie evidence. So, for example, the bank statements which show these payments being made to other entities. So there's a substantive basis to think that disclosure of what's being requested is likely to support the defendant's case and adversely affect the claimant. So the test is made out. I can see that it would be open to Your Honour to take a view that this was a neater solution. I think really the only question that would arise then is one of cost. So there's a presumption in non-party disclosure applications that the requesting party will cover the cost, but ultimately it remains a question for the court's discretion, which we say is wide, and in a case like this is one ought to be displaced because the additional parties are controlled by the claimants. They're not arm's length third parties who just so happen to hold relevant documents, and so should be provided some protection against the inconvenience of searching for those documents in a case that they otherwise don't have an interest in. The application is only being made because the claimants haven't complied with their own disclosure obligations, and the additional parties are also adverse to the defendants and aligned with the claimants in various other proceedings in other jurisdictions. So if that was the form of order that Your Honour made, we would say that the proper order on costs would be costs in the case or costs reserved, particularly given that trial will follow. And then the next point I have to make, Your Honour, about the amended defence and counterclaim, but it may be that you want to pause there.
Well, you haven't dealt with what I think is the biggest problem you've got, the timing, that you bring this application on the eve of the trial with no apparent explanation for the delay.
Well, the primary explanation for the delay, I think I've already said out, Your Honour, but really it was the...
Well, just remind me what it is.
Well, this was dealt with in some fairly lengthy correspondence sent at the beginning of July.
Let's go right back. So far as the additional parties being proper or necessary parties, nothing has changed since you filed your defence in August of last year. The other matter which you rely upon is the failure of the claimants to produce documents. That occurred in May of this year. So you have, at the very least, delayed 3 months in bringing the application, and now we are 11 days before trial, in a circumstance where if I grant either of the applications you seek, either joinder or alternatively non-party discovery, that will inevitably result in the trial being adjourned and postponed. In those circumstances, you must have a proper and adequate explanation for your delay. And as say, you've had 3 months, or sorry, you delayed 3 months in bringing the application. I've not yet heard an explanation for that.
Well, Your Honour, you'll recall in the document production statement, what the claimants say isn't we're not disclosing our college documents. They say we have disclosed documents that were in our possession, custody and control in our capacity as directors and shareholders of Health Insights Egypt and Health Insights Saudi Arabia. Now, it's reasonable in my submission for a party to take a view on what documents have been disclosed before asserting the documents haven't been disclosed. And the practical reality of that was that although the documents were disclosed, as I say, a large proportion, 60%, the majority, were in Arabic. They needed to be translated. That is a process which took time. Once the documents were in hand and once everything had been reviewed, a letter was prepared explaining the deficiencies in disclosure. Now, obviously, that process in itself takes...
Just go back a step. When was the trial date set?
The CMCs, I presume, would be October 24.
October of 24. So, on October 24, the trial date was set. You have presumably always thought these documents, if these documents are reasonably necessary, then you have known since October of 24 that they were reasonably necessary. You knew in May of 25 that the claimants were not producing them. And I'm still really waiting to hear the explanation for the delay.
Well, I think the first point is that it's difficult to say that we knew that they weren't producing them, because one had to look at what was actually produced in order to see what was there and what wasn't, and what had been withheld from disclosure. What the claimants had said in their document production statement is, we're not disclosing documents that the board won't allow us to produce, but what they said is, if we have documents that we held in another capacity, i.e. as a director or shareholder of Health Insights Egypt or Health Insights Saudi, then we'd produce those. In order to take a view of what those documents were, the translations had to be carried out, the documents had to be reviewed, in cases like this, things can't turn on a dime. There has to be a period of time allowed for the review of those documents. And if a view is taken that disclosure is inadequate, then it needs to be properly set out, which is why a detailed letter was put together itemizing the non-compliance. That was sent at the beginning of July. The indication was that the claimants were going to substantively respond to it. And given the nature of the objections taken, i.e. an argument that was put before Your Honour at the document production hearing and then dropped, we considered that there was a pretty strong grounds to suggest that these documents were going to be produced, or that some effort was going to be made to actually produce some categories of documents. And in fact,
But you were told in the May disclosure statement what they were producing, that is the documents that they then produced, and then they told you that there were other documents they were not producing because of the not getting permission from the board. So that was it.
Wasn't it, there was no itemized list of documents which had been sought from the board, which we were told were not going to be produced. In order to work out what was there and what wasn't there, you had to review the totality of the disclosure. Because it's not that there were no Al-Khalij documents, or they were saying we're not going to provide a single document in response to this. They were saying if they've come into our custody in this capacity, we'll provide it.
In a circumstance where the trial date had been set in October and was to take place in September, the onus was on you, if it was necessary for you to review the documents before deciding upon making an application, the onus was on you to do that quickly, not to take 3 months. That's my difficulty, Mr. Doherty.
Well, I didn't think that we accepted it took 3 months to review the documents. What happened was that the documents were translated and reviewed, and then a letter was sent asking for disclosure of the missing material. And then the process of engagement thereafter was, we'll provide you with a substantive response. We expect it will narrow the issues.
Right.
That's what the court was told at the PTR. But what in fact comes a month later is the claimant saying, well, we're not going to give you these documents. And at that point in time, the view was taken that, well, this just needs to progress, and the application needs to be made on that basis. And then it was progressed. But the background to actually obtaining and reviewing the documents is one that we say reflects the practical realities in litigation like this, particularly where you've got processes to go through before you can even undertake a review. So that's translating documents, actually reviewing them. You know, the number of relevant documents disclosed was considerably under what ought to have been, we say, but there were many other documents disclosed in these proceedings which had to be reviewed, which were of little relevance, but one has to actually comb through the material before they can form that kind of a view. And ultimately, and we'll come on to this in the context of the adjournment application anyway, but this is one of a number of strands which have come before Your Honour, which leave in effect work to be done. And we say that's not only on our application, we say it's on the claimant's applications as well, where there are unanswered issues introduced into the case which haven't been dealt with properly in evidence, and no proper opportunity has been given. And it all feeds into the same issue, which is there are multiple grounds on which the trial date, I have to say, unfortunately, from the defendant's perspective, because the defendant has what it says are extremely serious allegations with a clear documentary record of wrongdoing on the part of the claimants. It wants this trial to be dealt with as much as the claimants do, and however much my own friend might take issue with that. But the reality is that the overarching consideration for the court is fairness and doing justice between the parties as opposed to convenience. And so if the just disposal of the trial requires disclosure of documents which have otherwise not been disclosed in breach of court order, then the position is that the document should be disclosed. And if the trial date's lost, then that's just a consequence of that.
All right, thank you. Mr. Montague-Smith.
Thank you, Your Honour.
Joinder and non-party disclosure is the...
Well, there's also the service application, which my learned friend hasn't actually referred to. I mean, essentially the way he deals with it is he sort of says, well, Al-Khalij and the other two new parties are the same, so you don't really have to worry about that. But they're not. They're separate entities, and they need to be given the opportunity. They need to be served with documents, and they need to be given the opportunity to respond. And they might well have things to say about jurisdiction. I am not here to act on behalf of Al-Khalij or HI Saudi or HI Egypt. What I do is largely make submissions from the perspective of my clients, who are the claimants, who are individuals whose trial will be impacted by the sorts of orders. So I'll make those submissions. I do have some observations to make about the cogency of what's actually now being put forward and how that might all work. But I'm not here to argue the application. And in my submission, it would be quite wrong actually to for example, hear and decide an application for non-party disclosure orders against a third party that hasn't actually yet been served. Now, in relation to service, my own friend was pretty vague about this. He says it's been served on the claimants by email. Well, that's not an appropriate mechanism. That's not actually a viable mechanism of service of either of the other two parties, HI Egypt or HI Saudi Arabia. He does say, well, it's been put in the post. I've not yet received confirmation that it's been received by those two parties. It does appear that the documents have been couriered to Al-Khalij. And so I think we'd accept that happened, albeit that happened on Monday, and it's now Thursday. So that's 2 clear days. So this is still a without notice application in relation to them. Now, just dealing discreetly with the question of alternative service, because there is an application for an order for alternative service. I mean, at the moment, there's a bit of doubt about quite what's happening in relation to service. It would have helped if there was a certificate of service, which would be the ordinary way to deal with that, but we don't have anything like that from the parties to check whether or not actually the steps for service have been taken properly in relation to the other two entities. But anyway, what we would say is that at the moment, there doesn't appear to be any purpose in the order that's sought for alternative service, because my learned friend's position is that all of the defendants have now been served. If that is right, then you don't need an order for alternative service. We accept it in relation to Al-Khalij, but they still have time to respond. This is a fresh claim for them by a court that doesn't sit in Saudi Arabia, and it's serving court documents from the DIFC and the Saudi company. But if they're right, then the steps that they have taken will amount to service, and if they're wrong, well, then what they're telling the court about that must be wrong, and there's no excuse for not having served by now. And so, I mean, the justification that was advanced in the application for alternative service doesn't seem to be pressed now. The justification was that it was necessary, and I quote, to avoid any attempts to evade or dispute service. But there's no evidence to support the proposition that service would be evaded. In truth, these sort of orders that have been floated, dispensing with service, alternative service, they're really to get over the fact that they needed this to come on fast, and it all needs to be dealt with before trial or immediately. But that is a result of the way that they have handled this case. The document production statements, as Your Honour has pointed out, are dated 20th of May. They're very clear as to the position that was being taken. And I showed Your Honour the skeleton argument, which suggested that if that was going to be taken the position, then they would have to consider making third-party disclosure applications. My own friend, again, just gives evidence, which we don't know. He says, well, everything had to be translated and it all took some time. He doesn't even tell you how long. What we do know is he says that the translations took place in time for the witness statements, the first round of witness statements, which were served on the 15th of July. So presumably they were available a couple of weeks before then. I don't know. We just don't know. My own friend is just making assertions which are unsupported. And again, with all respect to him, that is no way to be bringing on an application so close to trial, which the effect he candidly accepts is that we lose the trial. So as to the discrete issues of service, we say really the justification for any kind of alternative order seems to be to expedite, but that really is a feature of my learned friends or his client's approach to the applications, and it's not a good reason, which is what's required. Now, as to the joinder applications, I mean, we do say it's quite remarkable. I mean, essentially 6 days before trial, they sort of want to reshape the litigation and bring in these 3 new parties. Now, it's just very unclear to me why they want to do that, other than the non-party disclosure application. I think we make 2 threshold submissions. First, it's just too late to try to do all this stuff. And second, this court should not be making any orders against those third parties on an ex parte basis, on a basis which they have not had the proper opportunity to respond to and be heard on. So as to the first, I mean, I think I won't labour this, but there just is no justification for bringing this so late. The proceedings have been on for years, and there's this just late scramble which we say should just not be permitted. I mean, in principle, given that the pleadings are against those other parties, there would need to be an opportunity for those other parties to potentially respond to the pleadings. So, you know, but they'd also be entitled to a bit of time to have a think about questions like jurisdiction. What jurisdiction does this court really have? Because this court's jurisdiction is based on a jurisdiction agreement between the shareholders of a company, and they would be entitled to take a view on that, and subject to that, file pleadings. So if, as appears to be the case, my own friend's claim or proposed amended claim is to set aside agreements which have been entered into by HI Dubai, that seems to be what he's saying, agreements to cancel existing contracts, agreements to write off debts, and that's the new claim that's being introduced, then the third parties who are affected by those so-called agreements would need an opportunity to plead to those, just as the third defendant has had an opportunity to plead to the allegations against it. And then after that, they would have entitlement to lead evidence and seek documents and all the rest of it. And effectively, you're just restarting the procedural timetable. As to the second point, the other parties ought to have an opportunity to be heard, not just on jurisdiction, but we say there are any number of problems with the proposed claim that would be incumbent on my learned friend to show that there's a real prospect of success against them in relation to that. And part of the problem is, if one actually looks, I think Yura has this, if one looks at the proposed pleading at 774, which sets out the relief that's sought, there is no relief sought against these new parties, as far as I can tell. And so, I mean, one would not ordinarily join the third party for the purposes of disclosure and then plead out a claim against them. One would not normally do it that way. One would normally have an application against them independently, or perhaps an application in these proceedings against them. But one way or another, one wouldn't plead a substantive claim against them. But that does somehow seem to be what is sort of, in a slightly kind of protean way, being advanced. So you were shown that the sort of substance of the allegations themselves, and they're at paragraph, if one goes to 763. Now, I'll take you through just a couple of things that we say on this. And what I would say is that obviously my learned friend's going to be addressing you on proposed amendments insofar as they affect the claimants. At the moment, we're just dealing with the proposed claim insofar as it affects the new parties. And obviously there are submissions to be made that cut across both of them, but on both the obligation on him is to show that there is a real prospect at the outset on these sorts of things. I'll come on to the late pleading and the effect of the trial, if I may, during the course of my submissions in relation to the amendments themselves. But essentially, what we understand this to be, my learned friend says in his skeleton argument, this is just a development of a case that was already being advanced, but it's really not, because what you see is it's paragraph 66. They say the complaint is that the first claimant knowingly caused Albulaihid to refrain from making payments in respect of orders from which Albulaihid benefited. So that's a claim about an existing debt which is said to have arisen, owed by Albulaihid to Health Insights Dubai. And that is about the first claimant's actions in his capacity as a director of Albulaihid, caused Albulaihid. So that's the reason why we sort of put a line through that. The submission will be, well, that's got nothing to do with any duties that might be owed. That can't be, logically, a breach of any duty owed. But then it goes on. And what it says is, in the most broad way possible, it refers to this memorandum, and then it says in which it was agreed and or which recorded the existence of an agreement, writing off Albulaihid's debts and or assigning the second defendant's contractual entitlements from Albulaihid to the second additional party. So there's an allegation there about writing off of debts, which is said to flow from the memorandum. The allegation is there's some other agreement, or the memorandum is an agreement. The memorandum just simply says, we confirm that there is no formal agreement between your esteemed company and Health Insights Dubai. Now, this relates to a long-standing dispute as to who had the contractual relationship with Albulaihid. Was it Health Insights Egypt or was it Health Insights Dubai? And it's a bit of a sideshow, really. But we say it was Health Insights Egypt, and that has been confirmed by a Saudi court when Health Insights Dubai, caused by Mr. Shehata, sued Albulaihid, and it was found there's no contractual relationship. But there's nothing in that. That's all historical. That's all well known. There's nothing new to the defendants in relation to that. What's new is this memorandum, and it's leveraged to say, well, there's been some writing off of debts and assignment of contracts, but there's no explanation of what those debts are. There's no explanation of what those contracts are. And there's just no pleading of what the contractual relationships were that were assigned. And again, I'm afraid my learned friend's submissions in response to questioning from you are giving evidence and false. What he told you asked the question, because this relates to the contracts that he says are pleaded in the reply and defence to counterclaim. Now, all of those contracts had ended by March 2022. That's the pleading that you will find in the reply and defence to counterclaim. And the allegations here are in, you'll see the contracts that are referred to below are at paragraph 71. None of those relate to that period. So they all post-date the March 22 termination of the contracts that are in fact pleaded. So how does he fill that gap? You asked him the question, oh, well, are you saying therefore that those contracts automatically renewed? And the answer was yes, and then carry on. But A, that is nowhere pleaded. There's no case asserted in relation to that. And B, it is factually false. And you can see it because at page 1783, you can see how contracts were extended. That is an example of it. It's a translation, but it's sorry, it's not a translation, it's the original. It's an example of an extension purchase order. You can see that from PO ALK 2815 extension, and then it refers to the Medica Plus maintenance contract and then places an order for its extension for a period for $5 million. So the way it worked is that you had contracts which were in place with Health Insights Dubai, and they did not automatically renewed. A purchase order had to be placed. And so the real complaint here appears to be that no purchase order was placed by Albulaihid to extend to effectively renew contracts that were in place. So there's a number of problems here, because you've got no explanation of any of this. If we go back to 763, you've just got this bare assertion in the second line of the amendment. Memorandum was issued in which it was agreed and/or which recorded the existence of an agreement, first writing off debts and/or assigning the second defendant's contractual entitlements. So what you would need there would be, I mean, on the way it's put is that actually incorporates an allegation of the assignment of contracts. That's what you've been told today, but that's not actually what it says. And so my learned friend is basically trying to kind of piece together on the fly a pleading, which is nowhere to be seen, and certainly isn't before your honour today. So that there isn't a coherent allegation in relation to all of these contracts that could be made against these third parties. And when it comes to sort of really what was the thrust of the original allegation, which was how we'd understood the new one, which is that the claimant knowingly caused Albulaihid to refrain from making payments, was that this was a new allegation of that causing Albulaihid to refrain from issuing new purchase orders. And again, that is legally incoherent. Where's the duty on the claimants to cause Albulaihid to place new orders? That's not pleaded out. So there's no coherent, articulated case in relation to these points. And then if one goes down to 71, you've got this allegation that Albulaihid has obtained the continued benefit of services supplied by the second defendant in the sum of at least $6.4 million. And it is very unclear what that even means. Is it saying that there's an ongoing contract? I mean, ultimately, presumably it's saying there's a debt that's owed, but it's very difficult to understand, because then it goes and pleads out contracts with third parties who are not Health Insights Dubai, and therefore pursuant to which no debts could arise. So again, the complaint seems to be you're contracting with other people, you're not contracting with us. But where's the obligation to contract on Albulaihid and so on? And so ultimately, these are claims which, and the other points in relation to this is that it's said, well, this isn't a derivative claim, but it's an unfair prejudice claim. And in the course of that, you can ask the court for permission to run a derivative claim. But this is, apparently, it seems to be the derivative claim. There's a number of short points that should be made in relation to it anyway. On top of that and in particular, unfair prejudice petitions have to be made to the DDA, not to the court. It says that in terms in the regulations. I mean, that's a point of law that we would raise, that we have raised in these proceedings in relation to the claim against us. But it's a point, no doubt, that these new parties would also wish to raise if those allegations are being made against them. B, as I've said, the Saudi court has dismissed the allegation that the contracts were with Health Insights Dubai. There's no dispute about that. And C, fundamentally, the allegation of diverting, you see that at 73A, where, I mean, essentially that's already there, but they now plead it out as if the third, the Albulaihid is to be a party. I mean, the allegation of diverting essentially must be predicated on some entitlement to receive that revenue, not some other revenue. And it's either a debt claim, in which case they still have that debt claim against Albulaihid, but it's not them, it's the second defendant, or there's some proprietary basis for the claim, which is again unarticulated. So we do say that the new allegations that are being run are not articulated with any kind of adequacy. And I'll come back to particularly how we deal with the amendments in a moment. But what we say is that for the purposes of joinder, there's no need to join them to the pleadings, if I can put it like that. For the purposes of the non-party disclosure application, I'm not really interested in that. My clients aren't. But we do say it shouldn't be allowed to disrupt the trial. It could have been made much earlier. And thirdly, we say that you really shouldn't contemplate making any sort of orders against these parties without hearing from them first. That's really where we get to on that. And I'll make the rest of my points in relation to the amendments. Unless you have any questions for me. Oh, you're on mute, you're on apologies.
Yes, thank you. In response, Mr. Doherty.
Yes, I think a lot of what was said is about the amendments, so I can come on and deal with the amendments. I think there was one point taken is that the court can't make an order like this without a hearing. Respectfully, say that's a bit rich, given the circumstances surrounding the third defendant's joinder in this case, which was made on an oral application at a hearing without notice to D3. The point there was that Mr. Shehata was attending the hearing, and so the conclusion in respect of notice and service was that was sufficient to make the order. And we've had arguments about that. The reason we have set out in evidence the steps that have been taken to provide by email and by post the notification of this application isn't to say we were relying on the service having been affected under the rules. What we're saying is the parties have actual notice of it. The first claimant is the managing director of Al-Khalij. The second and the first and second claimants are both directors of Health Insights Egypt and Health Insights Saudi. So it's by comparative reasoning, these parties have as much, if not more, notice than the third defendant had when it was joined. So that's all I have to say on service. I think most of what the claimants have to say about the joinder application just now related to pleadings, which respectively we say entirely mischaracterize the nature of the defendant's pleaded case. One has to not skirt around some of the core issues in dispute in this case and how it is said that entitlements under these contracts actually arose in the first place. And in some senses, this feeds into the adjournment application, but it probably won't be lost on Your Honour that one of the core issues in dispute is who owns the economic rights in Medica Cloud Care, MCC. Now, the positive case is set out. This is at 760. You can see the section which positively asserts how the rights in MCC were created, how they are held, and what significance that has when it comes to the contracting activity of all of the various different entities. So, but in effect, the first defendant's position is he is the author pursuant to a series of licensing agreements. Other Health Insights entities are permitted to distribute MCC in particular regions. So a time-limited license is given to the third defendant, and you see at paragraph 54 reference to partner reseller certification, which is what enables the second defendant to distribute MCC within Saudi Arabia in the UAE. And the basis upon which the second defendant can therefore generate revenue and has the economic rights to actually trade in that particular product. That's an important issue, and that's one of the reasons why, as you can see, it's in the evidence, all of the historic income, both for the rollout of Medica Plus, but also Medica Cloud Care with Al-Khalij, has always been income that was generated to the benefit of Health Insights to buy. And that's why in the reply, which my learned friend referred to, you have reference to those pre-existing contracts for rolling out that product. And one element of the defendant's pleaded case isn't only about what happens to these contracts in the future, but it's about accrued debts up to a point in the past. So the pleaded case is that there are purchase orders with Health Insights Dubai, which by around $5 million exceed the amounts that Al Khalij have actually paid. So there's an outstanding amount for those contracts, which my learned friend says came to expire. But there's still an outstanding amount of $5 million which hasn't been paid to Health Insights Dubai. And the basis on which the Article 79 claim is pursued is to say that as directors of Health Insights Dubai, the claimants have taken steps to write off its debts to Al Khalij. That was the originally pleaded case, and that's accentuated by the amendments which refer to that 28th of August memorandum. So that's the pleading at page 763. So here are accrued debts of 5 million. Those are all owed to Health Insights Dubai. And what happens is the claimants calls an arrangement to be entered into with Al Khalij, and that's in their capacity as directors of the second defendant, which have the effect of writing off those debts, and two, telling Al Khalij that all of its future payments should be made to other entities. And the reason that isn't permissible, and the reason that that is a breach, we say, of both Article 79, but also of their duties to the second defendant, is because it's the second defendant who is entitled to enjoy the benefit of the rights.
Do you plead that? Do you plead that there's a breach of somebody's duties to the second defendant?
Yes.
Where's that?
This is within the section dealing with the unfair prejudice claim. So the existence of the duties is pleaded in paragraph 88. That's page 770.
770. Okay.
And then breach of the duties is pleaded in paragraph 96. That's page 772.
Right.
So, like I say, there are two aspects of the case. One, there's the failure to declare an interest, but there's also a broader allegation of breach of director's duties. And it's not difficult to see why, if you are a director of a company who has historically enjoyed the benefit of income in respect of a set of contracts, and you subsequently take steps to divert those contracts to other entities which you control, and so deprive the company of which you're a director of the benefit, that would be a breach of your obligations as a director. And that's a perfectly pleaded out basis on which the first defendant's entitled to bring his petition for unfair prejudice. So there's no incoherence in the claim. It's pretty clear what's being alleged. There were contracts previously with Health Insights Dubai. Those have been stopped. The accrued debts have been written off, and the benefit of the contracts has been diverted to other entities in conflict with the claimant's obligations to the second defendant. And the bits of the pleadings that have been introduced all relate to that case, which has been pleaded from the outset. It's just that these documents clarify precisely what it is that we're relying upon. I should add that it was preempted that at the point in time the original pleadings were drafted, we didn't have full disclosure, so we didn't know precisely the nature of what the interaction and the transactions between these three entities, Al Khalij, Health Insights Egypt, and Health Insights Saudi was. We can start to piece it together from things like the bank statements, from the financial statements, but obviously, and again, this feeds into the points I've made about disclosure. If one has only shown a small piece of what's going on, it's difficult for the claimants to criticise us for not pleading out the specific contracts that were entered into. We've asked for disclosure of those documents from Al Khalij and from Health Insights and from HI Saudi. and we haven't provided them. And that's obviously going to feed into what adverse inferences we're going to invite the court to make in due course. But the point is that based on even the evidence that is available to Your Honour, there's clearly an arguable case of wrongdoing by the claimants in their capacities as directors of Health Insights Dubai. These pleaded paragraphs are plainly arguable examples of them acting in conflict with the interests of the company, but also in breach of their duties as directors. Because here, what is being said is stop paying Health Insights Dubai, pay this money to Health Insights Egypt instead. And that's what you should continue to do going forward. And the further pleading down at paragraph 71 refers to specific orders which were purportedly made to the benefit of both Health Insights Egypt and Health Insights Saudi. And again, there are alternative ways that one can analyze those, but either Health Insights Egypt and Health Insights Saudi Arabia have acquired from Health Insights Dubai the benefit of these contracts which historically had been entered into by Health Insights Dubai, in which case it's a transaction arrangement which stands to be set aside, or more flatly, it's entities which are competing with Health Insights Dubai entering into contracts which they're not entitled to enter into because they don't enjoy the economic rights to market and distribute Medica Cloud Care. But in either event, consistent with the originally pleaded case that they're diverting revenue streams that previously were enjoyed by Health Insights Dubai to other entities which they control. These are just the specific examples of those. The amendments, we say, are both consistent with what's already the pleaded case. It's just fleshing it out by reference to some of the documents that have been acquired. And to give you the references, but the pleaded case that the claimants had sought to write off debts, the defence and counterclaim paragraph 66 and 87 to 94, and the claims of responsibility for diverting revenues to entities they control, that's defence and counterclaim paragraph 72 to 73 and 89. In relation to sort of questions of procedural prejudice, again, some of the points being made respectfully are a bit rich, because what the claimants are saying as well, obviously we're going to need an opportunity to respond to this, which is a luxury they are quite content not to afford the defendants when it comes to their own application to amend. But in any event, as I took Your Honour to earlier, the existence and content of these documents which have been included in the pleadings was already referred to in Mr. Shehata's sixth witness statement. So that was his trial witness statement. There's been an opportunity to provide responsive evidence to that. And so one can see the issues as already having been ventilated. And what's left, therefore, is a matter of making submissions on the amended pleadings of trial. So we say that the...
Although, Mr. Dougherty, if I was to allow the amendments as against the claimants, not additional parties, the claimant should be given at least some limited opportunity to put on further evidence, shouldn't they?
In a sense, that's a matter for Your Honour on case management. It is our position that yes, but the same thing goes for amendments by the claimants. So if the claimants are in much the same way introducing new pleadings and new issues, then there should be permission to respond to the new pleadings and the new issues.
Yes, a few days.
Well, perhaps, and we're obviously going to come on to this, but it's I took you this morning through the third witness statement of the second claimant for a good reason, which is it rather depends on what's being proposed as advanced on the claimant's amended case, because if it is the introduction of a whole series of new factual allegations, the scope of what needs to be said in reply might be greater. But that might be a question of controlling the evidence at trial and ensuring that any points that are put to witnesses have properly been canvassed by the evidence and haven't actually just been put into reply witness statement and not pleaded and everything else. But yes, I mean, our position is that one effectively follows the other. If the claimant's amendments are permitted, the defendant's amendments are permitted, permission should be given. That will feed into the course Your Honour takes with the adjournment, amongst other things.
Well, no, I was talking about if I refused the adjournment but allowed the amendments, there is still an opportunity to put on evidence in response, isn't there?
If Your Honour orders that evidence can be put on response, then yes, that opportunity is there. Whether it's a sufficient opportunity, I think, depends on the content. And really, that's more a point for that I make in respect of the adjournment, which is the number of issues and the width of the issues that have been introduced in reply evidence is pretty vast and is difficult to respond to in a short period of time. And that causes material prejudice because all of this is about issues that have been known from the outset and really ought to have been dealt with sooner. But that doesn't affect the amendment application. Dealing in isolation with the amendment application, if the claimants are saying there are issues of fact which we haven't already dealt with, they should probably be able to identify those. Insofar as it relates to the existence of and significance of, for example, the 20th of August memorandum, that has already been put into evidence and there's been an opportunity to respond to it. So one would need to have a think about what further evidence is needed on that.
All right.
I think you have my points on the amendment. The simple point is that they clearly relate to plead a case and they've got prospects, so they ought to be allowed.
All right. Mr. Montague-Smith.
Thank you, Your Honour. So just picking up on that overriding submission that my learned friend made at the end, which is effectively that all amendments applications should be treated in the same way. And so they should all stand or fall and be, we disagree with that. They all need to be considered individually on their own merits. So, for example, as regards the amendments, the claimants don't take objection to all of the amendments that are sought, and we've identified the ones that we don't object to, and I can just run you through those very quickly if it's helpful.
But the ones you don't object to are not significant in any way, are they?
No, and they don't change the shape of things too much. That's the point. So that's right. The question is, how significant are the amendments and what the consequences
to be more
of that?
precise, I rather had the impression that they were just to do with the change of circumstances since the pleading was made and some naming issues.
Yes, I think that's broadly right. I can give you. I think we've listed them out in our skeleton. I can take you through them if you like, but they're rather quick. Very good.
I'm operating first of all on the basis that those objections which you don't object to will be allowed. Sorry, those amendments which you don't object to will be allowed.
Yes. So the ones that we do object to are that. I mean, two of them are only reflective of the introduction of the new parties, and those are at paragraphs 56 on page 761.
Well, for the moment, I'm considering the position that if there are no new parties, and just looking at the,
all right, very good.
The amendments. So
thank you. There are 8 discrete amendments that we object to. You've been sort of shown the shape of them, but I'll come back to that in a moment. Very briefly on principles, my learned friend says, well, they're reasonably arguable, therefore you should introduce them. There are 2 principles actually that arise at this stage. The first is that they need to be properly pleaded in a coherent and properly particularized case. That's the first. And then the second is that when you're dealing with very late amendments, which would risk the cause risk the loss of the trial, there is a heavy burden to demonstrate the strength of the case.
Well, let's deal with that. Why does it risk
Yeah.
amendment? Take paragraph 66.
Yeah.
You know about the 28th of August memorandum that's been raised before. If you want to say anything about it, you can do that very quickly, can't you?
We can, but that's not the only thing that it's referring to. So
Right.
so if you look at what it says, paragraph 66, what it does is, firstly, it extends the allegation to the first claimant, but secondly, it is advancing a brand new sort of claim. What my learned friend does is he conflates two different types of claim. Right, so you can see this from the blue text as opposed to the black text. So on the black text, what you see are complaints about the behavior of the claimants as directors of Al-Khalij. So the claimants caused Al-Khalij to refrain from making payment. That's not about entering into transactions. That's not about the existence of existing contracts. That's, we say, legally incoherent allegation that they have done things or failed to do things in their capacity as directors of a different company. And that doesn't work. So my learned friend to say that actually this is just his amendments just are already in there, this is just more material for it, is completely wrong, because when you look at the material that's been introduced, you have allegations of things that they are alleged to have done as directors of Health Insights Dubai.
Yeah, I think Mr. Doherty is saying that in doing that, in knowingly causing Al-Khalij to refrain from making payment of invoices to Health Insights Dubai, they were breaching their duties as directors of Health Insights Dubai.
Well, but
I think
there's a
that's
prior
right.
question. Well, he does allege that as a conclusion, but one has to think through the what are the categories of complaint that he's making. Because if you go down through his pleading, and I can't recall where exactly it was, sorry, it was in 96C, wasn't it? So if one goes all the way down there, 772, this is the sort of allegation that he's making. So he's talking about actions in directing another company. So
Yeah.
96C, you see there's a series at 1, 2, 3, 4, and 5. And the allegations of complaint are causing companies owned or controlled by them, including Al-Khalij, to refrain from paying debts. So that's about the actions of Al-Khalij and their control over Al-Khalij. Their active participation in opposing proceedings brought by the second defendant against Al-Khalij. So again, actions on behalf of Al-Khalij, taking contradictory positions which conflict. I mean, how that's a breach of duty is very difficult to say, but anyway, it's not, again, that's in their personal capacity or on behalf of different companies seeking to take steps to register interests in the MCC software which are detrimental to and conflict with the second defendant's rights as partner reseller. That's not taking steps in relation to controlling Health Insights Dubai. That's about their allegations of effectively copyright infringement, which isn't pleaded. Permitting businesses owned or controlled by the claimants to market, sell, and use the MCC software. So again, that's about their control of a third party. And 6, otherwise diverting business and revenues away from the second defendant to other companies owned or controlled, including the version of the sum of 405,000, where such sums were owed by Al-Khalij to the second defendant. So they're not saying that was property of the second defendant that the claimants had by reason of being directors. They're just saying, well, they've taken steps as directors of Al-Khalij to direct Al-Khalij not to pay and to place business elsewhere. But that is not a coherent allegation of a breach of a duty of a director in his capacity as director of Health Insights Dubai. Now, what you then have introduced is something quite different. So if we go back to 66 on page 763, you then do have allegations, fresh allegations of actions alleged to have been taken as directors of Health Insights Dubai. So this is a fundamentally different and new case that's being advanced here. So the first case can just be met with, what are you talking about? You're complaining about actions outside the scope of the duty. It doesn't apply, the end. And that's substantially the central answer to that question. The second, new allegations of entirely different nature. What they say are, firstly, that the memorandum amounts to or records the existence of an agreement writing off debts and or assigning the second defendant's contractual entitlements. Not assigning contracts, which is where it's gone in submission, but say it's assigning contracts. Either way, these are allegations of steps taken as directors of, or as people in control of, Health and Sites Dubai. So that's entirely different. But then the question is, all right, what are the debts that are alleged to have been written off? Fine, that debt is pleaded out at $5 million previously. What one can then analyze the memorandum, and I take your point, Your Honour, in relation to that. One can analyze the memorandum and say, all right, looking at that, is that in fact an agreement writing off those debts? Was there otherwise, as a matter of fact, an agreement writing off those debts? But the second part of it is, the assignment of the second defendant's contractual entitlements is entirely vague in a number of ways. First, it's just been characterized as meaning the assignment of contracts, the assignment of the benefit of existing ongoing contracts. Well, and secondly, the question has to be, well, what are those entitlements or contracts that are being referred to? Where is that pleaded anywhere? What are they saying? Because you will recall that this is a company that was under the sole control of Mr. Shehata. And we say, when he left, he pulled out all of the hardware, taken away all the laptops, and we've got no access to the documents of the company. Now, you may or may not agree with us on that, but that's a factual assertion for which there is plenty of evidence. And we say he has not therefore given us the books and records of the company. So what is the case here? What is being alleged? That he caused Albulaihid to enter in, he caused Health Insights Dubai to enter into contracts which were subsequently the contracts which were assigned. And if so, what is the list of that contract? How did they come about? What are the terms? Where are they? And that's the fundamental complaint, is that this is not a coherent, properly pleaded claim. It's not one that we can engage with because we don't know what they're talking about. Now, we say, of course, well, there's been no assignments, but unless we know exactly what is said, we can't go much further than that in analysing actually what the claim is supposed to be in relation to that. And none of that is particularised at all. So there is problems with the cogency, problems with the pleading, and if that was to be pleaded out, fundamentally we would be entitled to particulars. What precisely are the debts, insofar as they're not already pleaded? What precisely are the contractual entitlements, or as my learned friend has characterised it, the contracts which were in existence and which were assigned? And then we would be entitled to respond to that in pleading and give that some thought. And then there would be evidence directed to that. And nobody has ever suggested previously, as far as I'm aware, that as at the dates of the subsequent contracts, which are identified at paragraph 71, that there were ongoing contracts which overlap entirely with the contracts that were entered into prior to my learned friend's submission this afternoon. And so, what's going to happen at trial? You're going to get more of the same. And it'll just be this creeping case that we won't know what it is. So it has to be a properly pleaded, coherent, cogent case, particularly at this late stage of proceedings. You can't just allow in a sort of catch-all allegation of the sort that's being advanced. And my learned friend even advanced a brand new case even in this application. So he says, well, the main argument is that it's been the assignment of a contract. But if it's not that, then, and the way he put it was that these were contracts which Albulaihid was not entitled to enter into, or the other parties were not entitled to enter into, because they don't, as he put it, enjoy the benefit of the rights in MCC. So those rights in MCC are said to, on his case, to be owned by Mr. Shehata, not by MCC. MCC, he says, Health Insights Dubai has some sort of license which again we dispute, but we'll have an argument about that. That's all up for grabs. But how these third parties entering into some sort of contract in relation to MCC could infringe on the contractual rights of Health Insights Dubai is not explained. We've just had it said to us during the course of this hearing that there is effectively a copyright infringement claim in the background here, but it's not articulated and it's not pleaded out. So you'd have to be confident that there was a really arguable case here, and you'd have to be confident that there was a proper particulars of that case here. And you know, he's had a few goes at it, but we just there is no explanation for it. And the ones he's tried to do don't stack up. So he says, oh well, we've pleaded somewhere else. I mentioned this previously. We've pleaded somewhere else these other contracts that exist, but those aren't pleaded in the context of saying that there's been some sort of infringement by subsequent business. Those are pleaded in entirely different context, and they came to an end on his own pleading in March 2022. So then where does he plead that those are the contracts, A, that those contracts were extended, B, and that those terms continued? He doesn't actually plead it. So at the moment, you then have paragraph 71, just this allegation, which again we say is just incoherent. The Al-Khalij has obtained the continued benefit of services supplied by the second defendant in the sum of $6.4 million. What are those? I mean, we just don't understand what that actually means. He's alleging, in a sense, and he then goes on to allege, as I say, that the contracts with other parties. So there's no case, at least advanced here, of contracts between Health Insights Dubai, pursuant to which those alleged debts are said to have arisen. There's no coherent allegation at all. And this is, you know, I mean, not a not insubstantial claim that's being advanced. And essentially what you're being told is we can start this claim today by pleading it out for you today, and you can skip evidence and document production in relation to these debt claims that are being advanced, and you can get to the end of that process next, you know, in 10 days time, and have a trial about it from 0 to 100 in 10 days. And with respect, that is just not a fair way to do it. We ought to have the opportunity to see what the claim is and then marshal evidence in response to it. So we don't accept that if you allowed this in, it would be fair to say, well, no, you just put in evidence in response within 3 days. This is a whole brand new claim, and it's barely articulated. So I don't accept that, and it's different from the amendments that we sought to introduce. Those amendments were canvassed long ago and produced long ago, and they have been covered in the evidence already in copious detail, subject to perhaps a few documents which we would like to be produced. But that is not the case in relation to these allegations. So 73A, which appears at page 766. Again, I mean, it just, you know, a barely particularized allegation. They say the revenues set out at paragraph 71 above, and those revenues, they say, are about $6.4 million contracts entered into with third parties. They say the revenues above have been diverted. But again, what is the diversion? And you know, it speaks volumes that we just genuinely hadn't understood that what was being said in that paragraph 66 was that contracts had been assigned. And in fairness to us, that isn't actually what the language says, but that seems now to be the thrust of what's being alleged. But you can't divert something. You can't have diverted away from you something you don't own. So sometimes we talk about directors diverting opportunities away from companies, but that's because the opportunity is treated as the property of the company. And so we can divert the cash of the company, I can divert the money of the company, I can take assets of the company and assign them, but the cash isn't they're not entitled to it unless you've got some sort of claim to that entitlement. If there was a contract, then there's still a contract with Al-Khalij, for example. 73 AB, claimants have taken steps to contest proceedings brought by the second defendant against Al-Khalij for the recovery of outstanding sums due and owing to it, and or discontinue proceedings with respect to the sum due. I mean, it's just totally unparticularized. Now, when we made this point in the evidence, the response came back, well, everybody knows exactly what this was made in relation to the police complaints. And it was said, well, everybody knows what the police complaints are and everyone knows what the prosecutions are. So, and actually, there's quite a diversion of evidence in relation to that. It's surprising that there should be, but there is a dispute of fact as to actually what claims have been brought by whom and against whom. So in that context, it's being alleged that the claimants have taken steps to contest proceedings and to discontinue proceedings. And again, it's just totally unparticularized what is being said here. So what are we supposed to, how are we going to deal with this? We need to identify all the proceedings in which, we need to work out what those proceedings are, number one. And then we're going to need to put before the court all of the material in relation to those proceedings to justify, presumably, the steps that were taken in relation to them. So essentially, what's being said is that we shouldn't have allowed Al-Khalij to defend those proceedings. But so one part of that will be, well, what's the result? So we'll need to look into those proceedings and determine the question of whether or not that was a fair thing to do. Presumably, that will be one of the issues. Discontinuation of proceedings. I mean, the mere fact, if it's right, I don't even know if it's accurate factually that they were caused to discontinue proceedings. But if that is right, then that may or may not be consistent with duties of a director of a company. I mean, if the proceedings had no merit, then they would be obliged. If they genuinely thought that they had no merit, they'd be obliged to discontinue those proceedings. And so you'd have to look at and assess those proceedings. And in this, just as with the other aspects, there's no explanation of why the first and third defendants are entitled to bring that claim. And I mean, ultimately, presumably those are claims by the second defendant for breach of duty by the directors. But there we are. And then C is a further sum, $405,000 owed by Al-Khalij to HI Dubai was diverted to HI Egypt. Again, there's no particulars of what that is about, no particulars of the proceedings. Steps were taken to discontinue legal action brought by the second claimant. No explanation of what those proceedings were. No explanation of what steps are said to have been taken and when. I mean, it's just an absolutely shell of an allegation, which no doubt will be shored up in the course of the trial, and we'll be asked to deal with it on the fly, which is not, we say, a fair approach. I mean, there was a debt, a disputed debt. There was an allegation that Al-Khalij owed the second defendant money, but that was considered and decided, as Mr. Shehata accepts in his witness evidence for trial, that was decided against Health Insights Dubai. He disagrees with it, but that's another GCC state. I mean, he's going to struggle to show that there's a breach of duty not to pursue a claim against the company when that exact claim has already been dismissed. And then 74D raises the issue of the travel ban. So that's a new claim. It's unclear what precisely that is referring to, but this is advanced, you will see, as a particular of seeking to exclude Mr. Shehata from the management of the second claimant. But the exclusion from the management appears to really, I mean, the thrust of that is really about his removal as the general manager, which has been litigated. But in any event, the events relating to those criminal complaints against Mr. Shehata are clearly going to be complex. And it's very difficult to see, you know, that allegation needs to be unpacked into what is the duty and how has it been infringed? I mean, if for example, take an extreme case, which we say could be this case, where a director just steals money from a company, obtaining a travel ban may be totally appropriate. If it's all trumped up charges, obtaining a travel ban might not be appropriate. But merely obtaining a travel ban in and of itself doesn't tell you either way whether it is or it isn't appropriate. So packed up in that will be allegations that they shouldn't have made those applications or shouldn't have obtained those sorts of orders, which need to be unpacked. So it's not just about the sort of narrow points that my own friend has identified. There are other points which emerge, and we go on at 771, paragraph 94D. Seeks the setting aside of the agreements. And you want to ask me the question in relation to the memorandum. Well, what about the memorandum? We can all have an argument about that. But I think the allegation is that it's that memorandum reflects an agreement to cancel other contracts. And I've been through those submissions, so I won't repeat them. And then page 773, paragraph 99E. And then they plead out the right to bring proceedings by HI Dubai against HI Egypt or HI Saudi Arabia in circumstances where they don't actually explain what the nature of that claim would be. I mean, it seems to be in respect of unpaid invoices, capital I, but if you go back to 762, you see at the top there, invoices are defined, capital I, as invoices issued to Al-Khalij. So if we go back then to that pleading, 773, when it says they want to bring proceedings for non-payment effectively of some other of invoices, either you treat invoices strictly as being invoices identifying debts owed by Al-Khalij allegedly, or you have to sort of say, well, it's just talking about some other unpaid invoices which haven't been particularized. And therefore, again, we've got this sort of bucket of facts, which just will no doubt be unveiled during the course of the trial. And then they also want to make allegations in relation to the continued or unlawful use of the MCC software. But that suggests that they are saying that neither HI Egypt or HI Saudi Arabia has rights to use MCC. So then we have to get into that, which hasn't been on the table to date. But even before you get there, you have to, you still have no explanation of how this court can grant permission for the second defendant to pursue that claim. What is the second defendant's entitlement? The second defendant isn't, in the defendant's case, alleged to be the owner of the MCC rights. They put their claim entirely on the basis that Mr. Shehata owns those rights. So they would have to plead in a sense that A, there'd been an some sort of exclusivity or some assignment of the copyright, but more importantly, that right creates a right which HI Dubai itself is entitled to protect. So some sort of proprietary copyright of its own, which it can bring a claim on. But again, I mean, none of that is articulated, none of that is explained, and presumably we're going to get dumped with a whole load of Egyptian law on copyright, or possibly Dubai UAE law of copyright on Monday when skeleton arguments arise. So we would say that the only, if you were to entertain permitting these amendments, the only really the only safe way of doing it would be to require proper pleading of the allegations that are being made, and then to allow a response to that, and then after that, for the parties to consider whether or not further documentation is required. Because, for example, Mr. Shehata, in all of this diversion allegation, is alleging that there was alleging that there are some sort of ongoing contracts entered into by HI Dubai with Al-Khalij in relation to various hospitals. And those are documents which relate to the activities of HI Dubai, and no doubt during a period when Mr. Shehata will say that he was in control of it. So he'll take his old stance, which is, well, I did it, so I'm the only person who can talk about it. Don't ask me any questions. And we will potentially want to ask him some questions, not only about the documents that would exist, but also which might arise from the quality of the documentation which he himself produces, which we've seen on the issue of our own amendments. So I must say, in my submission, it is very difficult to see how these additional amendments can safely be introduced in a way which will allow my clients to have a proper opportunity to engage with them in the limited time there is before trial. And I have to say, I think that the result of that is either you refuse these amendments, or the trial goes off. And for the reasons that we'll come on to, we say that ought not to be countenanced. But ultimately, there is really no explanation that is satisfactory, at least, of the timing of all of this. These documents, well, the memorandum was produced on the 20th of May, and most of these points were available long ago anyway, but because that's essentially what's being said. So unless you've got any questions, those are my submissions. Thank you.
Mr. Doherty, in reply.
Yes, it's surprising to hear some of what's said. I've just pulled up the agreed list of issues between the parties. And for example, I think one of the suggestions was that there's going to be an argument about the MCC rights, which hasn't been on the table to date. Issue 2 on the agreed list of issues is who was and/or is the owner and/or holder of the MCC rights. The parties.
I'm sorry, that's just a mischaracterization of my submission, Your Honour. I didn't suggest that. Of course, there is an issue about who holds the rights. Yeah. The point that I was making was that this appears to be a new case being advanced, that HI Egypt and HI Saudi Arabia had no entitlement to deploy those rights. That's a separate question.
I'll come back to my pleading in due course, but the other issues which are listed are has C1 knowingly caused Al-Khalij to refrain from making payments? Have the claimants diverted business and revenues relating to the implementation and maintenance of MCC? Have the claimants sought to exclude Mr. Shehata from the business? Have they acted contrary to their constitutional interest of HI Dubai, as set out paragraph 79 of the claim? I mean, the issues that we've run through this morning are all set out in the pleading, and they're all known to be issues. I mean, if we go back to it, amongst the various things that you were told have never been canvassed before are all set out in the original pleading, so they're already issues. The only real point before Your Honour is whether or not to accept a further pleading out of those issues by reference to these specific documents. So, for example, if you go to page 768.
Well, see if I understand what you're saying, Mr. Doherty. You're saying that your existing pleading permits you to raise many, if not most, of these points.
I'm saying that the points and the arguments are already an issue, so they're not new arguments. What's new is the deployment of particular factual elements to those arguments. So what's new in the pleading is not that we're advancing a different case that we've never articulated before. It's just that what we have now is knowledge of the 28th of August memorandum and to those various purchase orders entered into with HI Egypt and HI Saudi. But it all fits within the context of what's already been advanced and put forward as the defendant's positive case in proceedings. And a number of examples were given as my learned friend worked through the things that would have to be teased out as a consequence of issues that have been introduced. So, for example, there's reference to the claimants taking steps to contest proceedings. That's the paragraph 73A-B. There's already been reference to that in the context of the pleadings. So 768 at paragraph 79 already makes assertions concerning steps taken to adopt contrary positions in sets of proceedings. To the extent that my learned friend just clarified, the point he's making is that there's no argument currently before the court that HI Saudi, for example, didn't have the right to utilize MCC. You can look at paragraph 79D, which is acts undertaken contrary to the interests of the second defendant, including continue to license, implement, and maintain the MCC software in the territories without payment or seeking the permission of the second defendant as the authorized partner reseller. And the context of that and the way that the rights are held is all set out. So page 760 is a positive pleading about how the MCC rights are held. So from 52 onwards, and paragraph 54 in particular refers to the basis upon which within Saudi Arabia, it's the second defendant who has the exclusive right to utilize and market MCC and therefore obtain the benefit of contracts in relation to that. So that issue is already pleaded out. And that's why the case is framed as here is an entitlement that the second defendant has to exploit the economic rights of MCC in this region. And that what's happened is the diversion of those revenues to other companies who do not possess that entitlement but happen to be controlled by the claimants. It's already in the pleading case. For example, when it comes to this assertion that what we're saying is an allegation which arises in the context of the claimants acting in their capacities for Al-Khalij, and so that doesn't fit into the matrix of the claim that's put. That's not the way that it's framed. So paragraph 81 onwards from 769 frames the conduct by reference to the duties that the claimants owe to the second defendant. So the issue with the transactions and the arrangements isn't the side of it on which Al-Khalij sit. It's that in order for a company for Health Insights Dubai to waive its debts to Al-Khalij might be the beneficiary of that, but ultimately the allegation is that Health Insights Dubai has waived its right to seek payment of those debts by Al-Khalij, and that is an action taken by the claimants in their capacities as directors of the second defendant. And the basis of that set out in paragraphs 82, 83, and 84, which is they're interested indirectly in those transactions as a consequence of the shareholding in Al-Khalij and the employment by Al-Khalij, and that those interests conflicted with the second defendant, and that it wasn't declared. And similarly, paragraph over the page, paragraph 87 onwards, deals with this in the context of writing off debts. And now at the time this was pleaded, the defendants were not aware of the 28th of August memorandum, so you can see it's pleaded on the basis of what was understood to be the case. So paragraph 89, if the claimants are successful in seizing control of the second defendant, they will act in breach of their duties by seeking to write off or extinguish, and that's the basis of seeking injunctive relief. But paragraph 91 says, in the event that the claimants take steps to write off or reduce or extinguish the debts, any such transaction that they entered into is one in which they have a direct or indirect interest, and the basis of that interest is pleaded. And so what is being said here in the original pleading is, if steps have been taken by the claimants that we are hereto unaware of, which have had the effect of writing off debts, those stand to be set aside. What happens on the disclosure of the August memorandum is we now know that that happened in the past, whereas we previously didn't. And so the addition of subparagraph D there simply reflects what is already the pleaded basis of the case, but gives the specific example of the transaction. I mean, it is slightly odd that the thing that I'm being criticised for is not identifying the specific transactions, and yet now that the specific transactions have been pleaded out, I'm being criticised for that still. I think the point was, well, it's not coherent because where are these contracts? When were they extended? What are the debts? All of that feeds into the submissions I've already made to Your Honour about disclosure and the importance of disclosure. It seems to me that the claimants are in effect hiding behind the fact that they haven't complied with the disclosure order to then say, well, you haven't identified specific contracts, which were ordered to be disclosed but haven't. And ultimately, however the allegations are put within the context of the Article 79 claim, they are plainly relevant to and pleaded as relevant breaches of the claimant's duties as directors of the second defendant. And so the factual pleadings set forward, we say, are clearly relevant to the unfair prejudice claim, but also as an important element of that claim, the fact that the relief sought is permission to pursue claims that the second defendant would have, including what we say is the continued unlawful use of MCC, which, for the reasons I've shown you, are pleaded. We say Health Insights Dubai has the exclusive rights to in these regions. So the take-home point is that however much my own friend looks in isolation at these aspects of the pleadings and says, well, that raises a brand new issue, the answer is that it doesn't. First of all, as a question of fact, because these factual issues have already been set out in the witness evidence. A right of response has been given in reply evidence. But two, the basis of the submission and the assertion that's going to be made at trial is also explained and set out in the original pleading. So all of it is already an issue. None of it is a new case. It is simply advancing a case by reference to new information that already existed.
All right.
So, Your Honour, may I just make two short observations, because my own friend's seriously misrepresenting what our position is. He says that my complaint is that now that they've set out the contracts that are being assigned, then that's the problem that I've got. The problem is he doesn't set out what those contracts are, and then he says, "Oh well, this is all a feature of the fact that the claimants are hiding behind their directorship of Al-Khalij to say they're not going to produce documentation." And that is a seriously misleading misrepresentation, because it has never been suggested that the claimants have failed to produce documents which came into their possession as directors of Health Insights Dubai. And this is the conflation that he consistently persists with, which is between allegations of them of their conduct as directors of HI Dubai and allegations of them as people who have a controlling or an interest or ability to control Al-Khalij. So the new allegations are all about their conduct as directors of HI Dubai. And it's not suggested that documents that came into their possession have been withheld in relation to in that capacity. And it just shouldn't be put in those terms, I'm afraid. So I object to that strongly.
All right. Does that take us to the adjournment, postponement of the trial issue? All right. Well, I want to take a 5-minute break at this stage. I make it 3:13. We'll resume at 3:18. All right. Mr. Doherty, are you ready?
Yes, thank you. Your Honour obviously has the context that lies behind the rest of the applications. The specific prompts that led to the adjournment application being made is the introduction of not only evidence of new witnesses, but evidence on completely new issues that have never been traversed by the claimants properly before, and I'll take you through that. So the first thing I'm going to go to is take you to some of the pleadings and evidence to give you the context of what was ultimately set out in reply with this evidence by the claimants served fairly recently. Two, to take you to some points of principle, and then just to give you the headline points that we make in support of the application. And really what it boils down to is providing parties with a fair opportunity to respond to a case that's put, particularly a case that's put very late in the day. The authorship and the ownership of MCC is an important, in fact, a central issue in many respects in the case. It's one that has been live since the very beginning, because Mr. Shehata, you will no doubt recall when this was a party claim, put in a witness statement in which, amongst other things, he asserted that he was the author of MCC and that he was the owner of the rights in MCC. And he explained how the rights were sub-licensed to Health Insights Malaysia and to Health Insights Dubai, enabling them to market and sell that product in particular regions. And that was an assertion that he has maintained throughout proceedings. It also won't be lost, Your Honour, that Mr. Shehata has put in a lot of evidence on these proceedings and has adopted a pretty cards on the table approach. We say contrary to what the claimants have done in these proceedings. The pleaded case put forward by the claimants at that point in time, in the knowledge of Mr. Shehata's position, you can find at page 17 of the bundle. At paragraph 13, bottom of the page. Which seems to be that at all material times prior to December 2021, the second defendant owned the intellectual property rights in MCC. Which is why, presumably, when you go to paragraph 36 of this document, which is at page 22, when it comes to the claim seeking to set aside the assignment agreement, what's said is the price agreed in the agreement substantially undervalued the MCC rights and or the work done in the development of the MCC software. The implication, of course, being that the second defendant owned the MCC rights and carried out the work done in the development of the MCC software. So the case that has been advanced before the DIFC court as pleaded is that D2 owns the intellectual property rights. Your Honour will no doubt recall we've made observations in the past about how that pleaded case is somewhat inconsistent with positions advanced in other jurisdictions, which is that Health Insights Egypt owned the intellectual property rights, but that is how the case has up until now proceeded. The defendant's case, in response to this, at page 27, which you've already looked at to some extent, but the first defendant's the sole owner, he authored MCC, that the third defendant was given a right to use, sell and deploy MCC under a licensing agreement. And then paragraph E says that effectively a similar license is given to the second defendant under a partner reseller certification, which enables them to resell the software to third parties in the UAE and Saudi Arabia. So that's at the top of page 28. So what we have is, on the one hand, the claimant making what we say is a bare assertion of ownership. So you have an assertion that D2 owns the property rights, at least the implied assertion that it carried out the work in the development of those rights. But there's no actual explanation in the pleadings from the claimants as to how the claimants actually acquired those rights, whether through creation of MCC or it being assigned by another entity who created it, or how it came to hold the rights that it claims to be entitled to receive, well, that the claimants are claiming Mr. Shehata ought to account for. The reply and defence to counterclaim is at page 51. This is paragraph 10, subparagraph 3. And this is in response to the positive case that I've showed you that was put by Mr. Shehata. And what's said there is it's not admitted that the first defendant was the sole author of MCC. And it's denied that the first defendant was the owner. So quite consciously not pleading a positive case, because of course if you deny an allegation under the court's rules, you have to provide your reasons why. All we have is a non-admission as to authorship at that point in time. That, I have to say, is pretty unsatisfactory, because you also still, even though there's a clear denial that the first defendant was the owner, there's no explanation, again, no positive case as to how the second defendant came to acquire the rights. If you go to page 66, at the bottom of the page, paragraph 10a, we assert simply that the pleading doesn't comply with Rule 17.27 because there's no positive case on authorship or how the rights came to be vested in the second defendant prior to the 19th of December 2021. Now, that isn't advanced at all in the initial trial witness statements, which obviously, given that this is an issue, it's issue 2 on the agreed list of issues.
Sorry, what wasn't advanced in the initial witness statements?
So the initial witness statements don't provide a positive case as to how the second defendant either authored or carried out the work in developing MCC, or how it came to be vested with the rights in MCC, assuming it wasn't the author.
I thought Ms. Hosny's witness statement did.
Ms. Hosny was not a part of the company at the time that MCC is developed. She deals with the development of Medica Plus.
Yes.
Which is in the late 90s.
Right.
Medica Cloud Care, I don't think it's, well, it's now unclear, I have to say, whether it's disputed, but it had not been understood up until this point in time that the parties believed that the rights in Medica Plus were the same as the rights in Medica Cloud Care. They're different systems based on different technologies.
Mm-hmm. Okay.
So Medica Plus is an older system. Medica Cloud Care is a system developed around cloud computing, whereas, as I understand it, the older system was, you would implement it on a particular desktop, so you wouldn't have the transferability of data in that way. So Ms. Hosny can't speak to that. What the claimants do is somewhat fudge the issue. So the first claimant says that he thought he was told by the first defendant that MCC was registered in Dubai, but he later found out it wasn't, so he tried to register it in Egypt. But he doesn't say anything about authorship or ownership. As close as you come to that really is a claim that, quote, Health Insights developed MCC, but there's no explanation in any of the claimants' witness statements what they mean when they say Health Insights. Are they talking about Health Insights Egypt? Are they talking about Health Insights Dubai? Are they talking about Health Insights Saudi Arabia? I don't know. I still don't know. There's similarly in those witness statements vague assertions of ownership of Medica Plus by, quote, Health Insights, again without being specific. And I can only assume that that was a deliberate choice by the claimants in the light of positions that they had taken in court proceedings elsewhere, where they were asserting that the owner of the rights was Health Insights Egypt, which of course is contrary to the position that they are advancing before the DIFC court. But the important point, certainly when it comes to the trial witness statements, is the claimants knew what the first defendant's position was, and they knew what case the defendants were advancing. This isn't in the trial bundle, but the section of his the second claimant's first witness statement, which deals with this, says in paragraph 30, I understand in these proceedings, Nasser has alleged that, one, he was the creator of Medica Plus, and two, he was at all times the sole and ultimate owner of the rights to MCC, when he says, I don't believe those allegations are correct. And in paragraphs 35 and 36 of the first claimant statement, he says pretty much the same thing. I understand in these proceedings, Nasser has alleged he's the creator. That's not correct. I understand Nasser alleges he was the sole and ultimate owner of the intellectual property rights. That is not correct. So they knew it was being alleged. That was the time to set out their positive case if they had one. But they didn't do that. They didn't explain how MCC was created, who was responsible for creating it, whose labor went into the creation of those rights to bring it back to how it was put in the particulars of claim about the undervaluing of work. There's no explanation that takes the creation of the rights and explains how that translates into intellectual property ownership. If dealing with it at a pretty high level, if Health Insights Dubai is said to have been the author, then they might say that it was the original owner of the intellectual property rights, but I don't think that is a case that's ever been advanced. If the intellectual property was created by someone else or other individuals, there would need to be an explanation as to how it came into the hands of Health Insights Dubai. But all of that is completely absent from the initial witness statements provided in this case, and it's not pleaded out. I have to say, I just don't understand, and I don't know what the claimant's case is, and it'll be interesting to see how it's set out in the skeleton arguments in due course, given what they are claiming. But it's only then when you get to the reply witness statements that you see for the first time, one, a pretty extensive positive case being advanced, but two, something that is completely new and hasn't been alleged up to this point in time in proceedings. So if Your Honour goes to page 1343, and paragraph 30, it starts with the same standpoint. It's the allegation that C2 already knew about. Sorry, this is C1. C1 already knew about. I'm aware that Nasser claims he authored MCC and that it couldn't have been offered by HI Dubai. And he then says this is right. As I explained above, it's a sophisticated and complex software. To build that kind of software, you need an entire team of programmers. It's not possible for a single individual to develop it. The only company who had the capabilities was Health Insights Egypt. And that allegation is repeated over the page at 1344, paragraph 32, in the final sentence, which says, in any event, the reality is that to develop a program like MCC, NASA needed the programmers that were within Health Insights Egypt. At 1350, this is the second claimant's reply witness statement. And he says at paragraph 7.1, well, he keeps it in vague terms, in fact. He says the development was carried out by a team of programmers at Health Insights rather than Nasser alone. He doesn't say which entity that is or whether it's the same entity that's being referred to, but at the next paragraph, so this is the end of subparagraph 2, there is some reference to Health Insights Egypt. So Nasser is not mentioned in a particular certificate because Health Insights Egypt did the implementation of this particular system. And then what he says is that the development of MCC started in 2016 in Saudi Arabia by a team located in Riyadh. We don't know who that team is employed by, just says Health Insights team in Riyadh. We moved the development team from Saudi Arabia to Egypt in order to work on the transition from M+ to MCC. MCC was then implemented in 2017 by Health Insights, not sure which one. The development was undertaken by Egyptian programmers employed by HI Egypt. It was not something that was developed by Nasser in his personal capacity. Now, obviously, this is evidence that purports to be given from the first-hand experience of these witnesses. And given that the creation of MCC has been an issue from the get-go in these proceedings, it's really startling that such an important issue is being dealt with in reply evidence at all. But what we then get is witness statements which try to make that new argument good from 4 entirely new witnesses who flesh this out in all sorts of ways. So, for example, page 1320, paragraph 10. So this is a statement of Marwan al-Shami. And he says that I recall in 2016 or 2017, it was the second claimant who came to HI Egypt's offices and announced that the future was in cloud-based systems. And that our colleagues in Saudi Arabia had already started to transition to cloud-based systems. And soon HI Egypt had an individual to come to the office to lead the transition. The entire development team went through company-sponsored courses to learn about web and cloud services. And then it says in response to what Mr. Shehata has been asserting all along in these proceedings, that that's wrong because there's a team of over 100 programmers involved in the development of MCC. I assume based on this evidence, the assertion is that it would be programmers from Health Insights Egypt. But in any event, he's saying that there are lots of modules, and these are the individuals I'm setting out as examples of who was involved in the development. And then in paragraph 14, he goes on to say that Nasser was not actually involved in the development of any modules, just monitoring due dates and development cycles. So suggesting he's not responsible for source code at all. And these sorts of allegations are repeated and expanded upon in all of these other statements. So 1326.
So what, page 1?
1326. This is a statement of Wessam Heggie. This seems to refer to Medica Plus being implemented in 1999 and Health Insights Egypt continuing to develop the software over the years. It's worth noting Health Insights Egypt, it didn't exist at the point that the program was actually created, didn't exist and wasn't operating until 2004. But then in paragraph 11, we have a slightly different argument again, which is that Medica Plus was upgraded to Medica Cloud Care, which again doesn't so much suggest that this is a different set. This is a piece of property with a different set of rights. It seems to be just suggesting that this is the evolution of Medica Plus, which would invite questions about whether or not we ought to be treating intellectual property ownership in that by reference to how the rights were established in Medica Plus. But then paragraph 15 of this statement, which is 1328, there are further assertions which obviously need unpacking if this is the way that the case is going to be advanced. But it's been my understanding that Medica Plus and MCC are owned by Health Insights. This makes sense to me. Health Insights is the entity that continuously funds and sustains the development of MCC, including the salaries of all teams. Well, which entity is that talking about? Where is the evidence about the funds that are being put into MCC? I mean, presumably on the way that the claimants are advancing their case, in that they say that there was an undervaluing of the rights compared to the amount of work that went into it, one might have expected there to have been positive evidence led, not in reply evidence, which dealt with here's the work that went into it, here are the costs associated with that work, here are the individuals employed and how much they cost, here are examples of the work that they performed, here are the files that we have stored at Health Insights Egypt, which shows that this is where the work was carried out. But we don't have that. We've just got a short sentence to unpack what are pretty complex issues from. There are further allegations at 16, which have never been referred to before, which is that Nasser didn't develop some of the underlying IP for Medica Plus. It says that he acquired the source code from a third party called Active Medical Sheets. That's not been asserted previously in these proceedings. And then in 2016, this is paragraph 17, in 2016, we learned that our development team based in Saudi Arabia had started to migrate the administrative and configuration models to cloud-based solution. This development team then traveled to Egypt. I mean, all of that begs the question of, well, who is being said to have begun the process of authoring this piece of software? Is it Health Insights Egypt? Is it Health Insights Saudi Arabia? And what impact does any of that have on how the intellectual property rights are held or how they subsequently vested? But there's also lots of technical information in these statements. So 1329 talks about developing a tool which is compatible with cloud technology, as though that's what spurred the advancement of MCC, and to try and take responsibility of that away from Mr. Shehata's work. It seems to be that that's the implication. Paragraph 20, it asserts that Mr. Shehata didn't develop MCC. When we upgraded it, he didn't have any software development role. He wasn't involved in developing any modules. He was just the CEO of HI Egypt and managed the company in a micromanaging style. Again, none of this has been presaged in anything that's before the court previously. And it's the same with the other statements. I mean, I'll take you through them so you know where they are. But 1306 is a translated statement of one of these witnesses, Mr. Al-Shawani, which talks about the
Did you say 1306? Yes.
And this one is particularly strange, I have to say, because it says the modules were initially developed on the old Medica Plus system when we commenced conversion to the MCC during my period of work for Al-Khalij, agent of Health Insights Company, which is the owner of the program. I and the working group conducted a complete conversion of such modules to the new MCC system. And I had started this work and conversion process when we were in Saudi Arabia. I mean, that almost seems to be attributing at least part of the creation or part of the authorship, not to any Health Insights entity, but in fact to Al-Khalij, based on my reading of that paragraph. Albeit it's pretty unclear, but in any event, he makes the same points about there being a large group of programmers. And then the next statement is 1314. This is Mr. Bashir. In paragraph 10, he says that by 2017, when he joined Health Insights Egypt, MCC had already been developed. And he makes the same points about these various different modules. At paragraph 12, he says, it's my understanding that it's owned by Health Insights. Again, not entirely clear what that means. At paragraph 14, he says that it can't be the work of a single developer. This is why he says we had over 40 developers covering all the modules. Paragraph 17, he asserts that Mr. Shehata didn't develop MCC, said there was a dedicated team managed by the development manager. I assume this is of Health Insights Egypt because that's who apparently employs this individual. And he managed it, but simply followed up with team members on the execution of models. What we have here is a set of entirely new points. Frankly, it's a completely new way of articulating the claim. I'm pretty unclear of what position the claimants are going to be advancing at trial when they deal with this. But it seems to be a position that has changed from Health Insights Dubai owned the IP at all material times, and that the work that went into it was undervalued, to now suggesting that Health Insights Egypt developed MCC through the interaction of numerous employees, seemingly that Al Khalij played a role in the development of MCC as an agent of Health Insights Company, whatever Health Insights Company means. That there are various individuals never previously named, but none of them are Mr. Shehata, who are personally responsible for writing the source code of numerous modules. We have an allegation that MCC is just an upgraded version of Medica Plus. We're told that the first defendant had no role in the technical side of it at all. We're strangely told that the whole idea was actually the second claimant's, which is slightly odd in that he forgot to mention that in either the pleadings or in his first witness statement. But anyway, he came up with it in 2016 or 2017. The work initially started with a team in Saudi Arabia. I don't know who employed them. I don't know whether it said that there's another entity that employed those individuals or whether they're employees of Health Insights Egypt. But in any event, all of the Health Insights team went through sponsored courses about web and cloud services. They developed it together with a team of over possibly 40 or maybe 100 programmers. And so Mr. Shehata's case is nonsense. He can't possibly say that he was the author. And all of this is put in reply witness statements for the first time on an issue which is clearly and has always been a central issue in this case. Who authored the work? Who owns the rights to the work? The claimants have known the defendant's pleaded case on authorship and ownership. That's been advanced even prior to the pleadings. They chose not to plead a positive case on that. And in the initial witness statements that they put forward, they also didn't put forward a positive case. They made vague references to Health Insights being the owner. And it's not only in these reply statements that we get all of this new evidence and also this brand new case that the defendants don't accept, but have no opportunity in the procedural framework to respond to. And we say that that can't be a proper or fair way to conduct litigation. The claimants say that this wasn't geared up as some type of an ambush, but respectfully, we don't agree with that, and we do invite Your Honour to draw appropriate inferences from the way that this has come before the court. But just to break it down, you're required by the court's rules, if you deny an allegation, to state your reasons for doing so. And if you intend to put forward a different version of events, you have to state your own version. That's Rule 17.27. In the defence and counterclaim, which I've showed you, a positive case was pleaded on the authorship and the ownership of MCC. If the claimants wanted to advance a case, the rules required them to plead it, and there are obviously good reasons for that, so that the court can avoid situations, frankly, like this one, where the claimants are introducing a new and pretty elaborate positive case in reply witness evidence, which prevents disclosure of documentary evidence on that issue. It prevents there being responsive witness evidence on that issue. So the starting point, we say, is you shouldn't be introducing a new positive case on an important issue like this in witness evidence at all, let alone a reply witness statement. So that's what the rules say about pleadings. The rules also make provision for the content of witness statements. Rule 29.18 says that witness statements should be as concise as the circumstances allow, but without omitting any significant matters. It's hard to see in the context of this case how there could have been much more of a significant matter than how the claimants were asserting ownership of the MCC rights came about. And we also point out that the RDC doesn't by default provide for reply statements at all. So in that context, we say that the effect of that rule means that it was incumbent on the claimants, if they were going to advance a positive case that was within their knowledge, they should have done that with their first round of statements. It's not a proper approach to try and keep your cards close to your chest and to say as little as possible in your initial witness statement, with the intention of putting it all out there in reply when you know the other side isn't going to be able to respond properly to it. And I think the point is made that, well, the RDC doesn't preclude us from introducing new witness evidence in this way in reply. But that's only because the RDC doesn't have any express provisions which even allow for reply statements in the first place. In that context, Your Honour will have seen in my skeleton, I refer to the guidance issued by the various divisions of the English High Court, which cover that issue. So the first is the Commercial Court Guide, which I think should be in Your Honour's bundle. It's page 2158. So you should have a section which says H, evidence for trial. But it's H12, which says where management direction is made permitting supplemental or reply statements, that permission is limited, unless otherwise specified, to witnesses from whom witness statements have already been served. And then at 2164, this is from the Chancery Guide. Paragraph 8.15, and it's the final sentence. Witnesses additional to those whose statements have been initially exchanged may only be called with permission of the court, which will not normally be given unless prompt application is made supported by compelling evidence, explaining the late introduction of that witness's evidence. So the proper approach as a matter of procedure is that even where there are reply witness statements provisioned in the rules, it's intended to deal with issues which are properly issues in reply. It's not just to expand upon a case which you should have dealt with at an earlier point. And the second point is, even if you're going to introduce reply points like that, the default position, unless you've got permission of the court, is that it should be from the witnesses who have already tendered evidence. You don't just put in a slew of new witness statements from new witnesses who haven't been canvassed before. And the submissions that we make on the additional evidence, but first of all, the first defendant's position has been in play since the get-go in these proceedings. It was supplemented by pleading. It's been supplemented again by evidence in the normal way. And so none of this is really evidence in reply. This is just the claimants advancing a new case. Second, having been put in the defendant's pleadings, the claimants were under an obligation to actually plead out a positive case if they had one in respect of the authorship and ownership of MCC, but they chose not to do that. And they also chose, third of all, not to do that when they were preparing their initial witness statements. And what they should have done at that point was to set out their evidence, and as the RDC requires, do so without omitting significant matters. For example, the assertion that MCC was all the second claimant's idea in the first place. There's no reason why that should have appeared in a reply witness statement. The fourth point we make is that there are good reasons why the court imposes procedural requirements on parties to give advance notice of the witnesses that they're intending to call. So the first time you get it's in the case management information sheet ahead of the CMC. That says, how many of these witnesses of fact do you intend to call to give oral evidence at trial? Please give their names or explain why this is not being done. At that point in time, the claimant said that they'd be giving evidence from 2 witnesses. In the event, it turned out to be 3. There wasn't necessarily an explanation about the expansion, but given the circumstances, given the addition of 1 witness, it was something that could be accommodated. So by the time we got to the PTR, it wasn't an issue. In particular, we were given notice at the PTR. So the pretrial checklist asks you how many witnesses do you intend to call? And the claimant said 3. The PTR fell in the middle of when the first witness statements had been served for trial, but before reply statements. And in the documents leading up to the PTR, including estimates of trial length that everyone has to serve on the court, suggesting a maximum of 6-day trial. But the pre-trial checklist said we intend to call 3 witnesses. No reference at all to the potential expansion to 4 additional witnesses. And there are obviously good procedural reasons for that, because it allows the court to properly manage the case, to fix the length of trial. But there's also reasons of substantive fairness. Parties are supposed to adopt a cards on the table approach to who they're going to call, because that gives another party an understanding of, well, what are the issues going to be and who do you need to call to deal with particular bits of evidence. And if you're telling one party initially that you're going to have 2 witnesses and then 3, and you serve 7 witness statements, it obviously poses questions not only of what the substance of the allegations are going to be, but also just balancing court time, making sure that the court is hearing from a sufficient number of witnesses to properly address the issue. But again, the claimants didn't do any of that. They've unilaterally decided to put out these statements, to put out these new allegations, which have the effect of doubling the number of factual witnesses attending trial. The 5th point, as we've said, is you can draw, particularly given the alignment of the RDC with the English court's rules, from the Commercial Court and Chancery Court guides about the fact that reply statements ought to be limited to witnesses who originally provided statements. And if there's going to be deviation from that, you would need permission. And the 6th point we make is to say that reply statements should actually be responsive, not introduce brand new issues or put a positive case for the first time. And the upshot of all of this is we say it introduces real substantive unfairness to the defendants. The claimants must have known that they were thinking about introducing 4 new factual witnesses, and they must have known when they decided to take that step that it wasn't going to be insignificant, and it was likely to cause a stir, if I can put it that way. So it's reasonable to assume that in making the decision to put those witness statements out there, they must have formed a view that this evidence is going to be really important to the way that they now intend to advance their case. Otherwise, it's difficult to see what the justification in doubling the number of witnesses in that way would be. If that is the case, and if the claimant's position is that this is important evidence, it needs to be out there, the court needs to consider it, in the interest of fairness, the defendants must be able to respond to that properly. And we make a number of points about that, but I mean, much of this is assertion without evidence. There are a few screenshots of, I think, out of context, WhatsApp messages being exchanged, and we don't have full chains of those communications. No one has had the opportunity to investigate where they arose, what the prior conversations were, and so on. That somewhat points towards the fact that there is a new issue which has been put out there, which the court's going to need proper document production on. So, for example, documents which show how it was that the second claimant came up with Medica Cloud Care and how he instructed a team in Saudi Arabia to start the transition over to a cloud-based system, given that he's advancing that this was his idea and that the first defendant had nothing to do with it. We would be entitled to probe the identity and details of employment of, first of all, this development team in Saudi Arabia. So we can have a think about, well, how does that impact on what's said about intellectual property rights, but also the development team situated in Egypt. Who are these individuals who say they were developing this source code? Are they qualified to do it? Is it plausible that what they're saying is actually correct? Even with that information, one has to draw from what is asserted about the creation of MCC, how ownership of the rights came to be established. And again, this is a real grey area in the claimant's case. I don't understand it. We'll have to see in skeleton arguments. But if what's being asserted now is that Health Insight's Egypt employees were responsible for all of this source code and writing it, there is a question about how the claimant's pleaded case can even work. How are they going to get to the conclusion that Health Insights Dubai was the owner of the intellectual property rights in Medica Cloud Care? That's completely unexplained. There's no positive case. I don't even know if it's still advanced. It might well be that they've abandoned that point and they now assert that the intellectual property rights are owned by Health Insights Egypt. But if that is the case, the claimants need to be upfront about it and they need to plead it and there needs to be evidence on it. Similarly, all of this information about the authorship of Medica Plus and active medical sheets not being written by the first defendant, but in fact being purchased from a third party. There's no evidence on that. We haven't an opportunity to respond to it. And there needs to be evidence about what the development work actually was, evidence about how the development work was allegedly funded, what entity is said to have paid for the development, given that it seems to be a part of the claimant's claim that what needs to be accounted for to the benefit of Health Insights Dubai is the value of the work that actually went into this in the first place. But at the moment, there's no opportunity to do any of that. A second point we make is that the first defendant obviously disputes this account and has consistently set out his position on this issue of the development of MCC. So he would want to put in witness evidence in response to the multitude of different points raised by these witness statements. And amongst other things, I understand that there's a material distinction one could make between the creation of a piece of IP source code and it on the one hand and its implementation on the other, which is a completely different thing. It's one thing to take a product that exists, for example, a product developed by Microsoft, and to then implement it to the specifications of a particular user. That is different from the creation of the software in the first place. And there would need to be evidence on that. The third point is that it's the claimant's position that they seem to take a view that they're the only party who's entitled to revisit the number of witnesses who the court needs to hear from in this way. But the defendants, Your Honour might have seen, have also identified witnesses who will be able to speak to these newly introduced issues.
Sorry, where do you refer to that?
I've referred to those individuals in my skeleton argument, and I believe it was in Mr. Shehata's, I've lost track of numbering, 12th statement. I'll double check that for Your Honour. But as it happens, those are the individuals who were referred to in the second claimant's third witness evidence, which he filed in respect of their amendment application. So he's the one those are the individuals who he says weren't employed by Health Insights Dubai. So as it happens, new factual issues have been put forward again in a reply statement by the claimants, which seem to engage the evidence of those individuals.
So can you just run me through that again? So who are the witnesses that you say you would wish to lead evidence from?
Yes, so it's Mr. Abdulaziz. You saw reference earlier to his salary payments going out of the HSBC account, and Mohammed Saad, who you also saw. Separately, those are individuals who've been identified as being able to provide evidence in respect of the issues in the 4 new witness statements, but also they happen to have been mentioned in the context of new allegations by the second claimant in his third witness statement, which was... All
right, and have you gone about obtaining witness statements from them?
There's a process of identifying them and speaking to them about the issues, but there's no draft witness statement, if I can put it that way. They have been identified, engaged, and spoken to about the issues that they would address in that evidence. But their witness evidence is, of course, one part of it. The other part of it would be obtaining the relevant documentary evidence, which would both support what they say, but also I think there would be questions about the documentary evidence that the defendants don't have access to, which would be engaged in this newly advanced case. So, for example, if what's being said is that Health Insights Egypt is the developer and its staff developed these bits of source code, the party that has access to and control of those documents is Health Insights Egypt and the claimants, because they have control over that entity. It would be, in my submission, rounds of disclosure which would need to deal with that evidence. So if this is now a change in the way that the claimants are advancing their case, which it certainly appears to be, there is a right to seek evidence from the claimants in respect of that case, but also for the first and third defendants to provide evidence in response to the allegations that are now put. But we would invite Your Honour to view these as plainly not insignificant issues. They engage a broad range of evidence. It's a new case that's being advanced that Health Insights Egypt developed this program, and it's really difficult to understand why that allegation is coming in August of this year and hasn't been part of the claimant's case from the outset, particularly since the second claimant says this is all his idea. So that's really the central reason we've made the application to adjourn, and we do so with absolutely no joy. This is not about trying to duck off issues for another day. This is about being afforded a fair opportunity to respond to a case on a critical issue articulated for the first time in a reply witness statement. And as I say, that's not the only part. Your Honour's heard the other applications this morning. But just as a matter of principle, we obviously accept that adjournments are an order of last resort, particularly when they're close to trial. But what we say is, given the nature of what has been introduced and its centrality to the way that the claimants put their entire case on ownership, and therefore the consequences of alienation of its ownership rights in MCC, the only viable option is to adjourn the hearing to allow this evidence to be produced. The evidence that we're not just trying to bump off trial is that we've already suggested that any adjournment should be as short as possible. We put trial dates to the other side for October, for mid-October, to allow enough time for witness evidence and whatever documentary production can be provided to get trial on within as little as a month after. That wasn't accepted by the other side, but it somewhat underscores the point that what we're trying to get at here is having a fair outcome and a fair trial, not having a lengthy delay in trial. And I suppose pursuant to that point as well, what we ask Your Honour to distinguish is between inconvenience on the one hand and injustice on the other, because if what the court is ultimately being asked is whether the balance between the inconvenience that might be caused to the parties versus the injustice, if a fair trial can proceed based on what's happened, it's the latter that should prevail. So I think what my learned friend said in his skeleton is that the most important question for the court is whether the witnesses can be accommodated. Respectfully, that's not the most important question. The most important question is whether it's fair to accommodate them without affording the defendants an opportunity to respond to what they say. And for the reasons I've given, we say it would be manifestly unfair for the claimants to introduce this new case in their reply statements and more points advanced in a reply statement to an application, but without affording the defendants a proper opportunity to respond to that. So that's from a principle perspective, but there's also practical issues as well. So the number of factual issue witnesses is now doubled. The issues before the court have become wider as a consequence of what's been put into play by those witnesses and by the claimant's newly articulated case. And we've had discussions about trial estimates at the PTR, and Your Honour, I think, expressing concerns about council estimates and taking a view that it was verging on ambitious. If that was the case when we were at the PTR, we say that the addition of 4 new witnesses renders the trial window insufficient to get through all of the issues that they deal with and the expanded issues in the case. We don't accept that going part heard is really a workable solution to that, because if there's new evidence in respect of authorship and ownership arising, it's inevitable that there's going to need to be some document production and some witness evidence. And if that is the case, if we go part heard, what you end up with is evidence coming in a piecemeal way, and the need to recall witnesses to deal with issues that haven't been put to them previously. And in any event, it doesn't really speed up the resolution of proceedings. So it's just the worst of all worlds. It interrupts the coherence of the trial with no end result of proceedings being resolved any more efficiently. There are a number of points taken on the incurring of costs. Again, we say that that's a neutral factor. I mean, this application has come about because of actions taken by the claimants, which, if they didn't know was going to cause an issue, they really ought to have known was going to cause an issue. And they can make all the points they want about brief fees being incurred, but that applies to every party in the proceedings. That is prejudice that is suffered by the claimants and the defendants alike. And we say that the evidence that's been introduced clearly needs to be dealt with, and that is one of those rare cases where an adjournment is fully justified because a fair trial could not otherwise proceed. And I don't think I need to labour any more of those points, Ronnie. I think you have my submissions.
All right, thank you. Mr. Montague-Smith.
Thanks, John. I'll be as quick as I can, noting that the time has pressed on.
Well, but I think it's important that we obviously.
Yeah, no. I'm not suggesting it's not. I'm not suggesting it's not. I won't repeat anything that's gone before. Adjournment. I'll deal with the adjournment on the basis of the new witness statements. That's really the central complaint.
Yes.
And one has to divide the submissions into two effectively. The first submission is that those statements raise new issues.
Yeah.
And then the second is that there are more witnesses. And it's just the number of the witnesses there that's the problem. So we accept there are more witnesses, obviously, than there were in the first round. But we certainly do not accept that these raise new issues at all. And I will have to take you through that a little bit, I'm afraid. So just explaining, I mean, what to start with, if I might just remind you of the summary of what the complaint is about, what the content of the complaint is about. And it's in my learned friend skeleton at paragraph 27. So if you have that, sorry, page 27, I apologise, I've written it down wrong. And he sets out a summary of what he says are the objectionable components of the evidence that's been identified. So running through them then, Mr. Al-Shanawi is one of the new witnesses, and I won't read out the whole thing.
Which paragraph?
Paragraph 87.
That's
page 27. Oh, I'm sorry, I'm looking at the skeleton argument, so I wasn't giving you a reference to the bundle.
Okay.
I was giving you a reference to the skeleton argument, but do you have the bundle set? Do you have the skeleton separately? Because that's what I was.
Yes, I do have it. 20, and it's
page 27, paragraph 87. So I was just working from that really to see what are the objectionable components of this evidence that's been produced in the second round. So you've got 4 witnesses that are complained about: Mr. Al-Shanawi, Mr. Al-Shami, Mr. Bashir, Mr. Heggie. And in this, what is complained about is, just picking out the highlights, Mr. Al-Shanawi at 1, the complaint is that he says HI Egypt developed MCC. That's the software, which
I'm sorry, Mr. Montague-Smith. My copy of the claimants. Oh, sorry.
I'm so sorry. I'm working for my learned friends, and it's probably my fault. I meant to say the defendants. If I said the claimants, I apologise.
Claimants.
It's the defendants. Yeah.
Yep. Okay. I'll come to that. Just bear with me a minute.
Of course. Of course. And I think it's in the. Just waiting for the bundle to load.
Right, I've got copies in different places. I'm just trying to find one. I
Yeah,
think
of
I've
course. I'm afraid I'm struggling to find my bundle reference. Ah, yes, it's 1437 at the bundle, if that helps, but you may have marked up a copy already that you were working from. I don't know.
on another one.
Yeah, well, I don't want to give you two sets of markup because I know how complicated that becomes.
Yes, okay.
So this is the thrust of the complaint, and you've heard a little bit about it as well, but you've heard about sort of some of the components of the complaint about the new issue allegation. It said that new issues were also introduced by the claimant's evidence, but the thrust of the complaint is captured, I understand it, by this summary. So you've got Mr. Al-Shanawi suggesting that at Little Roman 1, HI Egypt developed MCC. Then you've got at 2 that Mr. Al-Shanawi was responsible for developing partly or wholly some of the modules for MCC, and over the page, the first defendant requested the source code for the modules from programmers indirectly, and then 4, if more than one programmer was involved in developing a given software program, then there cannot be one author. I'm not sure quite what that means, but so ultimately all of these complaints are about the so-called new case that HI Egypt developed MCC using its developers, including Mr. Al-Shanawi, and the Little Roman numeral 3 about the request for the source code is that Mr. Al-Shanawi produces, amongst other things, WhatsApp transcripts which show Mr. Shehata, the first defendant, asking the developers to provide him with the source code and updates on the progress of the development of various modules of MCC. So the point there really is that ultimately the issue is that whether or not HI Egypt developed MCC, in other words, who developed MCC, and that is a sub-issue which goes into the question of who owned MCC. Was it Mr. Shehata, as he claims, or was it HI Dubai, as we claim? And I'll come on to, well, we don't need to argue the case in front of you today. I just need to show you what was out there, and I'll come on and explain it in due course at a later date, no doubt. So then, as to Mr. Al-Shami, you've again, there's various factual allegations which are picked out, but it is all about that question: who developed MCC, and was Mr. Shehata involved in it? So you've got, the development being carried out by HI Egypt, and various bits and pieces about the personnel, the development personnel being put on courses, and so on and so forth. But those are not issues in the claim. There's no issue in the claim. Did the developers go on a course to learn how to program these things? They're just evidence in support of the position as to who developed this program. And then you've got Mr. Bashir, and again, that is all about the development of MCC. You can look at that yourself, and I'm going to speed through this a little bit. And then you've got complaints about Mr. Hegyi, who is talking again about the development of MCC. He calls it an upgrade from the original M+ material, and then talks about its modules and who developed them, and the first defendant did not develop them. There is a point in there about something called active medical sheets. That is very tangential indeed, because active medical sheets did not make their way into the MCC program. It's historical, but ultimately this is just evidence about who developed MCC. And the role of Mr. Shehata and the role of Health Insights Egypt in the development. And as a result of that, the involvement of these individual witnesses. Now, these are all parts of the debates about who owns the MCC software. And it has always been, and it remains the case, the claimant's case, that the second defendant owns it. And that is, my learned friend took you to it, but just to remind you, that's at page 20 of the bundle in the pleadings, 25 and 26. Now, at that stage, it was not anticipated that there would be a dispute or much dispute about who owned the MCC. Why? Because the whole case is about an agreement under which Mr. Shehata purported to cause Health Insights Dubai to sell the MCC program. Now, there's arguments about that, but our understanding of the position was that he, Mr. Shehata, was trying to sell MCC to his own company using the agreement. That's what the agreement appears to contemplate. And as a result of that, one would anticipate that he would accept that, at least as at the date of that agreement, he would agree that Health Insights Dubai owned the software. And indeed, there are warranties to that effect in that agreement, which were signed off by Mr. Shehata and also by his CIO in Malaysia. But there is no doubt there was the case pleaded there that it's owned. Now I'm told that there's no pleading as to the development of that, but the development is an issue that was raised in the pleadings after the particulars of claim. And my learned friend says, well, it's incumbent on the claimant to plead out its positive case in relation to that early on. But he took you to the rules which apply to defences, 1727, which says you have to admit or deny and set out the basis of any denial. Whereas in relation to replies, the rules are completely different, and they're at 1734 and 1735. And in fact, there's no obligation to file a reply at all. And if you don't file a reply, you're taken to not admit things. And if you don't deal with something in a reply, you're taken to not admit it. Those are the two rules. So actually, there's no positive pleading obligation at all in relation to that. And in the ordinary course, as these things develop, these allegations or this dispute resolved as things do, or emerged as things do, in the evidence that was filed. But it's not true that it's introduced at the second stage at all. So, for example, if one looks at page 681 of the bundle, you have you have the second claimant, the second claimant's first witness statement. This is, and he says, paragraph 31(2). In 2017, MCC was created by Health Insights as a successor product to M+. It was created by a team of programmers employed by Health Insights. Nasser did not develop MCC alone and did not own the rights in MCC. And Mr. Abdulaihid, the first claimant, if you go to page 664, you'll see what he says. Paragraph 14. So this is the first round of evidence. From the point at which Mustafa and I invested in Health Insights, HI Egypt principally acted as the back office, by which I mean it was responsible for developing the technology used by Health Insights business, whereas HI Dubai acted as the front office, being the entity through which sales generally would be made to customers. There are some exceptions to this, and he says Al-Khalij is one of those, and that's one of the areas of dispute, but there we are. But he's clearly saying the development is by Health Insights, and the development function of the group is with HI Egypt. And 15, in around 2017, Health Insights developed a new version of M+ called Medica Cloud Care. So it's a new version. So some of the things you're being told is, well, it's brand new.
Who's he referring to where he says Health Insights?
Well, he's talking about the development. He's talking about Health Insights Egypt, because he's already said in the previous paragraph, he's talking about Health Insights as a group.
Yes.
And then he says, so at the paragraph 14, he's saying the development is with Health Insights Egypt. Now, right. You will recall that at this stage, these companies were under the control of Mr. Shehata. So this is something. These are facts which are being pieced together to an extent from records and subsequent conversations with individuals who are involved in that. But essentially, what our position is, well, however it emerged, what matters really for these purposes is whether the MCC ownership was with the Health Insights group that is owned by the relevant shareholders, or is with Mr. Shehata personally, as he assesses. Now, as between the two Health Insights entities that my clients have an interest in, we would say it's pretty clear that it's Health Insights Dubai who had the ownership for a variety of reasons that we will go into in trial. But as to the development of that, the case is and the evidence is, and this is the first round of evidence, that it was developed by Health Insights Egypt. Now, how does that give rise to rights over the software by Health Insights Dubai? Well, we can explain that in trial, and we'll look into it. And to an extent, that's not a clear. We don't have a clear view of it, but it does look like, for example, if one goes into the accounts, that there are payments due or accounts. Sorry, there are revenues received by Health Insights Egypt in respect of development costs and payments made by HI Dubai in relation to development costs. But we'll get into all of that in the evidence. The question is, was the issue of who developed MCC on the table in the first round of evidence? Is it brand new in the second round of evidence? Answer: clearly, it's out there. And not only was it out there, but the defendants were clearly aware of it. But I'll come back to that. If one goes down to 669. The other point that's made is, well, there's new evidence or new issues about the development of the predecessor software, M+. And so if one goes down to 669, you see at paragraph 35, Mr. Abdulaihid deals there with the development of M+. So his position is that it was created by a company called Solutions Plus, and that and then he says it was subsequently developed by Health Insights Egypt. And so, and my own friend says, oh, well, that's all incoherent. But of course it's not, because you're not dealing with you're not dealing with a video game or something, some small piece of software. You're dealing with an operational software with many, many modules that continue to be developed. And so to ask the question, who owns MCC? Does it make sense for MCC to be created and developed subsequently? Of course it does, because the modules are ongoing in their development. And as I say, Mr. Shehata clearly is aware that that is the case, because he deals with it in his 7th witness statement, which you have a copy of in the bundle, and he responds. So if we go to page 690, paragraph 14, he says he deals with some of the paragraphs that I've just taken you to. At paragraph 14 of his statement, the first claim refers to HI Egypt as a back office responsible for developing technology, and that HI Dubai was the front office through which sales were generated. Well, that is not correct. And then he says, well, the claimants wouldn't know because they weren't involved. And just pausing there, we say that's the real complaint here. That the introduction of the new witnesses cuts across his strategy, which has always been to say, well, you just have to take my word for it, Judge, because no one else was in the room at the time. If one goes forward then to page 691, paragraph 16, you can see him dealing with the allegation that HI Egypt was a software developer. And he says in terms, in relation to the first claimant's assertion that HI Egypt was a software developer, that is also incorrect. Assume the statement's been made retrospectively to justify and so forth. And then he goes on to explain that M+ had already been developed long before. In paragraph 17, he says HI Egypt's function was different, so as in different to being a developer. He says M+ was comprised of several platforms in which various settings could be configured for use. And he goes on to say that essentially HI Egypt's role was simply to configure the software, not to actually develop it. And so my learned friend, you may recall, made submissions to you. He said, well, there's a difference between developing software on the one hand and configuring, say, a Microsoft package for a wide range of users on the other. And that would all have to be explored in new evidence. But that's all being addressed by Mr. Shehata in his evidence. That's his assertion, and we'll deal with it. We'll look at it. What we say is all of this, that this is just configuration, is all given the lie by the documents that are being produced by the witnesses, for example, which show Mr. Shehata saying to those developers, please provide me with an update of where you are on developing modules and all the rest of it. But my own friend asserts without evidence again that that's all taken out of context. So they'll try and explain that away. But these are pretty damning documents, we say. Paragraph 18 then talks about the development of MCC, and it responds to claims about the development of MCC. So at paragraph 15 of his statement, the second claimant gives a very short explanation of how MCC came to be developed. And my own friend says it's a brand new issue as to how it came to be developed, but he's dealing with it. And then he goes on to say he personally developed it, and so on. And then over the page, paragraph 19, he goes on and responds to allegations that MCC was developed by Health Insights. You can see that in the second line. Specifically, the first claimant is wrong when he says that MCC was developed in or around 2017 by Health Insights, and in particular, HI Egypt. Then, if you go down to page 704, we're still in the same witness statement. Page 704, paragraph 46, he responds to evidence on the development of M+. So he's taking each witness in turn, and then he repeats the claim that he developed them personally himself. So again, development of M+ is clearly on the table, and he saw it. And that follows through to paragraph 48, where he makes out what he says is the evidence that supports him on that. And then page 713, further down, paragraph 64, he responds, second half, you'll see, to the second claimant's evidence on the development of MCC. About halfway down, he says the second claimant's wrong to say that MCC was created as a successor product to M+, or that it was created in 2017, and then just poo-poos it because he says, well, the second claimant doesn't know what he's talking about, and he didn't put any of his own time. And then 716, paragraph 71, deals with this Solutions Plus development of M+. So he says it's untrue that Solution Plus started developing M+ in 1995, and so on, and responds to Ms. Hosny's evidence further down that M+ was developed by some Solutions Plus. So my learned friend says, well, it wasn't previously alleged that HI Egypt developed MCC, and we say that's just wrong. And the rest of the points are really about supporting evidence dealing with that. So the pleadings frame the debate, who owns it, and the evidence is directed really at that issue. And inevitably, in the exchange of that evidence, factual issues, smaller factual sub-issues emerge. And so, for example, these documents, which we say show Mr. Shehata asking for modules and code, they're asking for progress of development. Those are not, there's no issue. Those aren't raising new issues as to whether he asked that question or what he was asking. That's evidence which goes to an existing issue. And the same for, this question of whose idea this all was. I mean, there's no issue in this claim. Who thought up the idea of MCC? Well, that's, it might be interesting, and it might even support your conclusions on who owns it one way or another, but it's not the issue. So we simply reject the allegation that this is new. These are new issues, and ultimately the true thrust of the complaint appears to be that there are more witnesses, and that is put on the footing that there's insufficient time in the court timetable to deal with the witnesses. But in reality, we say this is really a tactical complaint because, as I say, his strategy was really just to say, well, you have to take my word for it because I was the one who was involved and the claimants weren't involved. And Ms. Hosny was involved in M+, but not in MCC. So he produced witnesses and documents which we say will demonstrate that he's lying about that. Now he wants to change that approach. We also reject the allegation that it's an ambush, and this has been explained. Ms. Roshan has also explained this in her witness statement, page 1209, and it's paragraph 12.2. And this is late emerging evidence from our perspective as well. And by the time of the PTR, the claimants had not identified the additional witnesses as actual or potential witnesses, she says. And the additional witnesses were identified on the 11th of August, just shortly, very shortly, before the deadline. So it's not tactical, and all of the submissions where we should have raised it at the PTR that fall foul of that, really, because it wasn't known by us at the PTR that there were these other individuals. There's nothing in the order which restricts us to the existing witnesses. There's nothing that says in the order that was made that we can't produce additional witness statements from additional witnesses. You were taken to the commercial court guide, but that doesn't apply. There's no equivalent rule in the DIFC, and there was no equivalent statement in your honours order. So really what we say is that the only question really should be whether or not there is adequate time in the timetable to deal with these additional witnesses, and we say that there is. And the way I'd approach it, I mean, the usual budget, the usual tariff for a witness is the rule of thumb is about half a day for a witness, but in relation to these witnesses, we would point out that some of them are very short indeed. So just to run you through them. Mr. Al-Shanawi's witness statement is at page 1305. It's 4 pages long, but the substance is covered in 2 pages. There's topping and tailing. So it's a 2-page statement, really. Mr. Bashir's statement is at page 1313, and that is 5 pages long, but the substance appears on 3 A4 pages. So far, we're up to 5 pages of actual evidence. And he exhibits, they exhibit a handful of documents each. Mr. Al-Shami's statement appears at 1318, and that is a 5-page document, but again, the substance appears over 4 pages, and he exhibits 2 documents there. And Mr. Heggie has the longest of all, that's at page 1324, but even that is 9 pages long, with the substance of it appearing on 8 A4 pages. He exhibits 4 documents. So in terms of substance, you've got about 15 pages of evidence, as against almost 100 pages of Mr. Shehata's own witness statements. And the length of those statements is plainly indicative of the narrow compass which they deal with. And we say that it should not take 2 full days to deal with those witnesses. It should be that if a focused cross-examination is exercised, then those should eminently be capable of being dealt with in half a day each. Now, in terms of the trial timetable that we have, my own friend suggested that witnesses might need to be recalled, and it's never been our suggestion that there be some sort of break in the evidence. I think what we were saying is that the critical thing to do is to get to the end of the evidence by the end of the trial. And we can do that even on my learner friend's own timetable. So if we go to his, I think hopefully you've still got his skeleton argument somewhere, but his skeleton argument, I think it's 1446 in the bundle, but page 36, if you'll recall, right at the outset of this day, we looked at, he has the defendant's factual witnesses, sorry, I didn't mean to interrupt you, but the defendant's factual witnesses being completed by the end of day 7. And there are 7 days available to us. Now, if it really genuinely took that long, then that would mean, well, we'll have to come back for oral closings, or we could do, and I'd understood that Your Honour had indicated that you might benefit from written closings.
Yeah.
And sometimes the better approach is to have written closings and then come back for short oral closings. Now, that probably one way or another we can accommodate. Unfortunately, what I certainly can't accommodate, and what I suspect will be more difficult for the court to accommodate, is a rapid booking of a 10-day trial and pre-reading that's associated with that. So if we move this trial, I don't know what Your Honour's diary looks like, but so my diary can't accommodate it. And it may be that Your Honour is able to find a day or 2 days. There's much better prospect of doing that in relatively short order than there is of going away and coming back for 10 days. And so Your Honour's problems are no doubt similar to mine. Now, I think, we do say, actually, my other friend's timetable is pretty indulgent, in that he gives himself best part of a week to get through 7 witnesses, which, I don't know, there's some judges of this court who would not be particularly minded to allow for that, but everyone's got their own views on these sorts of things, and I understand that it's better not to go short. But I think with a bit of discipline, we really struggle to use more than 7 days on the evidence, so we say the critical thing is that it shouldn't be allowed to result in an adjournment. There shouldn't be an adjournment. There isn't a need for an adjournment on the timetable. These are not new issues that have been raised. And essentially, one of the things he says is, well, I might want to call more witnesses, but you've got the names of the witnesses, but this argument's internally inconsistent, because the complaint is that we didn't bring this evidence in our first round of evidence, but his response is, well, you can't have reply statements from new witnesses. So at what stage was he going to put forward his new witnesses on his own case? It would have come at the first stage or not at all. But anyway, more to the point, he doesn't actually provide any witness statements. He's clearly capable of doing it, because we've had fairly rapid. We've got a number of witness statements from Mr. Shehata that have come through in the last 24 hours. But we've dealt with some of these issues already, and actually the skeleton only says that he may want to call new witnesses. That's at paragraph 103. So it may be that they decide that they don't want to call more witnesses. And so what we say is that if there were going to be more witnesses, and if that genuinely was permissible, and it was a reason so serious and so important to move the trial, then you would expect at least some sort of summary of what that evidence was going to be, and really you should see a draft, or at least a statement from those witnesses at this stage. So but our primary submission is actually, if he wanted to introduce new witnesses to deal with the development process, he could have and should have done that. That's been on the table for some time. Fundamentally, sorry, I'm getting emails. Thanks. Fundamentally, the consequences of an adjournment. We don't really know how long we're looking at here, but I would suggest it will be substantial, despite the offer of dates in October. I'm not sure everyone else is going to be able to accommodate that. And I suspect if we are to change the counsel team, it's going to be quite difficult for my clients to find counsel who's experienced in the DIFC available for that period. But the consequences will be, firstly, the delay in and of itself. We understand how we've got here, but it is quite a long time since this claim was started. There's inevitably going to be significant wastage of cost. Brief fees are all incurred. There's some wrangling about document hosting fees and all the rest of it, but it's inevitable that very substantial amounts of money will just be wasted. Court time will be wasted. Your Honour's time will be wasted, and we will have to, as I say, change counsel to get this back on in a reasonable time. None of that, we say, is necessary on the material that you have, and so we say this really is a very late application to push things off in circumstances where they've had these statements for weeks now, but took their time in making the application. So for those reasons, we would resist. I think at one stage it was said, well, there's some problem with the admissibility of these statements, but we don't understand that at all. Admissibility is about the legal admissibility of evidence into the record, and these aren't, for example, people purporting to be experts for whom there's no permission or without appropriate qualifications. There's no points of that made. I think the suggestion is that as a matter of case management, you should simply refuse to allow us to adduce these witnesses, but there's no good reason to do so. You'd be excluding relevant evidence, which may assist you in deciding the truth in this matter. And in circumstances where those statements were served pursuant to Your Honour's order and fall within the terms of the order, then we would say it would be an error to exclude them. So we do say you should. We would ask you to refuse adjournment and just get on and let's try this case. My learned friend had some points about directions in relation to Mr. Shehata and whether he could attend remotely. We take pretty much a neutral. I don't think he's developed that, but just to be clear, we take essentially a neutral stance in relation to that. He says he doesn't want to come into the UAE because he risks arrest. Well, that's up to him. You may or may not think that's a good reason to allow someone to give evidence remotely. We don't oppose it in principle. No doubt, though, the court will want to be satisfied that that is permissible from wherever Mr. Shehata intends to give evidence. I think there was an email sent this last night or something. My clients were not copied on it. They were sent to the register by my learned friend's clients, so he should have been copied on it, but it came to us eventually, suggesting that he wants to give evidence from Egypt. I think clearly this court is going to want to be satisfied that that is permissible in Egypt, but subject to that, we don't have any real observations to make on that. What we would say, though, is that it shouldn't affect how the rest of the trial proceeds. And I know that the policy of this court is generally anything over 4 days or 4 days or more should be in person. And we do consider that the whole trial should take place in person, even if it's right that Mr. Shehata will dial in for his bit of the evidence. Thank you.
Well, thank you. So Doherty in reply. You're on mute, Mr. Doherty.
Thank you, Your Honour. The first point is to respond to this suggestion that somehow Mr. Shehata has adopted this strategy to try and prevent the court hearing someone's view other than his own. I really don't see how you could possibly draw that conclusion. Mr. Shehata articulated his case on ownership and development in April 2024. That's before any of the pleadings were drafted. There has obviously been ample opportunity for the claimants at various points to respond to that, not least in their pleadings, and certainly by the time they produced their witness statements. But they have declined to put forward any positive case on these issues. This isn't Mr. Shehata trying to get some advantage. He's been clear in putting out his view consistently throughout these proceedings, but since he made his first statement in proceedings. So nothing prevented the claimants from actually responding to the case prior to when they'd chosen to in August this year. You were taken to the evidence put forward by Mr. Shehata to say, well, look, this isn't a brand new issue at all, which is a mischaracterization of the way that we have advanced this point. We obviously accept that it is an issue how MCC was authored, created, and what the ownership was. It's issue 2. It's been put into issue from the outset, as I say, in April 2024. The problem isn't that it's a brand new issue to the proceedings in general. The issue that arises is that it's a newly put case by the claimants. So Mr. Shehata has set out his positive case about the development and ownership of MCC. And as I say, has been consistent in that. It's the claimants who, when he made those assertions and when he pleaded that case, declined to advance any positive position and simply put him to proof on authorship and issued a bare denial on ownership. So It's an issue in proceedings. Of course it is. That's why we say it's important that the defendant ought to be given the opportunity to respond to the new case that's being put. The prejudice isn't that it is a new issue in proceedings as a whole. The prejudice arises from the fact that Mr. Shehata hasn't been afforded an opportunity to respond to a new case that's positively been put by the claimants in their reply witness statements. It's a completely different point. I think what was said is that some of the evidence that's gone in from the 4 new witnesses is, quote, just evidence as to the pleaded position of who developed this program. So my learned friend, I think, sought to distinguish between the pleading that puts something into issue and the evidence that the court will probe by reference to that issue. But it's not evidence as to a pleaded position of who developed the program, because there is no pleaded case that is advanced or pleaded positive case that is advanced by the claimants that Health Insights Egypt developed MCC. You won't find that in any of the pleadings. So it's not evidence related to a case that has been advanced in pleadings by the claimants. It's a new case that they are putting for the first time in their evidence. It was suggested to you, I think, that at the point in time the particulars of claim was pleaded, it was not known that there was a dispute about who developed MCC. Again, we don't see how that allegation can be made, because the first time that Mr. Shehata said, I owned the rights and I authored MCC, was in the witness evidence filed in response to the Part 8 claim. That was on the 10th of April 2024. And the pleadings are from the 25th of June 2024. So the issue had already arisen by the point in time that the case was pleaded, and it was certainly an issue by the time the reply and defence to counterclaim was pleaded. So the case, if there was one from the claimants to be advanced, should have been advanced at that point. A point was made about Rule 17.27, and it was suggested, I think, that, well, there are no pleading rules like that that apply to a reply. But the document I took you on to wasn't just a reply, it was a reply and defence to counterclaim. So we say that Rule 17.27 does apply. It's a defence to a claim being put forward. If you're going to advance a positive case that goes contrary to a pleaded case on a counterclaim, you've got to state your reasons why. You can't just ignore the point. You were referred in suggesting that the claimants had put all of these points in issue to page, for example, there's a number of pages, but 681. So this is what was set out by the claimants in their first round witness statements to say, well, you know, this was advanced. And we underscore the point, but I think Your Honour picked it up, is there's what one might frame as a degree of strategic ambiguity in what these statements say. What the assertion is that MCC was created by Health Insights. It doesn't say MCC was created by Health Insights Egypt. And it doesn't articulate a route to Health Insights Dubai coming to acquire the intellectual property rights in MCC. The first time you actually get that allegation being introduced is in the reply statements, and that's why they have caused this issue. Two more short points. There was an issue taken about... Sorry, Your Honour, you're on mute.
What do the claimants' reply statements say about ownership? I thought you said that's raised they raised that in the reply statements. I thought
it's ambiguous what they say about ownership, but what they say about authorship is that it was Health Insights Egypt and a team of multiple employees who authored it. So one needs to get from authorship and first ownership to either the rights being owned by Egypt or being owned by someone else.
But what they're doing in their reply statements isn't it to seek to contradict Mr. Shehata's evidence that he developed the software. They're not dealing with the question of ownership.
Well, it's in a sense one and the same thing, because authorship and ownership are interrelated. because authorship can give rise to ownership. So if you're the author of a piece of IP and you become the first owner, if someone else comes to acquire ownership rights in due course, there has to be a reason why. Or, for example, and it varies from jurisdiction to jurisdiction, but if a series
Yes,
of
I
employees.
understand that, Mr. Doherty, but as you say, they're not the same thing. One might give rise to the other, but they're not the same thing. And ownership, and you can come to own software without having developed it, as you say. They're different things.
The position that seems to be now advanced is that the first owner is Health Insights Egypt. So there's a new case that requires explanation as to how Health Insights Egypt ultimately comes to transfer those rights to Health Insights Dubai. It has an impact on ownership, but in any event, the points were not raised in the first round witness statements, despite the fact that these have been an issue since April 2024. So Mr. Shehata has said, I am the author, I own the rights. And given that this is an important issue in proceedings, the places that it ought to be dealt with were in pleadings and in the first round witness statements, not in the reply statements of 4 new witnesses who've never been put before the court. There was a point taken about the length of those statements. You say that it has no bearing in the work that goes into unpicking what are pretty broad-ranging allegations. But that isn't even really the problem that presents itself, because what one is faced with is a series of witnesses who make assertions that 100 developers were involved in this. They haven't provided any evidence of who those developers are. One has a challenge going through bare assertions in a witness statement and unpicking what are pretty wide-ranging allegations made, albeit in short witness statements, but which deal with complex issues that need to be unraveled. So the length of statement doesn't really tell you much about how much effort is going to need to go into dealing with the allegations. So those are the points we make in reply. I'm happy to pick up what our position is on format of trial.
Yes.
Points to consider about whether the trial proceeds or not.
Yes.
And obviously all of this is without prejudice to our position on that. But when it comes to the form of trial, we say that it's obviously not possible for Mr. Shehata to attend. He's the subject of a travel ban. There's an arrest warrant. There's evidence before Your Honour which explains that and explains why he knows that to be the case. If he flies to the UAE, he will be arrested and will be unable to attend trial even if he tries to hop on a plane. Our position is that in the circumstances, primarily, we say the trial should just take place remotely. We say that from the perspective of introducing a level playing field between the parties, because what we have at the moment is 7 witnesses coming to attend for one party, and we will have no witnesses attending in person for another. And this court, of course, is accustomed to receiving evidence by video link and so on. But you will have seen I referred in my skeleton argument to some observations that were made by the English High Court when it comes to what mode of trial there should be. And in a jurisdiction where oral evidence is seen as carrying particular importance, what that decision, it's built up, says, paragraph 14, is that the introduction of any intermediation, even if it's video conferencing, can have the effect of derogating from the gold standard way of delivering evidence, which is giving evidence in person. And we say that the court, in circumstances where you're going to have one witness with that form of intermediation as against 7, all for another party attending in person, that poses an unlevel playing field and a risk of injustice on that basis. So our primary position is that the better way to proceed is for this trial, if it does go ahead, to take place virtually. And the backup position to that, but it is very much the backup position, is that the first defendant, the only real other option is giving evidence remotely with an otherwise in-person trial. The that isn't advanced as the primary position. Reference was made to the communications with the registry. That's simply pursuant to what the provisions in its Part 23 Schedule B say. We are not aware of there being a formal prohibition on individuals located in Egypt from providing evidence to the DIFC port from Egypt. But what Part 23 Schedule B says is if you are proposing to proceed in that way, you should communicate with the registry to make sure that it doesn't engage any difficulties in respect of treaties and so on. So that's what the communication with the registry was to say, well, we've investigated the position. We don't know that it poses any conceptual problems, but the rules have a mechanism for inquiring with the registry in case that they're aware of any. There are, I think, a few additional points to pick up very quickly.
Just before you leave that, if Mr. Shehata is to give evidence remotely, if he's to give that evidence from Egypt, then the court needs to know that it is not contrary to Egyptian law to administer an oath to somebody, oath or otherwise, to somebody in Egypt. And it's customary for parties who are going to give evidence remotely to make inquiry and inform the court whether or not there is any prohibition, any restriction upon the administering of an oath to somebody there.
Yes. I mean, well, the defendant's position is, having looked into the issue, we are not aware of there being a prohibition.
So you have looked into it, have you? I missed that.
Yeah, sorry. So we have tried to see whether there is any formal treaty provisions which preclude evidence being given from Egypt. We are not.
No, it's not a matter of treaties, I would have thought. It might be a matter of domestic Egyptian law, whether it prohibits somebody administering an oath. I mean, most countries don't. Well, countries from which we often take evidence, England, Australia, that don't prohibit it, but I understand some countries do. That's why one makes inquiry about it.
Yes, and that's the nature of the inquiry that's also been made to the court registry. So this Schedule B to Part 23, Paragraph 4, says if there's any doubt about this, so that's the presumption that foreign governments are willing to give their nationals within their jurisdiction to be examined before a court in the DIFC by means of video conference. It says inquiry should be directed to the registry with a view to ensuring that the country from which the evidence is to be given raises no objection to it at a diplomatic level.
Oh, I wasn't aware of that. So you're saying that it's the DIFC registry has the responsibility to find that out. Is that what?
Well, I don't know if I would term it as a responsibility, but there's a provision in a schedule to the rules which say you should make those inquiries with the registry if you're not if you're not sure. So like I say, we're not aware, having looked at it, of any restriction, but steps have been taken to check that with the registry in accordance with the court's rules.
Well, you could make inquiry of lawyers in Egypt, couldn't you?
I would have to take instructions. I don't know.
I don't know. I haven't asked them, but I don't know that the registry, the DIFC registry, I don't know that they will know whether or not there's any prohibition on administering an oath to somebody in Egypt.
No, I don't know. Well, as I understand it, inquiries have been made with Egyptian lawyers within the firm of my instructing solicitors. That's the basis of our understanding. Oh, okay. And to follow through with what the rules say, those inquiries have been made with the registry. In some senses, I would be surprised if the issue hasn't actually come before the court before, because I imagine there may well have been Egyptian nationals who have given evidence before the DIFC court, but I don't know the answer to that for sure. But that's where we are with that issue.
All right.
The final points dealing with that, and of course it's without prejudice to what I've said before, but is to pick up on the there's obviously an array of options for Your Honour based on the applications you've heard this morning. Specifically in relation to the further witness evidence, we do say that if you were to proceed with trial, then in the exercise of your case management powers, given the substantive injustice that arises, you should not permit the new witness statements. And the good reason for excluding that evidence is because it isn't properly reply evidence in the first place, and that the defendant hasn't been given a proper opportunity to respond to a newly articulated case. So the fair way to proceed if trial is going ahead is as originally envisaged, with the witnesses who the parties told the court were coming to give evidence. The further point is, if trial proceeds, it doesn't necessarily follow from that that other applications wane into insignificance. So, for example, when it comes to the disclosure of documents, if what's being contemplated is trial is not going to be done and dusted in the 7 days set aside, and there's going to be a period set aside for producing written closing submissions and possibly reconvening to deal with oral closing submissions, there's no reason the documents couldn't be produced to the court in the intervening period, and the parties can make whatever points they want based on documentary evidence. But it's the central point is that the court's not going to adjourn and then deliver judgment at the end of a trial if it takes place next week. Well, seemingly that's what is being suggested. And if that is the case, then Your Honour can make orders in relation to some of the other relief sought. There is, well, to add on to that, there's a final point, and it was made by my learned friend earlier, but subject to the outcome of the applications, obviously dealing with the witness evidence and preparation for this hearing has disrupted elements of trial preparation. If, when Your Honour makes your decision, if that decision involved maintaining the trial date, it's likely that we're going to write to the registry to seek Your Honour's permission to put back slightly the date for exchange of skeletons, likely to Wednesday from the current scheduled date, to accommodate the time that's effectively hasn't been allocated for in the preparation for trial, dealing with the applications. But I think that might be a point that can be picked up subsequently.
All right. All right, thank you.
I'm just taking instructions on pushing back skeleton arguments to Wednesday. I think that should be acceptable from our perspective and probably makes sense. Just one comment on my learned friend's suggestion that we might be introducing documents after the close of evidence. That we say, I think his suggestion is we might have the evidence at trial and then reconvene later for closings, but in the meantime, in the middle, we might have some documents. I cannot see for the life of me how that could be an appropriate way forward. The whole purpose of the evidence is that you have witnesses who can speak to documents and explain the context. So I would not support that proposition.
All right, thank you. It's now gone 5 o'clock. What I propose to do is that, given the imminence of the trial and the importance of resolving these matters, to tell you this evening my decision on the applications. I won't deliver any reasons for those decisions now. If either party wants reasons for those decisions, I will deliver them at a later time, but I can't promise when that will be. I'm currently overseas, well, that is not in Australia, and once I return, the preparation for the trial, of course, arises. But if either party wants the reasons, I'll give them to you in due course. Excuse me. So, dealing with each of the applications, the claimant's application to amend the particulars of claim, I will allow the defendants should give the disclosure which is sought by the claimant in their scheduled argument within 7 days. If the defendants wish to put on any further evidence in relation to the amendments, they may do so by filing further witness statements within 7 days. As to the joinder application, the joinder application is refused. As to the non-party disclosure application, that application is refused. The application for a declaration that the claimants breached the disclosure reduction order, I decline to make a declaration. The amendments to the defence and counterclaim are allowed to the extent that the claimant does not object to them, but not otherwise. On the postponement of the trial, I refuse the application for a postponement of the trial. The witness statements described by the defendants as I've forgotten the exact nomenclature, the new or further witness statements, those that were delivered on the as part of the reply evidence, they are not excluded from the trial. Whether or not they are admissible for reasons other than case management will, of course, is a matter for trial. If the defendants wish to put on any further evidence in relation to the matters in those witness statements, they may do so within 7 days. In relation to the format of the trial will proceed in person in Dubai. The first defendant may give his evidence remotely from Egypt. To practical matters, the trial timetable sets out first of all provides for opening oral submissions. I want to raise with both counsel whether that is necessary in view of the extended written submissions. Mr. Montague-Smith.
I mean, I'm very much in your hands, Your Honour. So if your inclination is that it's not going to assist, then I'm not going to talk at you, saying things you find unhelpful. I mean, we've canvassed quite a lot of the ground here, and we'll try and be as clear as we can in writing. If you so in your hands,
Mr. Doherty. You're on mute.
Similarly, I mean, ultimately, the aim is to do what will assist Your Honour in resolving the dispute. If that means giving over the time to evidence and dealing with submissions points later, that's obviously a matter for Your Honour.
The way I propose to proceed is this: that I will not take oral opening submissions, except to the extent that if after reading your written opening submissions there is any matter that I want to seek clarification on, then I will do that at the outset. But otherwise there will be no oral opening submissions. The second matter on the timetable refers to claimants' factual witnesses and defendants' factual witnesses. I request that you put in the names of the witnesses. The reason that I ask for that is so that I can see whether you're on track or not. When we've simply got blocks of claimants, factual witnesses, it is very difficult for me to know whether we're on track, and whether it's necessary for me to impose restrictions on the amount of time that is being taken, so that please put a provisional allocation in the timetable in relation to each witness. And if when we get to a witness, the time has been expired, we'll then consider whether you should be able to extend that time or not. Much will have to do with the overall timetable.
Your Honour, sorry to interrupt. May I ask
Yeah.
a question in relation to that, which is, thank you. Just because there's obviously competing timetables for the total amount of time that should be taken.
Well,
and
I'll
you've given us an
go
extra half a day. Yeah.
Yes, I'm going to go a little bit further and say that my preference, well, no, it's either necessary or extremely highly desirable that all of the evidence be completed within the 7 days. It is not necessary that the closing submissions take place within those 7 days. Indeed, my preference is to complete the evidence and then adjourn to take written closing submissions and then short oral submissions which can be given by video at a later time. Now, I ask that you provide those timetables before we begin. If, for example, which I think is highly unlikely, your timetables provide that all the evidence is to be completed within 5 days, then I might review that position. But my starting position is that the 7 days should be given for the taking of evidence, that we would then adjourn for written closing submissions and short oral submissions remotely. The next point is skeletons. Yes, so the time for the delivery of skeletons is extended to next Wednesday. One further practical point I want to raise with you is whether there are key documents which you consider would be helpful for me, and if so, if you could provide hard copy of those documents, preferably in a spiral bound A5 version of them. So I'll leave that, if perhaps if you could confer and see if that's, yes, Mr. Doherty.
Is your intention to have that ahead of trial, or is that something that you'll use during the trial? Do you want it in the courtroom, I suppose,
Yes.
in terms of timing?
Both. You needn't deliver them to me before, but I would like them in the trial, and then I'll take them away with me. Now, as to these I've indicated my decision on each of these matters. Mr. Montague Smith, can I ask you to ask your instructors, please, to draw up a minute setting out those decisions. As I expect to be back in Australia, I think on Monday, and I would like to formally issue those directions as soon as possible. But I think hopefully, having given you my decision on each point, you're able to get on with preparation.
Thank you very much. Just two further issues from me, if I may, just to consider. Thank you for your directions in relation to the skeleton. There are also similar directions in relation to chronology and dramatis personae. Would you like those in advance, or are you happy for those to come at the same time as the skeletons?
Same time.
Thank you. And then the other issue is costs, which I don't intend to burden you with at this stage, but if I can ask you to just reserve the costs of today, and then It may be at the end of the trial, it won't matter. But we may have a fight about it eventually.
That's an attractive proposition. Costs are reserved. Anything else? No?
Not from me. Thank you.
All right.
No.
Well, I both apologise to and thank the court staff for staying on after your short lunch hour, and thank counsel for your assistance. And that concludes today's hearing. Thank you.
Thank you also for us. Thanks.